What's that like?
So it looks like our committee meeting has just gone live and started up. Welcome everyone to the meeting of the Joint Standing Committee on the Judiciary. Today we're going to, in the morning, have a number of public hearings on bills. And then in the afternoon, we're going to do a number of work sessions. And we'll start our day with committee introductions and then move into our public hearings. As a reminder to members of the public, as well as to the committee, the public hearing portion of today's meeting is focused on hearing from the bill sponsors and members of the public. And we'll be directing questions to members of the public, but reserving our discussion of these bills for when they're scheduled for a work session. And members of the public who are here to testify on bills, you'll be in what we call the attendee part of the meeting. And when it is your turn or just about your turn to provide your testimony, you'll be moved over onto what we call the panel and be able to activate your audio and video, and we'll be able to see and hear you and vice versa. So just be patient. You'll be called, you'll be asked to raise your electronic hand at the appropriate time. And so with that, we'll begin with committee introductions. And I am just going to go across my screen as I see folks. Representative Poirier, we'll start with you.
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Mohegan and part of Madison.
Thank you, Representative Moriarty.
Morning all, it's good to be back in the top of the first inning. I'm Steve Moriarty, representing Cumberland and part of Gray.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the Passamaquoddy Tribal Representative. Please excuse I'm coming to you from my cell phone as I'm having my vehicle serviced, and I've been here since 7 a.m. thinking that I could get back home before 9. So I will be off camera, but I'll be listening in. Thank you.
Thank you and good luck. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I'm proud to represent Senate District 18, which is northern Oxford County and 2 communities in Androscoggin.
Representative Thorne.
Good morning. My name is Jim Thorne. I represent District 103, which is Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I proudly represent Biddeford's House District 12.
Representative Reckitt.
Yes, good morning. My name is Lois Reckitt, and I represent the ocean end of South Portland.
Representative Babbage.
Thank you very much, Madam Chair. Good morning, everyone. My name is Christopher Babbage. I represent House District 8, which is part of the 12,000 people who live within the 35 square miles of the town of Kennebunk.
Thank you. And Representative Evangelos.
Good morning, Senator. Jeffrey Evangelos, House District 91. I reside in Friendship.
My co-chair, Representative Harnett.
Thank you very much, Madam Chair. My name is Tom Harnett. I represent House District 83, which is the city of Gardner where I reside, and the town of Farmingdale. And I welcome all to the Judiciary Committee today.
And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, which is my hometown, and a little bit of Scarborough. And I think we've managed to have everybody introduce themselves. So we're going to start with our first bill hearing today, and that is LD number 795. And we actually have a request from the bill sponsor to vote ought not to pass on the bill. And I'm just checking to make sure that the bill sponsor is not here with us today. And I don't see him in the attendee space. And so with that, do we have a Senator Keim?
Thank you, Madam Chair. Yes, I would make a motion that we suspend the rules and go into a work session on LD 795
Thank
and
you.
vote ought not to pass.
Thank you. Is there a second?
Second,
Seconded by Representative Moriarty. And so let's do the motion to suspend the rules and go into work session by a show of electronic hands. Our committee clerk is raising a concern, and I also would like to introduce our committee clerk and our analyst, which I apologize for not doing. Our committee clerk is Susan Panett, and our analyst is Peggy Reinsch, and they have joined us this morning. And go ahead, Ms. Panett.
Madam Chair, I just wanted to bring to your attention, there is a person that signed up to speak on this bill, and he is in the attendee space.
Oh, thank you. Who is that?
Mr. Sherry, I believe his name is.
Okay, thank you very much. And Mr. Sherry, I see that you have your hand raised, but we are going to go into a work session on this bill at the request of the bill sponsor. And you can follow up with me later if you have questions about the process. Okay, so now all those who are in favor of suspending the rules and going into work session, raise your electronic hands. And it looks like that is nearly unanimous. And Representative Newell, we don't see your electronic hand. You probably can't raise it on your cell phone and where you are, but if you can, yes, raise your real hand. Thank you. Are you all set with the count, Soupy? Great, thank you. And now before the committee is the pending ought not to pass motion. And this one we're going to do by a voice vote because that's what we're required to do under the rules. If folks can just unmute so that we can just quickly go through the vote, that would be fabulous. And we're ready whenever you are, Ms. Bennett.
Thank you, Senator Carney. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yeah, yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Libby. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees, excuse me. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 11 members voting in the affirmative, 0 in the negative, and 3 are absent.
Thank you very much. And with that, the vote ought not to pass on LD 795 passes. And we will close the work session on 795 and move on to open up the public hearing on our next bill, which is LD number 1143, an act to protect tenants from unnecessary evictions. This is being presented by Representative Harnett. Representative Babbage, your hand is up. Did you have a question? Residual. All righty, thank you. And so we'll open the work session on 1143, and you can proceed whenever you're ready, Representative Harnett.
Thank you, Madam Chair. Good morning, Senator Carney and fellow members of the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which is the town of Farmingdale and the city of Gardner. I'm here today to introduce LD 1143, an act to protect tenants from unnecessary evictions. This bill amends existing landlord-tenant law so that a landlord may not terminate a tenancy at will, that is, a tenancy that is not subject to a written lease, without cause. This bill is important, and even more so as Maine finds itself in a housing crisis in which prospective renters, particularly those of modest economic means, are struggling to find affordable housing and to retain that housing once it has been found. Finding affordable housing in Maine has become so difficult that many Mainers become homeless simply because they cannot find an apartment that meets their budget. When a tenant gets a 30-day no-cause eviction notice, they are put in the precarious position of finding a new apartment and moving within 90 days of receiving that notice, or risk going to eviction court and being forcibly removed from their home. Homelessness always harms a family's health. But during the current pandemic, public health experts have likened avoiding homelessness to avoiding toxic exposure. When a tenant is forced out of their home with nowhere to go, moving in with a family or friends or in a congregate setting like an emergency shelter vastly increases the risk of COVID transmission. Even before the pandemic, Maine faced a housing crisis due to rising rents and stagnant wages. During the pandemic, property values have soared in every county across the state, making Maine's rental market more expensive and more competitive than ever. Since the onset of COVID-19, approximately 20,000 renter households have fallen behind on rent. The pandemic has highlighted the existing wealth and power disparities between landlords and low-income tenants. Tenants need housing stability. LD 1143 would at a minimum ensure that tenants do not receive a 30-day no-cause notice out of the blue. Maine's increasing property values are often linked to gentrification. Gentrification displaces low-income community members, usually tenants, when more affluent people move in. Under current law, landlords seeking to profit from speculation in the real estate market can easily evict tenants with a 30-day no-cause notice to sell their buildings or pursue higher-end development. This process is displacing tenants not only in Maine cities, but also in rural parts of the state. No-cause notices are very difficult for tenants to defend in eviction court. By its very nature, a landlord need not establish any cause or reason for the eviction. While Maine law prohibits landlords from evicting tenants in retaliation for complaining about health and safety problems with their rental unit, the no-cause eviction provision allows landlords to circumvent this law. Essentially, it allows landlords to forcibly remove tenants from their home without justification. This has never been more problematic than during the current pandemic, as landlords in Maine have easily evaded the CDC eviction moratorium by giving tenants 30-day no-cause eviction notices. Eliminating Maine's 30-day no-cause eviction provision is a low-cost, effective policy solution to alleviate Maine's current eviction crisis. A recent study by the Eviction Lab demonstrated that policies eliminating no-cause evictions reduced eviction and eviction filing rates. Waiting lists for rental assistance and subsidized housing throughout Maine have thousands of people on them who may wait years for needed assistance. Given our budget limitations to fund these programs and other long-term solutions to the eviction crisis, eliminating the no-cause eviction is an effective policy solution we can enact now. It is important to remember that eliminating no-cause eviction
I think Representative Harnet's internet connection has malfunctioned. Let's give him a moment to reconnect and complete his testimony. Representative Harnet, are you able to hear us? I'll reach out to him via text message and see if we can get him to reconnect everyone. Okay, it looks like he's doing that. And while we're waiting for Representative Harnett to return, if for those who are in the attendee space who wish to testify in support of LD 1143, please raise your electronic hands and keep them raised until after Representative Harnett completes his introduction of the bill and we have any questions, and then we'll turn to those attendees who wish to testify first in support of, and then in opposition to, and then neither for nor against 1143. Okay, and I see that Representative Harnett has not returned yet. Let me check in with him. This is an unusual situation, but I think that what we will do, since the bill sponsor, I'm sure will be back in touch with us very soon, we are going to take some of the folks who are here to testify in support of the bill. And then as soon as the bill sponsor rejoins us, we'll pivot and let him, I think he was a sentence or two away from completing his testimony. So when he returns, we'll let him finish his testimony and answer any questions that we have. But in the meantime, in order to efficiently use our committee time, I'm going to call on, let's see, hang on a second. Okay, yes. Yes, the bill sponsor wishes us to go forward with members of the public. And so Kaylee Bronte, I'm going to move you over onto the panel. And when you arrive, just activate your video and your audio and begin speaking. You'll have 3 minutes and I will run a clock. Thanks. Welcome, Ms. Bonte, to the Judiciary Committee, and you can proceed when you're ready.
Good morning, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. My name is Kaylee Bonte, and I am a staff attorney at Pine Tree Legal Assistance, Inc.'s Lewiston office, where I represent low-income Mainers facing eviction. I'm grateful for the opportunity to share with you my comments in support of LD 1143. I am here today on behalf of Pine Tree Legal Assistance and speaking on behalf of Pine Tree. There is and has been an ongoing affordable housing crisis in this state. The past year has only highlighted the disparities that exist when it comes to tenants and their landlords, particularly low-income tenants. Now more than ever, it is extremely difficult for low-income Mainers to find any housing, let alone safe and affordable housing. Many tenants forced to look for new housing not only face a slim chance of locating an available unit, they must then face the reality of having to pay applications fees, first month's rent, a security deposit, last month's rent, which often totals thousands of dollars that these tenants simply don't have. And very few families are fortunate enough to find safe and affordable housing under these circumstances. No family should have to face homelessness when they have otherwise followed the terms of their tenancy. The rate of homelessness in Maine is on the rise and projected to continue this trajectory due to the pandemic. WGME reported recently that Maine has the 13th highest rate of homelessness in the country. Allowing landlords to evict tenants without cause perpetuates a cycle of homelessness, and eliminating a landlord's ability to evict tenants who have done nothing wrong will be a step towards stable and long-term housing in this state. Landlords regularly abuse no-cause evictions to avoid existing tenant protections. Very few protections for tenants do exist under landlord-tenant law when it comes to tenancy at wills. And although these tenants may have some defenses, they're very difficult to overcome at hearing. Currently, one protection could be the CDC moratorium, but unfortunately courts have decided that those protections do not apply to no-cause evictions. So even if a tenant has fallen behind on rent, their landlord can circumvent the moratorium by serving them with a no-cause eviction. In his book, Evicted, Poverty and Profit in the American City, Matthew Desmond wrote, "It is hard to argue that housing is not a fundamental human need. Decent, affordable housing should be a basic right for everybody in this country. The reason is simple. Without stable shelter, everything else falls apart. At Pine Tree, we regularly see the impact that homelessness and unsafe housing have on our community. Thank you for the opportunity to share this testimony."
Thank you very much, Ms. Bonte. Committee members, are there any questions for Ms. Bonte? Representative Moriarty?
Thank you, Madam Chair. Ms. Bonte, the bill reads right from the beginning, tenancies at will must be terminated by either party as set forth in subsections 1 and 2. I haven't had a chance to check back elsewhere to find out what sections 1 and 2 mean. So can you elaborate on that for us?
I apologize, Senator Representative Moriarty. I don't have the text of the bill in front of me at this time, but I'm hopeful that other people speaking in favor may be able to directly address your question.
All right, I'll just quickly follow up. Does this bill create a de facto lease between the parties?
No, I don't believe it does create a de facto lease. There are some exceptions that, and maybe this is what your first question is getting to. I believe there would be some language in there that would give landlords under circumstances the ability to still serve a no-cause eviction. But what this does is give tenants more protection, and specifically the protection of being put out, in 30 days notice for no reason at all.
Thank you.
Senator Keim, you were next.
Thank you. Ms. Bonte, when a tenant moves into a location, are they aware before they move in that it's an at-will tenancy? Is that an agreement ahead of time?
I think it depends on the specific circumstances. And often I believe that tenants do not have enough experience or knowledge around landlord-tenant law to understand exactly what it means when they do not have a lease, or if they are tenants at will, and the lack of protection that tenants at will have under Maine's landlord-tenant law.
But when they move in, they're aware there isn't a lease. Like otherwise, there would be some other fallback provisions. Is that right, or no?
In some circumstances, there may be other fallback provisions, but yes, I would assume that tenants would understand that there is not a lease, and thus there's no controlling language around that relationship.
Thank you.
Representative Thorne?
Thank you, Madam Chair. Ms. Bonte, the basic assumption of the bill is that a landlord may not terminate a tenancy at will without cause. To the best of your knowledge, is there anything that protects the landlord from a tenant leaving without cause?
I don't think this bill
Just that
would.
the tenant wants to leave. Can the tenant leave, or is the owner of the property protected from a tenant that just wants to leave to go somewhere else?
I think explicitly protected, no, but I think informally, even if a tenant were to give a 30-day notice that they were leaving, without cause. It's simply not a reality for tenants right now in the state because there's nowhere for them to go. But there is no explicit, language that would prevent a tenant from deciding to move on.
Okay, thank you. Thank you, Madam Chair.
And our bill sponsor, I think, has returned and I can see by his smile that he is unfrozen. So Representative, let's see. Well, first of all, it doesn't seem like there are additional questions for Ms. Bonte. So Ms. Bonte, I'll move you back to the attendee portion of the meeting. And Representative Harnett, would you like to conclude your testimony and then be available for questions? We're not able to hear you.
This is not my day. The problem is I have no idea when I was cut off in my testimony.
It seems like you were right at the end.
I was right at the end? Then let me pick up where I'm trying to figure out. I'll go with my concluding paragraphs and hopefully that will make sense. It is important to remember that eliminating no-cause evictions does not prevent a landlord from removing a tenant for cause and for all of the reasons set out in 14 MRSA Section 6002, subsection 1, including tenants who are damaging property, causing a nuisance, threatening violence, engaging in domestic violence or other illegal conduct, or allowing unauthorized persons to occupy the premises. Landlords would also be allowed to evict a tenant at the end of the term of a written lease agreement if the landlord does not want to renew the lease for whatever reason. The proposed change to Section 6002 protects tenants while allowing landlords to protect interests in their property. I thank you for your attention and maybe for listening to part of this twice. I'd be happy to answer questions, but I do think you would be better served by getting information from the people who deal with these legal matters on a daily basis. But thank you for your time, and I have no idea what happened.
Thanks for coming back to us. And it looks like Senator Keim has a question for you. Go ahead, Senator Keim.
Thank you, Madam Chair. And I have just a few questions, if I could. So you mentioned in your testimony that this is a low cost and effective policy solution. I'm wondering, I understand from the state's point of view that it's low cost, but aren't we shifting the cost actually onto property owners who may want to be advantaging themselves of some other opportunity?
Thank you for the question, Senator Keim. And I think you're right. I mean, I have to be upfront. This does shift some responsibility to landlords, property owners, and may lessen their ability to take advantage of the current real estate market. And I'm not asking for them not to be able to do that. What I am asking for in this bill is to at least provide tenants with the protection that they will not be evicted and left homeless when they have done nothing in terms of violating the rules of the tenancy or have done anything to the apartment that they're renting. Mm-hmm. But there is an impact. I mean, there is an impact on property owners. Yes, Senator. Mm-hmm.
So, and just to clarify, if there is a lease, I sort of asked this, but I don't think I quite understood the answer. If there is a lease, can they also have no cause eviction?
My understanding is they cannot have a no cause eviction if there is a lease in place.
Okay. And then my last question, yeah.
But if there are violations of the lease term, including some of the activities I mentioned, violence in the apartment, illegal activities, there are.
Right, those are cause. Yeah, understood. Right. So then my last question is, how do you see this bill being in conflict with personal property rights?
It's a good question. I think it tries to strike a balance between the right of the property owner and the tenant. It's probably in the eyes of the beholder whether or not this strikes the balance that you would deem appropriate. I know the bill sponsor, as the bill sponsor, I deemed it as an appropriate balance, particularly given the current situation that we are in.
Thank you.
Thank you, Senator.
Other questions for the bill sponsor? I am not seeing any. Thank you so much, Representative Barnett.
Thank
And
you.
I'm going to return to the attendees, and Riley McNeil, you will be moved over to the panel. And while that's happening, Representative Libby, it appears that you've joined the meeting. Would you like to introduce yourself?
Can you all hear me?
Yes, we can.
Wonderful. Good morning, Senator Carney, Representative Harnett, and esteemed members of the Committee on Judiciary. My name is Riley McNeil, and I am an intern with Homeless Voices for Justice. Homeless Voices for Justice is a grassroots organization that works for social change with and on behalf of those who struggle with homelessness and poverty. I am here today to testify on behalf of Homeless Voices for Justice in support of LD 1143, an act to protect tenants from unnecessary evictions. Within my work with Homeless Voices for Justice, I see the catastrophic effect of no-cause evictions every day. Many of the people we work with who are experiencing homelessness are homeless due to the result of a no-cause eviction. Finding affordable housing in Maine, especially in Southern Maine, has become so difficult that many Mainers become homeless simply because they cannot find an apartment that meets their budget. We see this time and time again as folks we talk to while we're doing outreach tell us stories of how they're looking for an apartment, but there is nothing available within their budget, even if they have a voucher. When a tenant gets a 30-day no-cause eviction notice, they are put in the impossible position of finding a new apartment that they can afford and moving with 30 days notice, or risk going to eviction court and being forcibly removed from their home. This is a stressful experience which only exacerbates the vulnerability of their situation and only creates more trauma for our most vulnerable neighbors. Homeless Voices for Justice is based in Portland, and we have seen the gentrification of our city cause homelessness and the housing insecurity among our neighbors in our community. What we have been particularly concerned about is how no-cause evictions allow landlords to clear out tenants as neighborhoods gentrify. In turn, low-income residents suffer as landlords reap the financial rewards of higher rent. In Homeless Voices for Justice, we believe that our communities are for everyone, not just the people who can afford to live there. If housing is a human right, then people should not be able to be evicted without cause to make room for folks who can afford to pay more. And lastly, and importantly, no one should ever lose their home and risk becoming homelessness if they haven't done anything wrong. No-cause evictions only serve to further marginalize at-risk tenants while privileging the property owner. Between the lack of affordable housing, years-long waiting lists for subsidized housing, and vouchers that expire if they are not being used, we cannot let our neighbors lose their housing when they have done nothing wrong. Given our state's budget limitations to fund these programs and other long-term solutions due to the eviction crisis, eliminating no-cause evictions is a low-cost, effective policy solution we can enact now. We must protect our most vulnerable neighbors. So ought to pass on LD 1143. Thank you for your time.
Thank you very much, Ms. McNeil. Committee members, are there any questions for Ms. McNeil? Go ahead, Representative Moriarty.
Thank you, Madam Chair. Ms. McNeil, I want you just to sort of visualize the perfect tenant who is causing no problems whatsoever, is always promptly paying rent and all that sort of thing. But for whatever reason, at the outset of the tenancy, there was no lease between the tenant and the landlord. Can that tenant ever be evicted by the landlord?
Are you talking about in a regular lease or the no tenancy
No,
lease?
no, a tenancy at will, where the tenant is perfect in every respect. But for whatever reason, the landlord wants to move on, maybe wants to condominiumize the structure or something like that, and would like to evict the perfect tenant. My question is, can that be done under this bill?
I am not positive on that, but one moment. I think given our homelessness crisis and the lack of protections for tenants, I think this bill is essential. And yes is the answer.
So, okay.
I guess I'm not understanding your question. Could you repeat it one more time for me?
All right, let's try again. Again, you've got a tenant
That
without
may
a lease. Oh,
that may be a question suitable perhaps for Attorney D'Alessandro, who's coming up next.
okay, I didn't
Might
know
have
who was in
more
line.
experience. Yeah, it's in that area.
Okay, I'll wait. Thank you.
Thank you.
Committee members, additional questions for Ms. McNeil? Not seeing any. Thank you very much for testifying before the committee today.
Thank you for your time.
You're welcome. Representative Libby, do you want to introduce yourself?
Certainly, thank you. I'm Laurel Libby. I represent District 64, which is part of Auburn and all of Minot. And good morning.
Good morning. And now we'll be joined by Frank D'Alessandro, who is the final proponent. And while he's joining us, those who are part of the attendee list who wish to speak in opposition to 1143, please raise your hands and just leave them raised.
Okay.
Like able to call you. Okay, welcome, Mr. D'Alessandro, and you can begin whenever you're ready.
Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Frank D'Alessandro. I'm the Director of Litigation and Policy at Maine Equal Justice. Maine Equal Justice supports LD 1143. Eviction is not just a condition of poverty, but a cause of it, as it forces families out of their communities, away from support systems, makes children change schools, negatively affects mental health, and causes job loss. No one should lose their home and risk becoming homeless if they've not done anything wrong. This bill only eliminates a landlord's ability to terminate a tenancy at will without cause. A study of Maine's evictions records from January 1st to June 30th, 2020 estimates that no-cause evictions account for an average of approximately 8% of eviction filings in Maine. That's approximately 450 cases at the pre-pandemic eviction rate. This bill, importantly, does not eliminate any of the landlord's grounds to evict a tenant at will for cause. Finally, this bill does not prevent the landlord from terminating a tenancy at the end of a lease term without cause if the landlord does not want to renew the lease. Eviction creates disastrous consequences for families. No one should lose their home and risk becoming homeless if they haven't done anything wrong. When a tenant gets a 30-day no-cause eviction notice, they are put in the impossible position of finding a new apartment and moving, which is extremely difficult in this current climate. Also, every time someone moves, especially low-income families, they lose a lot of their possessions and they're forced to start over again. Maine's housing crisis and 30-day notices to quit also highlight the racial inequality in our housing system. 26% of Maine's homeless population on any given night is Black or African American, although only a little over 1% of Maine's population is Black or African American. Pine Tree Legal Assistance has provided statistics that 12% of households they represented in eviction court were non-white, though only 5% of Maine population. No-cause eviction notices allow landlords to clear out tenants as neighborhoods gentrify. Many parts of Maine have been gentrifying for decades, but the pandemic has put unprecedented pressure on Maine's housing market. While so many people are buying and renting new Maine homes, many Mainers are struggling to stay in theirs. Under current law, landlords seeking windfall profits from speculation in Maine's booming real estate market can easily evict tenants with 30-day no-cause eviction notices to sell their buildings or pursue higher-end development or short-term rentals. The pandemic has only highlighted and widened the power gap between tenants and landlords. Also, the cost of not only the cost of families of displacement, there's a cost to society. Research showed eviction increases emergency shelter costs, hospital costs, mental health costs, administrative burdens for court, and the deterioration of communities when people move away from their support system. These costs are even greater during housing shortages such that we're facing now when low-income tenants feel like they can't find replacement housing.
I'm sorry, the 3 minutes were up and I lost track. I didn't give you a warning. Can you please wrap up your testimony?
Well, all I can say is LD 1143 can immediately reduce eviction costs without any cost to the state. And we strongly support this bill.
Thank you very much. Committee members, are there questions for Mr. D'Alessandro? And Representative Moriarty, you can go first. We're not able to hear you.
I'd been muted. Thank you, Madam Chair. Mr. D'Alessandro, I'm going to pose to you the same question I tried a moment ago. And that is to visualize the situation in which you have a tenancy at will, and the tenant has been perfectly compliant with all obligations, including payment of rent and not causing damage and so forth, and has done nothing wrong. Under the bill, can that tenant ever be evicted against his or her will?
Well, under the bill as currently written, a tenant at will can't be. The tenancy at will cannot be terminated except for cause. However, there's nothing that would prevent the landlord from requiring the tenant to enter into a lease agreement of a specific duration. And there's nothing in this bill that would prevent a landlord from terminating that lease agreement at the end of the lease term without cause. Also, I think that the bill could be easily modified to include a measure that said at the anniversary date of the creation of the tenancy, either party could terminate the tenancy upon 30-day notice without having to show cause.
I don't understand the comment about a landlord could, during the tenancy, require a lease.
Well, the tenancy, okay, so a tenancy at will is lasts 30 days if it's not terminated. So at the end of the 30-day period, a landlord could, as a condition of renewing the tenancy, require the tenant to enter into a lease agreement.
And that would not be considered to be an eviction?
Not if no, an eviction only occurs if there's a court order ordering the tenant to move.
Okay, thank you.
Also, the section, to answer a prior question, Representative Moriarty, that you had asked concerning Section 1 and Section 2, the reference to Section 1 and Section 2. So in 14 MR 6002, which is the statute that this bill seeks to amend, Section 1 and Section 2 sets forth the grounds for which a for-cause eviction could be brought, and also the notice requirements for those notices.
Okay, that's good to know. Thank you.
Representative Thorne, you can go ahead with your question.
Thank you, Madam Chair. Mr. D'Alessandro, I'm curious, how clear and defined are the causes for a tenant to evict? The list of causes. Is
So
that explicit somewhere, or?
Yes, they're set forth in 14, in this statute, 14 MRS 6002, Section 1. So the statute has been on the books for quite a while. The first part of the statute is actually unnumbered, but then it goes to Section 1, and that sets forth the reasons for which an eviction for cause notice can be brought against a tenant at will.
Thank you. Thank you, Madam Chair.
Committee members or the Representative Libby, you have a question? Go ahead.
I do, thank you. And again, today I seem to be absent in electronic hand. Thank you, Madam Chair, and thank you for being here today, Mr. Alessandro. I am just wondering, in this and other bills similar, obviously we're hearing a whole slew of them today. I hear testimony that this will decrease eviction costs for the state, that this is necessary because we're lacking resources for Section 8 and other low-cost housing. So I just wonder if you could please explain to me how this and other bills do not infringe on our constitutional rights to property, to due process for landlords, and that private property not be taken for public use, because it seems to me that we're merging onto that, taking it for public use. If the need is because we need to save eviction costs for the state, and the need is that there's not enough state-funded housing, then how does this not infringe upon the Fifth Amendment? Thank you.
Thank you for the question. I just want to apologize first for any background noise. I'm also watching my grandson today. So to answer your question, there are prohibitions on no-cause terminations of tenancies in other states and other municipalities. And those have survived constitutional challenge. Where I grew up in New Jersey, actually my father was a landlord, and I worked quite a bit in those buildings. And in New Jersey, in fact, you can never terminate a tenancy at will or a lease except for cause. And even if the lease expires, the tenant still needs to have done something wrong before the tenancy can be terminated. This bill does not go that far, but this bill, I think, provides common sense protections for tenants while not depriving landlords of their ability to earn a return on their investment in their property. And it also, there's nothing that prevents a landlord from requiring a lease and then refusing to renew the lease. And there's nothing in this bill that requires the landlord to show cause for refusing to renew the lease agreement. And all this bill does is tries to strike a balance between the rights of tenants and landlords and the rights of tenants to remain housed and not face homelessness because in the instance when they haven't done anything wrong. And the other thing to follow, there's a real lack of bargaining power between tenants and landlords right now. Basically, most low-income tenants that we represent are lucky to find a place. And they're willing to enter into almost any agreement in order to secure housing, even if it's unstable.
Thank you.
Senator Kime?
Thank you. Just to clarify, Mr. D'Alessandro, I think you said the bill as currently written would mean that if there was an at-will tenant, that they could never be evicted, as long as there was no cause.
As currently written, that's correct. But as I also said, there would be nothing that would prevent the landlord from requiring a lease agreement at the end of like a 30-day period, which would set forth the terms of the agreement and also set an end date.
Thank you.
Any other questions, Representative Libby?
Thank you. I am just curious, thinking of real world examples of how this would play out. I have a fellow legislator that is a property owner, and in a case that she faced, there was a smoker who smoked only inside the apartment, and so not seeing it visually, was unable to evict. It was a no cause eviction, but it actually did harm to another tenant, an asthmatic. So I'm just wondering, would this bill protect, is there any protection for the asthmatic suffering with someone who is actually harming their health in another apartment in that building, or are there no protections for these other tenants unless the landlord actually sees someone doing the behavior that's not allowed?
Well, there's nothing in this bill that would prevent the landlord from having a no smoking building. Also, it would not be necessary if another tenant observed the behavior. The other tenant would be able to act as a witness in court in an eviction case brought against the tenant who was violating the terms of the tenancy. And so it would not be necessary for the landlord themselves to actually observe the behavior if there was another witness who observed the behavior or smelled, in this instance, smoke coming out of the unit, or observed the other tenant. I mean, fundamental. Go ahead, I'm sorry. I didn't mean to cut you off.
Sorry, follow up, Madam Chair.
Oh, yeah, one follow up, and then we'll need to move on to Representative Thorne.
Thank you. So then, to be clear, all this person would have needed to do was simply put up a no smoking sign, and then having the smell of smoke in the apartment would be enough to say that there is cause, and then that person could be evicted. Is that what you're telling me?
Well, this certainly could make the building a no smoking building. Whether or not, I mean, the evidence that would be needed is up to the judge to decide. But certainly if someone, I mean, we've done no smoking, I've done many no smoking cases. I mean, if a landlord or a tenant observes another tenant smoking in violation of the building, that's grounds for termination.
Thank you.
Representative Thorne?
Thank you, Madam Chair. Mr. D'Alessandro, it's not my intention to go back over every possible loophole, but you did mention something that I think is very important, and that is that during an at-will agreement, at any point, the landlord can present a lease agreement that the tenant can either agree with or refuse, correct?
Well, I may have misspoke. It's not at any point, but once the tenancy at will, it is true that they could present the lease agreement to them at any point during the tenancy.
And then, go ahead.
But at the end of the tenancy at will, which is like 30 days, then they could require the tenant to enter into a lease agreement.
And then at the termination of that lease agreement, be it 6-month lease, then the tenant could theoretically, or excuse me, the landlord could theoretically not offer that lease agreement again.
There's nothing in this bill. Yeah, there's nothing in this bill that would prevent the landlord from refusing to renew a lease without any reason.
Only an at will.
Yes.
Thank you. Thank you, Madam Chair.
You're welcome. I'm not seeing any other questions for Mr. D'Alessandro, so I'll send you back to the attendee. And I did miss another proponent, and since we're still on the proponents, I'll bring this last proponent over, and then we'll move on to the opponents. And Ms. Moran, when you are ready, please activate your audio and video and proceed with your testimony.
Thank you.
Welcome, go ahead.
Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Gina Morin. I am a member of the Maine People's Alliance. MPA is Maine's largest community action organization with over 32,000 members across the state. Our mission is to create a world where everyone has what they need, contributes what they can, and no one is left behind. One of the most basic needs we have is a safe, decent, affordable place to call home. That's why I am testifying in strong support of LD 1134. LD 1134 will prevent Mainers from losing their home due to no faults of their own. When the tenant gets a 30-day no-cause eviction notice, they are put in an impossible position of finding a new apartment and moving within 30 days notice, or risk going to eviction court and being forcibly moved from their home. Under the current law, landlords seeking to profit from speculation on the real estate market can easily evict tenants with 30-day no cause notices to sell their buildings or pursue high-end development. This process is displacing tenants not only in main cities, but also in rural parts of the state. In 2016, I was forced out of my home in Oxford. After spending 10 days in my car, I rented a motel room. I lived there for over 4 years, actually. Tenants like me need housing stability. Also, especially during a pandemic. When a tenant is forced out of their home with nowhere to go, moving with a family or friend, or into a congregate setting, like an emergency shelter, vastly increases the risk of COVID-19 transmission. LD 508, it's also recognized Mainers' health and well-being also starts with having a stable home, providing mediation and presentation in eviction court to help tenants preserve their homes and avoid the devastating consequences of eviction, from forcing kids to switch schools, preventing families from relocating to a decent housing in safe neighborhoods because many landlords screen for past evictions. Landlords and tenants both benefit from coming to an agreement on how to preserve or end a tenant. By eliminating no-cause evictions in 1143, access to mediation on LD 508 can take two crucial steps towards ensuring all Mainers have the foundation to economic security that a safe, decent, affordable home provides. Maine People's Alliance urges you to vote
Ms. Warren,
yes.
your 3 minutes is up. Let's see if committee members have questions for you.
Thank you.
Thank you for your testimony. Committee members, are there any questions for Ms. Morin? I am not seeing any. Thank you once again for presenting your testimony this morning.
Thank you.
And that, I think, takes us through everyone who signed up to testify in support. And now we'll turn to those who wish to provide opposing testimony. And we'll start with Daniel Bernier, who will join us momentarily. Welcome, Mr. Bernier. You can proceed when you're ready.
Thank you. Good morning, members of the committee. My name is Dan Bernier. I represent the Central Maine Apartment Owners Association, and I'm a resident of Waterville, Maine. Landlords make money by renting apartments. They do not make money on empty apartments. It is against the landlord's financial interest to engage in an eviction without good reason. It also costs them money to go through an eviction. competent landlords, when you meet and talk with them, will have a conversation about occupancy rates. And if you're really one of the bigger ones that can't tell you their occupancy rate, doesn't know what they're doing. And one of the things here is that, well, landlords want to increase rents. Well, if you want to increase rent, it's much easier to give a tenant a 45-day notice of rent increase than it is to go through an eviction. That's all you'd have to do for these landlords. And then if the tenant doesn't pay it, you could just issue a 7-day notice for failure to pay your rent. So the idea that this somehow deals with people wanting to raise rents down in Portland at all, it simply doesn't stand up to the practice. As someone who tries a lot of eviction cases, the no-cause eviction is extremely important in protecting good tenants from bad tenants. When you have the trailer park bully or the man who's harassing the woman in the next apartment, often the people being harassed or being threatened do not want to testify. Had a lot of cases with drug dealers lately. So when the other tenants don't want to testify, you don't have the witnesses to prove your cause as a landlord. You have to default to the no-fault eviction. I do that on probably 7 or 8 cases a year where I'm doing that, using that for that reason, probably actually more than that, but I don't want to overestimate. The other issue I have with this is most month-to-month tenancies are in writing. I know very few landlords who don't use written agreements. So you have a term of either month-to-month, year-to-year, or in the case of a solar lease, you might have a 20-year term. So are we saying if you have a written month-to-month agreement, you can still evict for no cause under a 30-day notice? Or if we're saying you can't, then doesn't that also mean that under a year-long lease, you can't evict at the end of the year under a 30-day notice? And are we abolishing the notice of a tenancy for a term, a legal notion that has about a 1,000-year history in Western property law, and that's a pretty big thing to be abolishing. So I would caution you that I think the application of this statute as drafted is far more sweeping and actually ambiguous is probably the term I would use, and it's probably an employment project for lawyers. The other thing is subsection 1 only deals with some of the legal reasons for eviction. Section 6025, which you would be eliminating, denying the landlord access for the premises, would no longer be a reason for eviction. The other thing that I would also say in leases is often tenants, well, you'll see cases where tenants come up with something you didn't think of. I had a tenant pitch a tent in the parking lot. We would have lost on 4 cause. We had to do a no cause, and I'm running out of time, so I can't explain that case. I'd be happy to take any questions, but this is a pretty sweeping change which denies a landlord the ability to protect good tenants from bad tenants. I'd be happy to take any questions.
Thank you very much, Mr. Bernier. And I see that Representative Libby has a question for you, and then Representative Sheehan.
Thank you, Madam Chair, and thank you for being here today, Mr. Bernier. Can you please more fully explain that scenario you were just talking about? I'd like to understand this concept better.
Sure. In December, I tried a case. The tenant had set up a tent in the parking lot. She said she was using it for storage. We believed her brother was living there. When we went to trial, we had given her both a 4-cause notice for the tenant in the parking lot and a no-cause notice. The judge pointed out, and this was a landlord that uses a lease that I drafted that most of the landlords probably in this part of the state use. I had never anticipated in drafting that lease having to deal with somebody pitching a tent in the parking lot. And you see these cases where a tenant comes up with something you never thought of when you were drafting the lease. And the judge was very clear. We would have lost the 4-cause eviction, but we won on the no cause. And the parking lot, the intent was for parking, but I've never thought of putting that of the parking area that is for parking and not for pitching tents in a lease. I'm now redrafting my lease to include that in the future.
Thank you, Mr. Bernier.
Representative Sheehan, go ahead.
Thanks, Madam Chair, and thank you, Mr. Bernier. I just wanted to ask if you could submit written testimony. Your testimony is pretty dense, and I think I'd just like to delve into it before the work session.
Yeah, I will plan to do something before the work session. The pace of bills this week's got, I'm going to have to get things for the work session. It got the better of me, and I didn't want to put together something too quickly and make a mistake.
I feel your pain. Thank you.
Representative Moriarty.
Thank you, Madam Chair. Mr. Bernier, you mentioned, I think, section 65. And I wonder if you can tell us what that states.
Section 6025 is the section that allows you to evict under a 7-day notice if the tenant changes the locks on the apartment and fails to give the landlord a key. The way this statute's drafted, that would be eliminated as an eviction reason.
You can just sign it down. I'll fill it out.
Okay, thank you.
Any additional questions for Mr. Bernier? I see Representative Horn, your hand is up. Go ahead.
Thank you, Madam Chair. Mr. Bernier, I'm always amazed that here in the year 2021, we're just now discussing this type of legislature to become law, that it hasn't been brought up before or that it hasn't succeeded in the past. And I'm wondering if I could just kind of get your view on that. You seem very knowledgeable about landlord-tenant agreements. Why do you suppose it is that we're seeing this now and not in the past? Or have we seen it in the past and hasn't succeeded?
This bill has come up at least once, I'm thinking maybe twice in the past, and did not succeed. You hear a lot of reference to the pandemic, the CDC order. I will tell you, I think the CDC order, I haven't seen an eviction. I think that whole thing was really, I haven't seen any evictions where landlords wanted to evict where the CDC order would apply, because the big thing that you're seeing in a lot of the evictions right now is the tenants who are getting evicted never bothered to apply for any government assistance. They were told they couldn't be evicted, so they didn't bother to apply. And so I would argue that most of the real reasons for evictions right now are tenants got bad advice. They were told there was an eviction moratorium. It wasn't explained there's 4 or 5 things you've got to do to qualify for that moratorium, so they got evicted. And many of the tenants, they're pretty honest with you too, and I'll get to this on a later bill, they heard they couldn't be evicted, so they just figured they didn't have to do anything. Now, I want to be clear, 95% of the tenants have paid their rent. It's probably like 97, but we've done a lot of surveying. It's at least 95 paid, were good tenants, they paid their rent. So I do think this crisis showed that most people do the right thing, even if they don't have the threat of an eviction. But there was a small number that took advantage, and I think that whole dynamic, but also a lack of understanding of really what went on in that dynamic, is pushing this a little bit more right now. The one other thing here I didn't get to is I would also be concerned, part of why this failed in the past is a very strong presumption in our legal system for mutuality of remedy. And some of you talked about this. A tenant can break the lease at any time, but the landlord can't. We've always had that a landlord can evict under a 30-day notice, but a tenant can leave on a 30-day notice under a month-to-month tenancy and not be responsible for more rent. Under a year-long lease, if the tenant leaves during the course of the lease, let's say they leave 5 months into it, technically they're responsible for the remaining 7 months' rent. Sometimes it's trying to get blood out of a stone. And so there's a lot of legal principles why this has failed in the past. You're getting away from mutuality of remedy. You're getting away from tenancy for a term and the notion that the owner of property has the right to set a term by which somebody can stay on their property, a length of period of time. And so I think this really is a significant departure in Western real estate law, what we're talking about right now.
Thank you. May I ask a follow-up question, Madam Chair?
A brief follow-up question, Representative Thorne, because we've got other opponents waiting to testify on this bill. Go ahead.
Then I'll forego my question for LD 1508 coming up. Thank you, Madam Chair.
You're welcome. And thanks for your consideration to the other witnesses. That's much appreciated. Are there any other questions for Mr. Bernier? Not seeing any. Thank you, Mr. Bernier, for providing your testimony today. And next we'll bring over Representative Arata. Welcome, Representative Arata. I owe you an apology. I did not realize you were here to testify on this bill, and I ordinarily would have taken you as the first person to speak on the bill immediately after the sponsor. So please accept my apologies.
Oh, absolutely accept your apologies. No need for it. I appreciate your time. Senator Carney and Representative Harnett, thank you for letting me testify in opposition to this bill. Although well-intended, this bill will make it almost impossible to evict tenants who are causing harm to their neighbors. Under this bill, if a tenant's being harassed or threatened by her neighbor, or her neighbor's causing her harm through secondhand smoke, damaging her property, keeping her family awake all night, etc., she'd have to go to court and testify to help her property manager get the offender evicted. But many tenants are afraid to make the neighbor angry or can't afford to take a day off of work to attend court. And many also have severe anxiety about public speaking. The property manager can't go to court and testify on behalf of the victim about the harassment because that would be hearsay. Also, in the unlikely event that the victim of harassment or other harm were actually to go to court, she would have to then go home and wait at least 7 days for the writ of possession to be issued, and then at least another 2 days after that for the sheriff to escort the offender off the property, assuming no holidays or weekends interfere with the process. So that's at least 9 days of sharing a building with a person who would be angry and maybe dangerous. Also, some tenants don't have the English language skills to testify in court or communicate a problem to their landlord. I once had a tenant who began calling me with racist rants about her new neighbors. So rather than allow her to harass these new Mainers who were doing nothing wrong, I initiated a no-cause eviction to get her out of the building before things escalated. This bill would have prevented me from doing that. If I can't pursue an eviction of a troublesome tenant, then the neighbors who can afford to move away will. But families who can't afford to move will have to stay and suffer and possibly be in danger. So this bill would harm the very low-income people who it's intended to help. Now, the vast majority of tenants work hard, respect their neighbors, and are not in danger of no-cause evictions. But because landlords have no incentive to evict good tenants. This bill would protect the small number of tenants whose extreme behavior makes life absolutely miserable for their neighbors and also effectively creates an infinite lease for tenants at will. So thank you for letting me testify, and I'd be very happy to answer any questions.
Thank you very much. Committee members, are there questions for Representative Arata? Representative Libby, go ahead, and then Senator Kime.
Thank you, Madam Chair, and thank you, Representative Arata. Can you please explain that term to me? I'm not familiar with, I think you said infinite lease, and how that's affected by this bill.
Right, so if you have a tenant, well, we've talked about this a little bit earlier. I can't force a person to sign a lease, but under this bill, I believe I wouldn't be, a refusal to sign a lease is not a cause for eviction. So the person's already living there, they have possession of the apartment, and in order to get them out, I'd have to give if I wanted to move my grandma in to an accessory unit or something like that, I'd have to give a no-cause notice of termination. And then if they refuse to move out, I'd have to go to court to get them out. I couldn't do that under this bill. That tenant would be able to stay there infinitely. There's just no way to get there would be no way to get my property back.
Follow up, if I may, Madam Chair?
Yes.
Thank you. So we heard in earlier testimony that all you have to do to be able to evict under this bill is simply have your tenant sign a lease, but you're saying that some tenants would be reluctant to sign a lease because they know that then you do have more legal recourse to evict. Is that correct?
Right. And, in fact, I have a client right now who's dealing with that. She had a year lease. She gave the tenant notice that she was terminating the lease. She wanted possession of the property back, mostly because the tenant, she caught her smoking in the building. She'd smelled smoke, but, it's hard to prove unless you see somebody smoking that they've been smoking. and she lived on the other side of the duplex. She wanted possession of her property back, and the tenant's refusing to move out and refusing to sign another year lease. She did give her the option to sign another year lease because she did like the income, you know, the reliability of the income. So now she has to go to court with a no cause eviction to get the tenant out because it's just, she's in a really bad situation. The tenant was hoping to have a month-to-month or a tenant at will lease because she wants to buy a house this summer or move into a bigger place or something. So it was about the tenant's convenience.
Okay, thank you very much.
Senator Kime?
Thank you, Madam Chair. Thank you for being here, Representative Arata. I wonder if you could tell us if you've ever done a no-cause eviction yourself and just kind of walk us through that process a little bit. And because I'm a little bit wondering too, if something that you said made me think that the no-cause eviction is sometimes used even though there is a cause, but because the pathway is less messy. So those are the two questions I have for you. Thanks.
Right. One that comes to my mind was I had a tenant, his lease had ended, and so he became a tenant at will. And he had been behaving erratically. He'd been smoking in the property, you know, even though it's a no smoke, all my properties are non-smoking. I'm very strict about that because the other tenants shouldn't have to live with secondhand smoke. He'd just been, one day I asked him to please shut his window because it was wintertime and his window was left open and I pay for heat. He started swearing and cursing at me, just really acting bizarre. And then he got kind of quiet and he looked at me and he said, my address, like, don't you live at this such and such address? And I took that as a veiled threat. Now he didn't violate the law. It's not against the law to swear at me. It's not against the law to quote my address where I live. And I've been using a PO box in my correspondence with tenants because it's a business, you know. And so at that moment, I decided as a woman, you know, am I going to take this threat and go out of business? Am I just going to give up? Or will I take control of my business and not allow him to threaten me? And so I did do a no cause eviction. It was very messy. He fought it all the way. He said, I don't know why she's evicting me. You know, it's kind of like that. And then, you know, my instinct was correct. I did see in the paper that he's actually in prison for assault. So that's one example where I used a no cause eviction to protect myself and my family. Felt I had no choice.
Right. Thank you. I'm sorry. I just have one other clarifying question because now that you said that. So I was assuming that a no cause conviction wouldn't go to court, but I guess there's the option always there is what you're saying, because this one went to court. So it's not like you as a landlord could just say, here, you know, you're being evicted. If they fight that, you go to court with them.
Right. I gave him a 30-day no cause eviction. Then I stayed away from the property because I started getting phone calls and emails and things like that. So I gave him a no cause notice to move. He could have moved. He had 30 days. Then I went through the process of having the court summons served to him by sheriff. Then you have to do that. I believe it's 7 days before the court date, and there are only 2 court dates in Androscoggin County. Some courts have only one a month, and some only one a quarter. So it took several months to get him finally evicted, and he did move out before the sheriff showed up with the final FPD. He was able to move in with family, and actually he kept harassing me throughout the time that this was going on. So I couldn't even go to my own property to mow the lawn. So it was pretty traumatic. I don't know why I'm in this business.
Thank you.
Committee members, are there any additional questions? Go ahead, Representative Thorne.
Well, you're on mute.
We're not able to hear you.
Sorry, that was a Sophie guard. I have a question for you. My brother up here in Brewer got into the renting his house one fall. And he went on the trust factor, verbal agreement. And essentially what happened was he unknowingly rented to a professional squatter. So this person knew that they could not get evicted in the wintertime. And she never paid him a dime.
Representative Thorne, are you testifying or are you asking a question? Could you clarify that, please?
Am I testifying or I'm asking a question? As a member of the committee, I believe I'm asking a question. I'm setting it up with an example. And perhaps I'll shorten my example for your pleasure.
Thank you.
So basically, this person didn't pay him anything throughout the winter. And then after that whole time frame, probably 6 months passed, she moved on and he never did see any of his money. In this case, with unnecessary eviction, and there's a clear list of causes, does this put all the effort into protecting the tenant versus the landlord? Do you think?
Well, I think that in the situation you just told me about, you could still evict with a 7-day notice for non-payment. So you have to wait till the rent is 7 days late, and on the 8th day, you give them a written notice. You have to hand it to the tenant, I believe, make 3 attempts. If the tenant's not home, you can leave it on the door. That gives them a 7-day notice to pay or get out. And they don't get out. So
even in the winter?
Even in the winter, yeah. Otherwise, you would never see a dime. All winter long, you wouldn't be able to pay your oil bill. So you at day 14, then you, or 15 or 16, depending on how long it takes to serve the notice, you can go to court, purchase the summons paperwork, and then have that, and then pay someone to deliver that, pay the sheriff or somebody official to deliver that to the tenant. So with COVID, I believe it's not 7 days anymore. I think it's longer than 7 days for non-payment. Of course, with the rent relief program right now, there's absolutely no reason for a tenant not to pay the rent. And most landlords are willing to wait for the paperwork to get done for them to pay the rent, as long as everybody's working in good faith. So I think your brother should have hired a lawyer.
Yeah, you tried going through the police, but it didn't work. So, well, thank you.
Sure.
Committee members, any additional questions for Representative Arata before we move on to Mr. Chamberlain? Not seeing any. Thank you once again for being before the committee today, Representative Arata.
Thank you. Nice to see you all.
And Mr. Chamberlain, you can activate your camera and your video and proceed when you're ready.
Thank you, Senator Carney and members of the Judiciary Committee. My name is David Chamberlain. I've been practicing law in the state of Maine for 34 years. Chamberlain Law is the name of my firm. We have prosecuted more forcible entry, detainer, eviction cases than any other law firm or attorney in the history of the state of Maine. It's just, I don't say that to be boastful of any means, but just to state my experience level. And I'm sure my colleagues at the loyal opposition at Pine Tree Legal will confirm that. My practice consists of a concentration here in Cumberland County, York County, Androscoggin. We service courts from Skowhegan to Bangor to Rockland and everything south, and have been in some of the northern counties occasionally. This is just straight unconstitutional deprivation of property without due process of law. This bill would I think would be stricken down as depriving people of their property. In the state of Maine, we have many leases that expire and have no continuation language. When the landlord accepts rent after that lease expires, a tenancy at will is created. In Maine, we have a lot of informal landlords, from your mom and pop all the way to some of Maine's biggest landlords that have tenancies at will. And the only thing that governs them is Section 6002 of Title 14. So in answer to the question posed by Representative Moriarty of Mr. D'Alessandro, you cannot require a lease of a tenant once this bill passed. If this bill passed, that tenant has a tenancy for life. It would prevent a landlord from evicting that tenant except for cause. I routinely litigate for cause evictions under rural development, HUD properties, public housing, LIHTC properties, fair market. It's very difficult to prove these cases. And as Dan Bernier pointed out, tenants are very reticent to testify against other tenants. It's just a difficult thing to subpoena them and then to have them come in and not expect retribution in these cases. This bill would prevent a landlord from protecting other tenants from a drug deal that you can't prove. Oh, that case is still under investigation by the MDEA or the police department. So don't subpoena us in. This tenant hasn't been charged yet, but people are coming and going from that property, and there are unsavory characters there. And this is just bad policy and unconstitutional.
Thank you for your testimony, Mr. Chamberlain. I see that Representative Libby has a question. Go ahead.
Thank you, Madam Chair, and thank you for being here today, Mr. Chamberlain. Earlier, we heard in testimony about other states, specifically New Jersey, having laws that are even more extreme than the one we're considering today. I wonder, given your depth of knowledge on the issue, if you can speak to what other states have done. And I'm curious if you think we should be or should not be emulating what New Jersey has done, if that's a desirable law that they have there, or if Maine should perhaps not be attempting to imitate that law or others from other states.
I was multitasking when Frank D'Alessandro testified about what was going on in New Jersey, but regardless of what is happening in New Jersey, I'm only licensed here in the state of Maine, but as Mr. Bernier mentioned, this would abrogate years of case law and statutory construction in Western law. It literally would deprive somebody of their property. I heard the example given by one of the proponents that if somebody wanted to sell their property to take advantage of the hot market right now, that would somehow be a bad thing, that landlord would not be able to sell the property without having a tenant in it. And that's just deprivation of property. And why shouldn't that landlord who may bought it in a low market when things weren't going so good, and the property is now worth money, and he can't sell that because he can't make it vacant upon closing? It's just a straight up deprivation of property.
Clarifying question, Madam Chair.
Yeah, I think you asked two questions in that last round, but go ahead. Last question. You could have the third one, and then we'll see if anybody else has questions.
Thank you. I would like to make the point. I think Maine residents and citizens are we should have all the questions we need when deciding if a law is worth passing. And if I can't get the information because I'm limited to a certain number of questions, I don't think that does Maine citizens any good. So Mr. Chamberlain, in your view, would this law infringe on the Fifth Amendment to the Constitution of the United States of America?
Absolutely, straight up. It's a law that prevents due process of law. You can no longer take a tenant to court except for cause in a tenancy at will case. You are unable to regain possession of your property and cannot take a tenant to court for a no cause eviction. We also have to understand that this is a mutual right. The tenants sign up when they sign up for tenancy at will, and the landlord and the tenant just have maybe a rental agreement of some sort that sets some form of rules and regulations, but it is a tenancy at will from the beginning. The tenant benefits from that because they're able to give a 30-day notice when they want to leave, or when they came into some money and saved up for the down payment of their house and they want to move. Well, under a lease, if they're ready to buy a house, start a house in month 6 of a 12-month lease, and they have to break their lease, then that presents problems. Okay, they're under the obligation of the lease. But if a tenant at will wants to buy that home, and they can give a 30-day notice and reasonably move. So it's a mutual right. And the fact that it was mentioned earlier by Mr. D'Alessandro that you could require a lease after this bill is passed and becomes law is absolutely not the case. Representative Moriarty was correct. If the tenant is paying their rent, otherwise abiding by the terms and conditions of their lease, they are a tenancy for lifetime. The Section 8 years ago, tenants that have Section 8 through HUD, where HUD pays the administrating housing agency pays 70% of the income of the rent to the landlord, relax those regulations where you had to have cause for a Section 8 tenant to move from a private residence to you're able to terminate at the end of a monthly term or at the end of the first initial year lease. So this would create a strict no cause, no ability to get your property back. It's just bad legislation. And we can't take a permanent, a temporary situation where to my right shoulder up on Munjoy Hill, where there are people taking advantage of
Mr. Chamberlain, I think you've answered the question. We appreciate your willingness to provide the answer to Representative Libby's question. We have our next opponent ready to testify. Committee members, are there any additional questions for Mr. Chamberlain before we move on to Mr. Layton? I am not seeing any. Thank you very much, Mr. Chamberlain. And Mr. Layton, you can begin your testimony whenever you're ready.
Hello, thank you, Senator Carney, Representative Harnett, and the Judiciary Committee. My name is Matt Layton. I have owned rental property for over 10 years, and I wanted to share two impacts that this bill would have on my business and a couple of stories on how I've used them, so-called no-cause eviction in the past. So as other people have mentioned, people have issued no-cause evictions for issues that are difficult to prove in court. And I've issued a 30-day notice in conjunction with 7-day notices in the past for issues of non-payment and behavioral issues. In one instance, I had a tenant, unbeknownst to me, who was dealing drugs out of his apartment. His apartment was raided by the local detectives with some state involvement with the DEA. Even though the detectives and the DEA found drugs in his apartment, they were unable to testify in court to that fact, leaving me with a matter of hearsay before a judge to get that tenant out so I would not be subjecting my neighboring tenants to his drug dealing. Moving on, throughout my 10 years of managing rental property and owning rental property, I've had a typical practice of going month to month with tenants after the initial term of their lease agreement. I've always given tenants the choice to sign on an additional term. There's only been a couple of tenants in over 10 years that have taken me up on that option, and I've happily obliged because they were decent tenants. But I've found that a lot of my tenants enjoy the flexibility of a month-to-month arrangement, and it allows them to do things like shop for apartments, and which a lot of them will tell me beforehand, hey Matt, we're thinking about moving in the next 3 to 4 months. Just wanted to let you know. And I reply with thank them for letting me know, and just remind them that they need to give me a 30-day notice once they find a place. I think that's a really important benefit for tenants in this tight rental market. If this bill were to pass, I would be forced to keep everyone on a term, and that flexibility for tenants they would not have that flexibility. On the other side, when I'm showing apartments, I routinely show apartments to tenants who tell me their landlords are selling their buildings and they're apartment shopping because it's such a tight market. So thank you for your time and your consideration.
Thank you very much, Mr. Layton. Committee members, are there questions for Mr. Layton? I'm not seeing any. We appreciate you being here today. And next we have Ned Payne. And Mr. Payne, you could begin whenever you're ready.
Great. So good morning. My name is Ned Payne. I'm a housing provider in Portland. I primarily rent to workforce and mid to low income tenants. I'm here speaking on behalf of myself and the Southern Maine Landlord Association in opposition to LD 1143. So no cause evictions. The belief that landlords routinely part ways with tenants doing no cause evictions for no reason is just something that does not happen. It's unfortunately a very poorly named concept. There's always a cause in a no cause eviction. When a tenant leaves, it takes a lot of time and money to freshen up and rehab their apartment into a presentable condition and then go through the process of finding a new tenant. Under no circumstance would I ask a tenant to leave and go through this process unless I had a very good reason for doing so. The ability to part ways with the tenant who is not under a lease using a 30-day notice or termination of tenancy at will or no cause eviction is an incredibly important tool I ask you to protect. I ask you not only because it helps me, but it benefits the reasonable tenants in a building dealing with a troubling individual or group, the respectful neighbors next door, and the already heavily burdened court systems in Maine. A few years back, I bought a building and soon found out that one of the tenants was dealing heroin. I found this out from the tenant that lived across the hall from the drug dealer. The tenant who told me was a 19-year-old girl that was 100 pounds soaking wet, that had a 2-year-old daughter, with just the two of them living there alone. To the best of my ability, based on the amount of activity, I was able to confirm that there was drug activity. Fortunately, this troubled tenant was month to month, and I was simply able to give them a 30-day notice asking them to leave. While there are hundreds of used needles in a wrecked apartment I did have to attend to, I did not have to file a court case. I didn't have to ask, compel, subpoena, or pressure this petrified girl to come into court and testify against the drug dealer. Had no cause evictions not existed, the dealer could still be there today. Instead, the young woman still lives there and her daughter just turned 6. The other tenants in the building are safer and the neighborhood is a better place. She told me she would have never testified against him because of the fear, danger, and risk it entailed. Less dramatic, but unfortunately more regular, I've come across tenants who are smoking. The tenants around them can smell it, and it can cause a lot of trouble and concern, especially with those with children who fear the effects of secondhand smoke or have issues with asthma. Proving this, however, and getting people to agree to testify against their neighbors with no guarantee of a favorable income is not an open and shut case you'd expect. An eviction is cumbersome, expensive, it's time consuming. It's a very emotional process because it's so frustrating. The ability to do no cause evictions is imperative. And again, no landlord evicts a good tenant for no reason. I'd argue no landlord evicts even a mediocre to slightly bad tenant for no reason, as it's a hell of a process to go through, and there's no guarantee the next tenant is going to be stellar. I don't think a reasonable or good landlord who cares about their safety and happiness of the other tenants in the building, their neighbors, the neighborhood, town, or city would be able to operate without the ability to do no cause evictions. And I ask you to not support this bill. Thank you.
Thank you very much, Mr. Payne. Committee members, are there any questions for Mr. Payne? I am not seeing any, so Mr. Payne, we again want to thank you for appearing today. I'm going to move over the next opponent, and then I actually need to step out of the hearing, and so I'll turn the virtual gavel over to you, Representative Harnett.
Thank you, Madam Chair. And I believe that we are now hearing from the last person who has signed up to testify in opposition to LD 1143, and I welcome Mr. Cashman to the panel. Mr. Cashman, nice to see you again. Whenever you are ready to start, just begin and I will start the 3-minute clock.
Thank you, Representative Harnett, distinguished members of the Joint Standing Committee on the Judiciary. It's nice to see all of you again. I'm going to, in the interest of time, so I'm here on behalf of, my name's Andy Cashman. I'm here on behalf of my client, the Maine Association of Realtors, and they represent over 5,600 members in residential and commercial transactions across our state. And I'm a partner at Party Flaherty. So what I want to say is just in the interest of time, and obviously I'm trying to rush this to try to compress, but if you look at my written testimony, we consolidated our opposition to 3 of the bills today. I'm here to speak on 1143, but we also have 1255 and 1296. I will not be speaking live on those bills to try to save time for the committee. I would just like to say our overarching opposition to these bills, though, and to 1143 in particular, is that we think that there's been a lot of discussion this morning about balance, and we do think that this is pushing that balance out of whack. And we appreciate where this is coming from in terms of concerns around affordable housing, and there have been a lot of bills around affordable housing. It's an issue we care very deeply about. And we, in fact, have opposed a number of bills that we think approach that problem in the wrong way, and supported a number of bills that we think address that problem in the right way by building more affordable housing. In this case, though, this bill and all 3 of these bills are really favoring one party over another, the landlord over the tenant, disproportionately, and we think inappropriately. You know, a lot of the landlords are small family-owned businesses, and in this case, you would be able to evict somebody for lack of payment of rent. The other ones you would not. In this case, you don't want to have somebody interrupted with their not be able to pay their mortgage and then have to disrupt and expel tenants in order because they've defaulted on their mortgage and they have to sell the property, et cetera, et cetera. Landlords couldn't afford maintenance or repairs on properties and liability insurance or upgrades as well if they have interruptions in rent. You know, one of the big concerns with these bills as well, and in 1143 in particular, is that they could cause significant delays in transfers of real estate. That, you know, this, even with the carve-outs that Representative Harnett discussed in 1143, where, you know, you have serious problems like domestic violence, and you can still expel people even with these changes under that. You would not be able to expel them if they were disrupting somebody's ability to have the property inspected for a sale, or if a tenant was refusing to show the property, or if they needed to expel somebody in order to be able to move in themselves or their family into their own property that they're renting. Sometimes also buyers need to be able to own or occupy the property in order to be able to purchase it. So those are the reasons why, you know, we oppose this. I'm trying to address our primary concerns with it in terms of the impact on the real estate market. A lot of the comments I was going to make in terms of the legal impacts, you know, I think have been addressed well by attorneys Chamberlain and Bernier. The only other point I would make is that to Attorney D'Alessandro's point that, you know, if you have a lease, you could evict somebody at the end of that lease rather than put them into a tenancy at will. I don't think that that's a situation that anybody wants to see. It's really advantageous not only to the landlord, but also the tenant to be able to go into a tenancy at will. We don't want to, I think that would have the opposite effect. You'd be forcing people to be expelled from the property just because the lease has ended and they don't want to sign another lease. So I think that would be problematic. I appreciate the committee's concerns or time, and I'm happy to answer any questions that you may have.
Thank you very much, Mr. Cashman. Are there questions from committee members for Mr. Cashman? Seeing none, I thank you very much for your time today.
Thank you for your time.
It appears that I misspoke. We did have another person who had registered to testify in opposition. Ms. Frazier, welcome to the Judiciary Committee. Whenever you are ready to begin your testimony and feel comfortable, just start and I will start the 3-minute clock. You'll see me hold it up when there's about 10 seconds left to testify.
Great, thank you.
Thank you, Chairman Harnett, members of the Judiciary Committee. My name is Elizabeth Frazier. I'm an attorney at Pierce Atwood. I'm a resident of Portland, and I'm before you this morning on behalf of the Maine Real Estate and Development Association. We are the state's premier trade association for commercial real estate development. Our members are varied and many. We have architects, bankers, realtors, engineers, pretty much you name it, anyone that could be involved in commercial real estate. I think in the interest of time, the committee has heard a great deal of testimony this morning, and I won't repeat it. I did submit written testimony. You'll see me again this morning on a couple of other bills, and I think Mr. Cashman sort of touched on the same underlying theme, runs through all of these, and that's really that there's a few proposals here this morning that I think do threaten to upset the balance of real property ownership in the state of Maine. And that there are better ways to address the affordable housing crisis that Maine is facing. Primarily, and Marita is consistent on this point, we make it in front of a lot of committees these days, the construction and development of affordable housing. We simply don't have enough. The only other thing I would say here, I would echo Mr. Bernier's point that this is a significant shift in sort of our underlying real property rights system. I had to really go back to first year property law when reading this bill to think about the impacts, because that's how basic it is. The only other thing I would say is that, just to remind the committee and to bear in mind that property owners aren't required to offer their property for rent. They do it because they choose to for any number of reasons. And that balance that I spoke to earlier has to be maintained, because if it's not, and there's a disincentive, then someone who is seeking to make money from their property, might just convert it to condos. And that's a real thing. And this bill can't stop that. So just reminder to sort of keep in mind the balance of real property ownership. And again, you'll hear from me this morning on a couple of other things, but construction and development of new affordable housing, that's the theme for the morning. Thank you so much, and I'd be happy to answer any questions.
Thank you very much, Ms. Frazier, for your testimony, and I know we will hear from you on the bills coming up after this one. Are there questions from committee members for Ms. Frazier? Seeing none, I will thank you for your time again, and look forward to seeing you probably in a couple of minutes. That is the last person that I had signed up, seen that was registered to testify on 1143. I do want to take one more look at the attendee room to make sure that there's not anyone else who would like to speak in opposition to LD 1143. And seeing none, I would ask if there is anybody who would like to speak neither for nor against LD 1143. And seeing none, I will now close the hearing, having heard testimony from all those present. Whoops. Representative Supika, are you? Soupy, could you move Representative Supika over so I can see if she wants to testify on LD 1143? Representative Supika, you put your hand up when I was asking about 1143. Did you wish to be heard on that?
That was bad timing on my part. I'm here to testify for 1255, and I was trying to give you my hand. So I'm here.
Thank you. Not a problem. Then I will now close the hearing on 1143, having heard from all those wishing to testify. We will now move to the next bill on our agenda, which is LD 1255, an act to prohibit evictions until 90 days after the end of the governor's declaration of emergency. And I recognize the bill's sponsor, Representative Lookner. Welcome to the Judiciary Committee.
Thank you, Mr. Chair. Senator Carney, Representative Harnett, distinguished members on the Committee on Judiciary. My name is Grayson Lookner, and I represent the neighborhoods of Libbytown, Nason's Corner, Rosemont, and Stroudwater in Portland. I'm here today to introduce LD 1255, an act to prohibit evictions until 90 days after the end of the governor's declaration of emergency. And much of what I'm about to say could be taken directly from Representative Harnet's testimony on his bill earlier today. So here goes. In 1948, the United Nations adopted the United Declaration of Human Rights. One of those rights was the right to adequate housing in which a person can provide for their, quote, health and well-being, unquote. Never has this right been more important to both individuals and the public at large than during the coronavirus pandemic of the last 14 months. Everyone by now ought to be aware that the primary means of keeping ourselves and others safe from the spread of the disease during this time has been to socially distance and shelter in place. That is the reason why the National Center for Disease Control and Prevention has issued an evictions moratorium last September that prevents some evictions for some renters who are unable to pay their rent due to financial hardship caused by the pandemic. That ban did not go far enough. It does not cover evictions without cause, as we've heard this morning. Right now, a landlord is not permitted to evict a tenant for inability to pay their rent if that tenant can demonstrate that financial hardship, that financial hardship due to the pandemic. That landlord can, however, evict a tenant for no reason whatsoever, hundreds of which are underway in the state as we speak. That doesn't make a whole lot of sense to me. University of California study demonstrated that states that enacted broad evictions moratoria at the beginning of the pandemic had lower death rates than those states that did not, and attributed over 10,000 deaths nationally to inadequate protections for tenants during this public health emergency. That alone should be reason to enact a strong evictions moratorium. There are other downstream reasons why such a prohibition is necessary. Thousands of Mainers are still without work and are surviving on federal aid that will likely expire as soon as the state of emergency is lifted. When that happens, there is likely to be a wave of evictions. We must do everything in our power to prevent that from happening. Our state spends millions every year on emergency measures to serve people experiencing homelessness. This money is spent on housing vouchers, emergency room visits, police and emergency intervention, municipal general assistance, indigent legal services, something I think is of interest to this committee, aid to numerous agencies and nonprofits throughout the state that serve this population, and a myriad of other costs borne by the public. Even with all this help, dozens of our unhoused neighbors die in Portland from preventable causes every year. We can stop all this by preventing people from falling into homelessness in the first place. Preventing renters from falling into homelessness has innumerable benefits for the public. Children in these households will be much more likely to succeed in school. And when work becomes available, these renters will be much more likely to pursue those jobs. Health and economic outcomes decrease significantly for people who have experienced evictions. I know there are no shortage of landlords and others who will testify in opposition to this bill, and I understand that it is asking them to take a lot of personal responsibility to provide for a public good. However, I would add that when people decide to go into the business of working as a landlord, they're taking responsibility for another person's health and safety as their tenants. This bill does not prevent evictions of tenants who are destructive of property or who present a danger to themselves or others. All it does is ensure that during this state of emergency that landlords do their part and keep a roof over the head of their tenants. We must ask ourselves, what is more important, human life and public safety, or the ability of some people who own property that they rent out to evict people for no cause? Most landlords have been working hard to keep their rents low, to work with tenants to utilize other resources that have been made available during this pandemic to keep people housed. Some others, however, have deemed it necessary to try to evict tenants for no other reason than they wish to renovate their properties or convert them into profitable short-term rentals. Let's help the tens of thousands of Mainers renting and at risk of eviction in the coming months and give them some certainty that in our state, we value their lives, their safety, and public health, and we'll give them time to find other arrangements so they can continue to live in the communities they call home. We can do this by prohibiting evictions until 90 days after the declared state of emergency ends. Thank you for hearing my testimony. I urge you all to pass, and I'll do my best to answer any questions, although we will have legal experts testifying after me.
Thank you very much, Representative Lookner, for bringing this bill forward to the committee. I will now turn to committee members for questions for the bill sponsor, Representative Lookner, and I will recognize Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Representative Lookner. Couple questions for you. One is, are you and have you ever been a landlord?
You know what, that question I think is, I've been the chief leaseholder and been somebody who's subletted numerous rooms. But I myself, and I don't see how that really pertains to this conversation, but the answer is no.
Thank you. Another question, if I may, Mr. Chair. Thank you. So this bill, I'm just looking at items 1, 2, and 3 on line 17, 18, and 19, non-payment of rent, expiration of term of lease, and certain termination of tenancy at will. So if a tenant, let's say a tenant didn't pay last month's rent and they haven't paid this month's rent, have no plans to pay rent moving forward, and haven't applied for rent assistance, even if they are, even if they're qualified to receive it, this bill would say that that person could not be evicted until 90 days after the expiration of the public health declaration of emergency. Is that correct?
Yes, that is correct.
Thank you. And one last follow-up, if I may, Mr. Chair.
Yes, you may. Thank you so much.
Given the ongoing nature of the declaration of emergency, do you have any knowledge that the rest of us are lacking in when the declaration of emergency will end?
Thank you for that question, Representative Libby. You know, that is, we have separation of powers in the state, as you're aware, and the governor, that is her decision, the chief executive's decision.
So no date.
It's up to her.
Thank you.
Thank you, Representative Libby. Are there additional questions from committee members for the bill sponsor, Representative Lookner? Seeing none, thank you very much for bringing this bill forward. You're welcome to remain as a panelist for the remainder of the public hearing.
Thank you, Mr. Chair.
And I am now going to call on Representative Supika, if I could have her moved over as a panelist committee clerk. And Representative Supika, as soon as you are ready, first of all, welcome to the Judiciary Committee. I will let you know, and everyone else testifying here forward, due to the sheer number of bills we have and the number of people wishing to speak, other than the sponsor, we limit people to 3 minutes. So I will be putting you on a clock. Once you begin to speak, I'll hold it up with about 10 seconds left, and then I'll remind you when that time has expired. But welcome to the committee and proceed when you're ready.
Good morning. Thank you. Thank you. Senator Carney, Senator Harnett, and honorable members of the Joint Standing Committee on Judiciary. I'm Representative Laura Supika, and I represent House District 126, which includes a portion of Bangor, and I'm here today in support of LD 1255 and Act 2 prohibit evictions until 90 days after the end of the governor's declaration of emergency. So there is a direct correlation between a person's health and their housing, and that is why I'm urging judiciary to pass this bill. We know that quality, affordable housing reduces negative health outcomes. The effects that evictions have on public health are clear. An eviction causes a family to lose their home. most often their possessions, sometimes being thrown to the streets. And it's an extremely traumatic event. Children can have to change schools, people can lose their jobs from the turbulence, and now a mark is placed against them, making it harder to rent again. It has a huge effect on people's mental health and well-being. It is also shown that it is not just a condition of poverty, but a cause. Evictions can target groups of vulnerable people, putting them in even more precarious situations. Victims of domestic violence, for example, can be targeted by landlords in municipalities that have nuisance ordinances that penalizes tenants for calling for help and pressures landlords to evict tenants who call 911. Such an ordinance exists in Bangor, and when I inquired about it, I was told that it's a really good tool in the toolbox. So it's a tool that's used to kind of intimidate, even though that might not be the landlord's intent. But it's an intimidating thing for a person experiencing domestic violence to know that if the police are called, they could put themselves and their family at risk of becoming homeless. Evictions are also gender and racial justice issues because of the disproportionate effect on women, and particularly Black women. It has been shown during this pandemic that Black women renters had evictions filed against them at twice the rate of white renters in most states. This pandemic has flipped our economy upside down. Some individuals have sustained themselves, while others have done very well. But for those who are barely holding on, the bridge back to normalcy is not complete. The current ban does not sufficiently close the gaps, and too many are beginning to fall through. We will be facing mass evictions, and that will result in a continued instability and will affect the well-being and economic recovery for the entire state of Maine. And I am happy to answer any questions that you might have to the best of my abilities, and I thank you all for your time here today.
Thank you very much, Representative. Are there questions from committee members for Representative Suppica? Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Representative Suppica. So 2 questions. One is, if the landlord does not receive rent payment for months on end and ends up in foreclosure or some other financial difficulty, does that end up harming the tenant in the long run?
It's a pretty complex question right there, and one that I think there's lots of different avenues to. It's a very specific example that would have multiple outcomes, and I'm happy to get what legal recourses and what is available to you for the work session, so that you can have examples of that.
Thank you. I'd appreciate that. And one more question, Mr. Chair.
Yes, Representative Libby.
Thank you. You referenced that in most states that Black women have unfortunately been adversely affected more than really any other group. Of course, we're specifically talking about Maine. So if you could get me the research pointing to that here in Maine for the work session, I would appreciate that.
That is a great question. I really appreciate you asking that. And part of the issue with this information is that extensive studies have not been done in these areas. I've tried to see what's specifically available to Maine, and I will get what I can find. But there is a lack of data in this area because I think, honestly, we haven't been acknowledging racism in our housing, and I don't think that there's been enough studies to shed further light on that. But that is a great question, and I'll show you what I can.
Thank you. Whatever research that you have that you used when you were writing your testimony would be a great place to start.
Absolutely, absolutely. I will send citations for my statements. Absolutely.
Thank you very much.
Thank you, Representative Libby. Are there additional questions for Representative Suppica? Seeing none, thank you very much for presenting your testimony to the Judiciary Committee today. We appreciate it. I am going to ask the committee clerk, I'm going to take a witness out of order, and I would ask that Representative Arata be moved over as a panelist. I realize she is testifying in opposition to the bill, but I'm doing this as a courtesy because I am aware of the time demands on my legislative colleagues. So if we could have Representative Arata moved over. Representative Arata, welcome back to the Judiciary Committee. begin speaking whenever you're comfortable, and I'll start the clock and wave it to you at the appropriate time.
Okay, thank you, Representative Harnett and members of the Judiciary Committee. It's nice to see you all again. I'm going to be spending some time with you this morning, I guess. So the good news about this bill is that it's no longer necessary. Due to the rental relief program that has been instituted, there's no reason to have unpaid rent. There's no upper limit on what can be paid. Tenants can apply even if the landlord refuses to cooperate. And in my testimony, I gave you a link to more information about the program. However, landlords can't apply for rent relief on behalf of the tenants. So some tenants, I do know of some tenants, none of mine, I have good tenants, but some have refused to cooperate out of spite. And so, under this bill, those who refuse to cooperate out of spite would be able to stay in their housing. And there's just no need for that. A bill dealing with this problem, LD 1322, was heard yesterday by the Labor and Housing Committee. It probably won't pass because the federal government has some strings attached to that money that requires the tenants to cooperate. Other than that, the rest of my testimony is very similar to that of the last bill. I and most other landlords take very seriously our responsibility for the health and well-being of all our tenants, including those whose lives can be made miserable by a bad neighbor who's threatening, terrorizing them, keeping them up all night, smoking, giving them asthma attacks. I mean, that's the type of people who normally have a no-cause eviction. There's a vacant building is not worth very much. I don't know why people think that evicting tenants helps the value go up. In fact, you can't get a mortgage for a vacant building. I believe if they're more than probably 90, they have to be at least 90% occupied for most lenders to provide a mortgage. And that rental income is part of the calculation to determine the value of the building. So you really need that rental income to make the building valuable. So there's really no need for landlords to evict tenants who are good tenants and paying. There's no reason for tenants not to pay with the help that they're getting from this program. Also, I want to address something. In the state of Maine, I can't evict someone and just throw their possessions out on the street. That might be true in other states, but in Maine, we have an abandoned property law, and there's a process you have to go through. I have to store their property for a given period of time and go through a process. We talked about race a little bit, and I have evicted a tenant for being racist. And under this bill, I wouldn't be able to. I mean, I think that new Mainers should be treated with respect. And I'm not going to put up with a tenant who treats her new Mainers poorly, or her neighbors who are new Mainers poorly. And if that makes me a bad person, so be it. But I take it very seriously to protect people who rent housing from me. So with that, I'd like to answer some questions if you have any.
Thank you very much, Representative Arata. Are there questions from committee members for Representative Arata? Seeing none, thank you very much for your time today, and it sounds like we'll be seeing you again.
Thank you.
I will now turn back to persons who have signed up to testify in favor of LD 1255, and I will next recognize Angela McWhinney. Ms. McWhinney, whenever you are comfortable testifying, just begin your testimony, and welcome to the Judiciary Committee.
Thank you. And thank you to the honorable members of the Committee on the Judiciary. Thank you for hearing my testimony today. I'm Angela McWhinney. I live in Brunswick, and I'm here to speak in support of LD 1255, an act to prohibit evictions until 90 days after the end of the governor's declaration of emergency. I want to just say that I live in Brunswick, but I also was born and grew up here. I spent a number of years living out of state and have returned to raise my children here in Maine. It's important to me to be here today to speak to you because I'm deeply concerned about the lives of my fellow Mainers. The deep economic impact of COVID-19 and the struggle that many Mainers are going through will not be over when the spread of the disease has slowed enough to lift the state of emergency. If what follows is a year of pandemic is a wave of evictions, 2021 might also be a brutal and painful year for family, friends, and neighbors. I've seen a wave of evictions, what it does to neighborhoods, and more importantly, what it does to people. When I was living in Portland, Oregon for a period of time during the recession, neighborhoods, including mine, were hit by waves of evictions. Valued friends and neighbors disappeared, seemingly sometimes overnight. Remembering clearly sitting in a hotel room with a couple who were evicted and crying because they were on oxygen and they had nowhere to go. And it took 3 years of working with families like that, trying to assist them, prevent evictions. And I learned 2 lessons there. We just put every measure in place to protect the right of people to shelter. When it comes to home, the voices and health and safety of family at shelters should matter. As a community, our first priority should be to the family's ability to remain in their home. The second lesson I learned was that we all wished we had started to put protections in place to keep people housed before the wave of evictions hit, not while it was rolling through our neighborhoods. We have an opportunity to support doing so right now with LD 1255. Preventing renters from falling into homelessness is about a commitment to strong and stable communities. Every health, mental health, economic, and social outcome improves when people have and maintain access to stable housing. LD 1255 does not prevent evictions of tenants who are destructive to property or present a danger to themselves or others. All it does is ensure that during this state of emergency and a little beyond, landlords do their part to keep a roof over tenants' head. I urge you to vote ought to pass, so that we leave this pandemic, we do not find ourselves in another wave of community loss through evictions.
Thank you very much for your time and testimony today, Ms. McWhinney. Are there questions from committee members for Ms. McWhinney? I am not seeing any electronic hands. I'm going to poke around to see if there are any real hands. And seeing none, again, thank you very much for taking the time to testify to the committee today. Greatly appreciate it. The next person on my list, I welcome to the committee, Catherine McGovern. Ms. McGovern, nice to see you again. Welcome to the Judiciary Committee, and begin testifying as soon as you're comfortable.
Thank you. Good morning, Representative Harnett and members of the Joint Standing Committee on the Judiciary. My name is Catherine McGovern, and I'm an attorney at Pine Tree Legal Assistance. Pine Tree provides free legal services to low-income Mainers, and we have offices all over the state. We represent tenants in eviction cases before the district courts throughout the state. And in 2020, we assisted low-income Mainers in 1,847 eviction cases. Pine Tree Legal Assistance supports LD 1255 because the federal eviction moratorium leaves many low-income Mainers vulnerable to eviction and homelessness during this global pandemic. As you've heard from others, evictions not only drive poverty, but during COVID, they also cause death. During COVID, we've seen that evictions can be a matter of life and death. Having a home is critical to one's ability to stay safe from an infection. And we've seen that with increased rates of eviction, there are increased infections and increased deaths. We've also heard some this morning about how the federal eviction moratorium has left large categories of tenants vulnerable to eviction. The federal eviction moratorium provided some important protections to tenants, but it leaves out many tenants, in particular those who don't know about the moratorium or how to invoke their rights under it, and those whose landlords issue notices of eviction for no reason. Tenancies at will and those who have leases who have ended can be evicted and named without a reason. and that type of eviction has increased since the federal eviction moratorium went into effect. The Maine Affordable Housing Coalition's report showed that in recent months, the number of no-cause eviction filings has increased. I believe many of those eviction filings are due to the fact that landlords would like to avoid the protections of the federal eviction moratorium. This winter, I represented a family with 2 small children who were being evicted after they fell behind on their rent. Their landlord served them with a notice to quit that listed 2 reasons. It was a non-payment notice as well as a combination no-cause notice. The tenant served the landlord with a CDC declaration, but the landlord continued to seek an eviction judgment. The family did apply for rental assistance and general assistance and was receiving that assistance. However, the court's opinion was that it didn't matter, that non-payment of rent was, to me, clearly the motivation for the issuance of the combination non-payment and no-cause eviction notice. And this judge's opinion was that the federal moratorium did not prevent this eviction. My clients asked me how this could be, where the stated purpose of the federal eviction moratorium was to protect tenants who lost income due to COVID and to keep families from having to double up or live in unsafe conditions in congregate shelters. Unfortunately, that is where this family ended up. And if I could address Representative Libby's question about the state of emergency. The declaration of emergency will be over when the public health crisis decreases, and having people be able to remain in their homes allows us to get to a time when the public health crisis will decrease. Thank you.
Thank you very much, Ms. McGovern, for your testimony and taking the time to present it to the Judiciary Committee today. Are there questions from committee members for Ms. McGovern? Seeing no virtual hands, I will just pop around. Seeing none, thank you very much for taking the time to testify before us today. The committee greatly appreciates your input. The next person that I have signed up to testify in support of LD 1225 is Samantha Heyman, and I hope I'm pronouncing your last name correctly. I think I got your first name okay.
Yes,
welcome to the Judiciary Committee, and please begin testifying when you feel comfortable.
Wonderful. Thank you so much. Good morning, Senator Carney, Representative Harnett, and the distinguished members of the Judiciary Committee. My name is Samantha Heyman. I'm a resident of Scarborough. I'm here on behalf of Maine Renters United, a tenant-led community organization working for the dignity, safety, stability, and affordability of rental housing in Southern Maine. I come before you today to speak in support of LD 1255. In the past harrowing year, 2 things in my life have nourished and sustained me more than any others: my home and my community. I know I'm not alone in this. In times of calm as well as crisis, home and community form pillars without which our lives would collapse. I'm here today because the eviction crisis poses an existential threat to both of those things. The devastating effects of eviction on communities are well documented. In 2016, Princeton sociologist Matthew Desmond wrote that quote, "Evictions fallout is severe. Losing a home sends families to shelters, abandoned houses, and the street. It invites depression and illness, compels families to moving into degrading housing in dangerous neighborhoods, uproots communities, and harms children," end quote. Make no mistake, no-cause evictions do not improve the quality of housing. They do not prevent violence, harassment, or disturbances in a building, all of which are covered by just cause eviction law. They grant a landlord carte blanche to evict a tenant for almost any purpose, whether it be to sell the building or to rent a unit to a friend. No-cause evictions serve only to displace people in the name of profit and convenience. Surely temporary delays in transfers of real estate do not take priority over the safety and welfare of good, law-abiding tenants during a pandemic. At Maine Renters United, we believe that housing is a human right. Throughout this pandemic, our homes have been the heart of our livelihoods, our health, and our well-being. To allow our homes to be stripped from us on a whim during this time of crisis is inexcusable. The people of Maine deserve much better. Full recovery is within our grasp, but only if we protect the people who attend our schools, walk our streets, and patronize our small businesses. I urge you to help defend my community by voting in favor of this bill. Thank you.
Thank you very much, Ms. Heyman, for your time in presenting testimony to the committee today. Are there questions from committee members for Ms. Heyman? Seeing none, again, thank you very much for taking the time to be with us today.
Thank you.
That is the last person that I have seen who registered to speak in favor of LD 1255, but I will check the attendee room just to make sure there is not anyone else who would like to testify in support of LD 1255. If you are here to do that, please raise your electronic hand and I will recognize you. And seeing none, I will now turn to those who have registered to testify in opposition to LD 1255. And I welcome back Daniel Bernier to the Judiciary Committee. Nice to see you again, sir. Begin testifying whenever you feel comfortable.
Good morning. Thank you for asking me, or thank you for letting me speak again. My name is Dan Bernier. I'm a resident of Waterville and I represent the Central Maine Apartment Owners Association. As this bill would create what in this crisis would have been at least an 18-month period, perhaps longer, where landlords would have to pay their mortgage, their taxes, their insurance, heating an apartment, while they could do nothing about a tenant who does not pay their rent. Landlords have bills to pay too, and they need to receive rent. Now, through this crisis, overwhelmingly tenants have paid rent. And if you look at the services that were available, whether it's all the efforts Maine State Housing made to help people, general relief, stimulus checks, there was really no good reason for not coming up with at least a large portion of your rent through this crisis. The program now is a little bit more effective than the one we had last fall, but I think I would encourage you to look at all the efforts Maine State Housing made to help people pay their rent. I would also point that through this, while most tenants have paid their rent, I've seen some of the largest arrearages run up. The worst case I've seen was one where by the time we got a tenant out, they owed $12,700 in rent. That tenant had never bothered to apply for any of the many government assistance programs that were available. Prior to the crisis, before you'd evict somebody, it used to be a $2,000 or $3,000 arrearage. Now arrearages generally run between $5,000 and $10,000, and most of them closer to $10,000. And that's based on Waterville area rents, Waterville, Skowhegan, Augusta. I'm sure in Southern Maine, where rents are much higher, it would go much longer. You're seeing landlords getting huge arrearages. And I would we're seeing some spites from some of the tenants, because I've also seen some serious destruction during this period by some of these tenants. Recent case I've had over towards Belfast, during the last 48 hours before they left, they moved their chickens into the house to destroy it after they'd run up over $10,000 in rent. It's simply taking, we talk about a housing shortage. This will create more of a housing shortage if you have to worry about going this long without receiving rent as a landlord. I guess I'll just leave it at that. I won't use my whole 3 minutes, and I'll be happy to take any questions.
Thank you very much, Mr. Bernier. Are there questions from committee members for Mr. Bernier? Representative Moriarty.
Thank you, Mr. Chair. Mr. Bernier, because you are familiar with the various statutory provisions, I've sort of saved this question for you. I don't completely understand the language of subsection 3 of the bill. I don't know if you have that before you.
Yes, I do.
Okay. The question, I guess, is, it appears that there are some circumstances during the state of emergency and 90 days thereafter in which a tenant at will can be evicted. But I don't understand the various statutory cross references. And I wonder if you can identify those circumstances in which an eviction can take place.
Well, understood. Subsection 1, sections A through F, sets forth the reasons which pre-COVID you could use a 7-day notice for eviction. So it's not all the reasons for an eviction, but it was the reasons for a 7-day notice. It excludes the one I mentioned in earlier testimony, section 6025. And so basically, what they're saying is you can't do it for C, which is failure to pay rent, but you could still do it for nuisance, damage, not being an authorized occupant. The drafting did worry me a little bit, because you see where it says D2F. I assume that means to include E, because E is violence. E is threatening violence against other tenants. And so those are the reasons for a 7-day notice. Now, what I suppose would concern me, are we eliminating 30-day notices altogether? Because a landlord in their lease can come up with reasons for a 30-day notice. the landlord can create as many reasons for a 30-day notice. I mean, there's some limitation on it, whereas only the legislature creates reasons for a 7-day notice. And that's the list of the reasons for 7-day notice. And so the intent is to eliminate C for failure to pay rent, is what I'm assuming. And I hope it's not the intent to eliminate E, which is violence.
Well, let's see. As I read it, these sections A through F remain as reasons for an eviction of a tenant at will during the emergency.
Well, they're saying A, B, and D to F. I think the intent is to eliminate C, but I agree with you, the drafting could be improved.
And what is C once again?
C is failure to pay rent.
Oh, I got it. Okay, okay.
Yeah.
All right.
So basically, there's 5 reasons for a 7-day notice in that statute, and it looks like they're trying to eliminate one of the 5.
It certainly does. Yes, it does. Yes, I agree. Thank you.
Thank you, Representative Moriarty. Are there other questions from committee members for Mr. Bernier? Seeing none, thank you very much for presenting your testimony on this bill this morning. We appreciate your being here. The next person that I have registered to testify in opposition is Elizabeth Frazier. If I could have Ms. Frazier moved in as a panelist, committee clerk, and here she is magically appearing. Welcome back to the Judiciary Committee, and please begin your testimony as soon as you feel comfortable.
Great, thank you. Thank you very much, Chairman Harnett and Chairman Carney and members of the Judiciary Committee. It's nice to see you again. My name is Elizabeth Frazier. I'm an attorney at Pierce Atwood, and I am before you once again on behalf of the Maine Real Estate and Development Association, which represents commercial real estate and development interests in Maine. You did hear from me earlier, and I won't sort of repeat some of the things I said about, the importance of having, when appropriate, forcible entering and detainer action available for landlords in cases where it is necessary and should always be the approach of last resort. I do want to echo that I think certainly we've heard from our members that by and large tenants have been able to make rent during COVID or work out some kind of agreement with their landlord. It's not actually something that we haven't heard from landlords screaming that they're just, plowed under with rents being behind. So we do think the availability of rental relief assistance is critically important. We understand there are really actually a lot of dollars available, but not necessarily being taken advantage of for one reason or another. And we certainly support efforts to educate both landlords and tenants about the money that is available, helping that get out the door. In the interest of saving the committee time, I'll just quickly say that we'll also be opposing LD 1296 for a lot of the same reasons. And I am submitting written testimony on both bills with slightly different reasons. So I would encourage you to look at that, but I won't come bother you on LD 1296. So I'll see you again later this morning, but happy to answer any questions if you have them.
Thank you very much, Ms. Frazier, and thank you for your brevity.
Thank you.
Are there questions from committee members for Ms. Frazier? Seeing none, thank you for Representative Moriarty.
Just under the wire. Thank you, Mr. Chair. Ms. Frazier, reference has been made to the rental relief program. Is that a state program?
So I'll caveat this by saying that I'm not very well versed. There are a few programs out there, and my understanding is there is one under Maine State Housing. Now, I'm not sure if that's funded in full by state of Maine on its own through COVID CARES money, or if it's coming directly from federal funding. I think there are both funds coming into the program, and it basically all lives within Maine State Housing now. But I think Maine State Housing is testifying either on this bill or on a later bill, and I know they're going to talk about their rental relief program, so they may have more information on that as well.
All right, the quick follow-up is, any reason why a landlord couldn't apply for the relief?
My understanding, and again, I'm not an expert, but I believe that the way the program is structured currently, or at least was during sort of the height of the pandemic, required tenants to also apply. And I'm not sure I think the rationale was that, you know, it makes sense on the face of it, have the landlord and tenant co-apply so that everyone knows what the terms of the agreement is and what, you know, what the benefit is to both parties. But as a practical matter, I think it's been difficult in some cases to get tenants to sign on or to submit their application. So it's sort of clunky, I guess, you know, in some ways. And that has resulted in some difficulties, I think, with getting the money to people who need it, landlords and tenants.
Yep. Thank you.
Thank you, Representative Moriarty, and thank you for the answer. Representative Lookner, I keep seeing your hand go up and down, and I'm not sure why. Are you?
Thank you, Mr. Chair. I could speak to Representative Moriarty's questions if that's okay.
You mean as to the funding mechanism? If you could briefly do that, that's fine.
Yeah, so it is all funded federally, and the federal, it is stipulated through the federal program that tenants apply and not landlords. So there was a bill to make this a state program that was heard in Labor and Housing yesterday, and those questions were answered. But yeah, it has to be a tenant. A landlord cannot apply. So thank you, Representative Moriarty, and thank you, Mr. Chair.
Thank you, Representative.
Thank you.
Before we let Ms. Frazier go, are there additional questions from committee members? Representative Libby. You're muted, Representative.
Thank you, Mr. Chair. It's actually more for Representative Lookner if he's back for a moment than for Ms. Frazier. It was regarding the funding issue. I apologize if the question's been answered as well. My Zoom quit on me and it took me some time to get back in.
You can go ahead.
Thank you. So the question of funding has been an ongoing question for me. Given that tenants have to apply and not landlords, what is the recourse for landlords currently if the tenant does refuse, as some have to apply for the funding? How are landlords supposed to pay their bills if they have a tenant who not only is not paying the rent, but is refusing to apply for the assistance program?
Representative Libby, thank you for the question. And that bill was heard in Labor and Housing yesterday. I forget the LD number, but there was a bill that would permit landlords to apply for this assistance. But it is federally stipulated in the CARES Act funding and the American Rescue package that was just passed that all this money is coming from, that main housing is administered, that only tenants can apply and landlords cannot apply independently of tenants.
So follow up, Mr. Chair?
Yes.
So then the short answer is there is no recourse for a landlord whose tenant refuses to apply. Is that correct?
You know, there may be some other provision, but I think that should be left. I think I see Mr. Jorgensen there to answer any your questions. I think would be better left for him.
Thank you. And just a follow up for the work session. I'm not sure this other bill, I'm not sure of the LD number, but this other bill that was heard in another committee, it'd be nice to know if that is a bill that has the same emergency preamble that this bill does, because it really doesn't have any bearing, even if it passed, if it doesn't have the emergency preamble. Thank you.
Okay, thanks.
Thank you, Representative Libby, Representative Lookner. And I did see the mention in the chat from former colleague Eric Jorgensen. I'm going to ask that Representative Jorgensen be available for the work session to discuss the mechanics of the federal funding under the Relief Act, because we just have quite a few people to testify today on a variety of bills. That is all I had signed up for. Persons wanted to speak in opposition to LD 1255. If there is anybody in the attendee room who wishes to be heard in opposition, please raise your electronic hand. And seeing none, I will now turn to those who wish to testify neither for nor against. And in that category, I have Kaylee Moore. Ms. Moore, welcome to the Judiciary Committee. I see you brought an audience with you. Thank you.
I pre-apologize and thank you for bearing with me as I don't have childcare today. So hopefully he'll behave for the 3 minutes.
This is life. And
Yeah.
to defend you, as soon as you get to 3 minutes, I will let you know. But begin
Okay.
testifying whenever you're comfortable.
All right. Thank you for allowing me to speak today. My name is Kaylee Moore, and my husband and I have a small property management company here in Portland. I'm also on the board of the Southern Maine Landlord Association. I'm here today to speak to some concerns I have about the bill and maybe offer some other perspectives. As a former social worker, I have definitely seen firsthand the devastating consequences of homelessness, and I very much agree it's a problem that we're facing within our community right now. I also know that as a property owner myself and someone who takes care of buildings for smaller landlords and owners, this bill can have some serious consequences. Throughout the pandemic, my husband and I, like many landlords, have worked very hard to accommodate those who are struggling to pay their rent. I regularly send out information to tenants about rent relief. I will fill out any form or do any inspection that's needed so that our tenants can qualify for the extra help when they need it, because there is quite a bit of help out there. Despite this, there have been many tenants who have fallen behind and struggled to pay. Luckily, we've been able so far to cover the gaps that exist by their non-payment, at times of upwards of over $7,000 just for one apartment. As the pandemic goes on, this will not be the case. Certainly, there are larger landlords with deep pockets who can cover the difference and ride out the storm. Most landlords, however, are smaller. They may have 1 or 2 buildings they purchased as part of their retirement plan. They are struggling too and simply don't have the extra money to continue to pay the bills while not receiving income for the building. Having to then wait another 3 months after the pandemic has been declared over will only continue to put pressure on property owners to cover these deficiencies before the process to remove a tenant can even begin. We prioritize the safety in our buildings. We work very hard to make sure our tenants have clean, safe spaces to live. I'm worried if owners are put in these challenging financial situations, they'll have to prioritize their fixed costs such as utilities, mortgage, taxes, and whatnot. And there will not be the funds left over to maintain the building and ensure tenants continue to live in safe, nice places. In summary, I would consider myself very successful if I can make it through my career without having to complete an eviction on a tenant. It truly is a last resort to me that I avoid at all costs. I also know we currently have a procedure in place regarding evictions during a pandemic, which seems to be working with regards to protecting tenants from eviction due to non-payment. It does not seem that extending the procedure after the emergency has been declared will help, and it will continue to cause harm to the smaller landlords who are struggling to get by. So thank you very much for your time.
Thank you very much, and excellent child wrestling skills on display for the
Thank you.
Are there any questions from committee members for Ms. Moore? Seeing none, thank you very much for taking time out of your obviously very busy day to come before us. We greatly appreciate it.
Thank you all.
You're very welcome. I'm going to turn to the attendee room one more time to see if there are any persons wishing to speak neither for nor against on LD 1255. And seeing none and having heard from all those present who wish to testify, I will now declare the public hearing on LD 1255 over. And we will move on to our next public hearing. And our next public hearing is on LD 1296, which is an act to guarantee housing rights during a state of civil emergency. And it is an emergency bill. And I would welcome the bill sponsor, Representative Ben Collins. Nice to see you, Representative.
Thank you, Representative Arnett. Good morning to you and to Senator Carney and to all the distinguished members of the Judiciary Committee. I'm Benjamin Collins. I represent House District 42, part of the city of Portland. I know you've probably been hearing bills dealing with emergency bills dealing with housing today, and I'll try to be as quick as possible. So basically, when we sort of started this shutdown, when the pandemic started raging over a year ago today, when the state, Maine, officially shut down the legislature and the governor declared a state of emergency around St. Patrick's Day of 2020. From that point till today, I've been advocating to the executive branch, to the legislative branch, and many others that we do all that we possibly can to keep people housed and safe during a deadly pandemic, where not being in a safe shelter could cause exposure to others, and could be quite detrimental, obviously, during a deadly pandemic, when being in close proximity with others isn't a good idea. So basically, it's very simple what the bill tries to do. There's two components of it. The first part would be, which in essence, what we've had through action of at the federal level through the CDC, we have currently a moratorium on rental evictions. And to some extent, there's been assistance for mortgages for homeowners as well. So that's what it does. And the second part would, just as with eviction moratorium, it would have the same for utilities. They wouldn't be shutoffs of utilities during a state of emergency, a civil emergency. Now, obviously, I'm not anticipating something to the extent of COVID-19 anytime soon. I don't want anything like this, but I think it's wise to plan and to be pragmatic. And just like several years ago, when we had a huge ice storm, many people prepared in the future for another ice storm. So if it happened again to that extent, people's homes and properties would be protected. And so it's that simple. And I would have to say I will send to the committee the list, to the best of my knowledge from my research, and I'll double check it once again. But there are many states that have declared eviction moratoriums that may have ended. Some have different conditions. Some are more unconditional. Some are still into effect today, all over the country. And to some extent, not as many listed as states with eviction moratoriums, but there are many states that do have also a ban on utility shutoffs. Now, what I do want to say is, again, that this is only in a state of emergency. It's not for any other time. So if people have an issue with that being an ongoing law, it's not. It's only for a state of emergency. So I want to be very clear on that. And it's not my intent to allow this to apply to issues like dangerous activity in a house, crimes, drug dealing, any risky behavior, any severe damage to property. That's not what I'm talking about. I'm talking about removing people that are abiding by rules and laws. And as far as the utilities go, I understand, and I think it's unfortunate, but with utilities, I know in many cases to get assistance from different agencies, you actually need to have a shutoff notice, and then that triggers getting help, which I think is it's unfortunate that you have to be at that level to get that assistance. But I'm more than willing to work on the bill to make it that there's still some mechanism for people to get help in light of the current situation, where you need to actually have a disconnect notice in order to get assistance. So that's my bill. Thank you for hearing it. I know you've have many hours of hearing similar pieces of legislation, so I won't take up any more of your time. I'd be happy to answer any questions and continue to discuss this with you into the work session. Thank you.
Thank you very much, Representative Collins, and thank you for bringing the bill forward. I will now turn to questions from committee members, beginning with Representative Reckitt. And so you can rest your arm. Representative Libby, you will be next. Representative Galgay-Reckitt.
Thank you. Representative Collins, I have a question about the utility piece of this. Could you tell me whether or not the PUC is in, I'm trying to find the words now in in the bill talks about the utilities that are covered by the PUC. Are there utilities that are not covered by the PUC, which might also impact a tenant? I mean, I don't know whether the PUC controls natural gas, for instance, or oil, or do you know who does the PUC control? I should know this after 5 years in the legislature, but I don't. So if you would tell me, I'd appreciate it.
I'm not 100% sure. I hope someone will answer this after me. I believe that they do, for example, for regulate entities within Maine, such as Central Maine Power, other electrical utility companies. I believe they have some jurisdiction over water as well. I do know for a fact that I wanted to put in the bill internet, cable or internet, because so many people throughout the state for work, and specifically for the children that couldn't be in school in person, that had to be on the internet, or they couldn't do the remote learning. I wanted that, but that was, I believe, to be, I think, if not solely, primarily regulated at the federal level. And so because of that, I didn't include that in my legislation. So for sure, though, that this would be electrical utilities, water utilities. As far as gas and oil, I think the PUC may have something there, but I'm not. That's one area I'm not 100% sure. Someone might be able to answer that after me, but if not, I will clarify that and get that to you after this public hearing.
Thank you.
And Representative Reckett, I would just point out there has been testimony submitted by the PUC and also by some water utilities as well. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Representative Collings. I certainly appreciate the noble intent of this bill, but I would ask lines 14 through 17, not being allowed to remove a tenant for failure to pay rent. Heaven forbid we ever have another scenario where we have a state of emergency for 14 months. But if a tenant in a future state of emergency did not pay their rent for months at a time, there's no way of knowing if we'd have any kind of rent relief available in a future emergency. So given that scenario, what would the recourse be that you would suggest for a landlord who is not receiving rent during a state of emergency, but still has bills to pay, including the mortgage and any utilities on that building, to be able to meet their needs so that they can then provide for not just one tenant, but all of their tenants?
Thank you, Representative Libby. And my internet, I think I'm on too many different Zooms and windows at the same time, but I can hear all of you. I can't see you, like all your windows went away. So I can hear you though. So I hope you can at least hear me and see me. But so yeah, my intent was just to prepare in the unlikely and unfortunate situation where this could happen again, that instead of having to we kind of do something and then wait, and then an emergency is extended, and then certain things we don't do, we rely on the federal government. My intent was to do like a great number of states, and was to have the state take the lead on this, just to keep people safe. My intent, if it's Representative Libby, if it's not, it may not be written technically in this bill, but I would have it changed to reflect that I in no way would take away the liability of someone. And just like as in this current federal moratorium on evictions, and even before these recent extensions on the CDC extending the moratoriums, when the state just wasn't having court hearings on evictions, it was still very clear that a tenant still was liable for any past due rent. So in this bill, I'm in no way trying to absolve someone of that. I understand, especially smaller landlords need to pay bills, and it's a great burden for them as well. So I would want it to be clear, and I could work on changing this language to reflect so that tenants still would be liable for their rent. It wouldn't just disappear, and the landlord would take that loss. And a tenant could not stay, of course, if they're doing something illegal. So I hope that satisfies most of what you're asking. And I agree with you. I don't want to hurt tenants. I don't want to hurt landlords. I want to keep people safe and do so in a fair way, and not wipe away someone's debt owed. I want them to be liable for that, and I want people to be made whole.
Sure. Thank you so much, Representative. A follow-up, if I could, Mr. Chair. I think that was a yes.
That was a yes, Representative.
Thank you so much, Mr. Chair. I guess my follow-up would be then, I do understand that intent with the bill, Representative Collings. So I wonder if, given that we wouldn't know prior to another state of emergency, if there would be federal assistance, if you would want to have something in the bill that would make an allowance for the state to cover, the state to be on the hook for that rent if a tenant was not able to pay and there was not federal assistance, so that the landlords would not then be left in the lurch and unable to pay their bills and keep their tenants safe. So does that fit with your intent of the bill? That way everyone gets paid and there's assistance for those that need assistance? I think Representative Collings may be frozen.
I think that you are right. Representative Collings, can you hear us? I think we may have to wait for the response to your question, Representative Libby. As soon as Representative Collings is back, I will have you posted again.
Thank you.
In order to
I'm sorry,
there you go. He's back. Representative Collings, can you hear us?
Okay, now I can. I'm having issues, so I turned off my video, and I did get frozen out for about 30 seconds. And when I came back in, I heard Representative Libby asking me about maybe some state assistance to cover in this scenario. I don't have any language like that. I don't foresee anything like this happening in the near future. I don't want to, but I don't want to put conditions like that, because I just think there would be no way to accurately depict what may happen in the future and what might be available from state and federal assistance. But my intent is clear that I do want, like I think almost about half the states at least have done, is to have a moratorium on the evictions and include the utilities. And if there is assistance, that would have to be determined at a future date. But it is my clear intent, I can say this, is that I'm not saying that someone should not be liable for rent owed. That would, just like currently today, right now, someone can get assistance. There's ways to get assistance through rent relief, through the federal program that's funneled to the states. If someone doesn't, they're still liable for paying their rent. And I would make it so in any future scenario of an emergency. So, and I don't know if you can hear me at all anymore, but
we can, Representative Collings. Thank you for that response. Representative Thorne.
Thank you, Mr. Chair. Representative Collins, I look at this and I read it and I think to myself that what it does is it goes halfway to solving or preventing a problem. And the halfway point is that tenants aren't responsible for anything that they could be terminated for involving state of emergency. But it doesn't say where to go forward with that after to resolve the tenant landlord disparity. Could you address that a little?
Sure. Can you hear me now, Representative Thorne?
Yes.
Okay, yeah, because I'm sorry, I keep going in and out. I don't know what's going on. My Wi-Fi is very strong, but for some reason I keep getting frozen out. And I hope before, maybe I was cut off when I was speaking before. If probably my bill doesn't technically say this, I would change it for the work session, that a tenant is liable for the rent, just as they are now. I'm not trying to take away that liability of payment. And in the future, if we are in a state of emergency, whether or not there's federal or state assistance, just like has been the case now, someone is still liable for their payments. So I don't want to take that away, that liability. So I can change that, but yes, I do recognize that. And as is the case today, people still are reliable for any back payments owed. I would like to have it that way. And this just addresses it being automatic and doing what about half the states around the country already do, and not just relying on the federal government to, through their own acts, through the CDC, extend these orders. So yes, I would remedy that, and I would make sure that technically it would state that for the work session. So thank you.
Right, and if I can ask a follow-up question, Mr. Chair?
Yes, Representative Thorne.
Thank you. I just curious what that would look like, and it seems to be omitted in this. We have the cause, we have the effect, but the remedy is non-existent.
Yes, I would, if the committee would so entertain my desire to do so, I would have a very simple language added that would make this consistent with what is the current situation, where someone can get assistance if they choose to, whether they do or not. The fact being is that a state of emergency hasn't taken away the obligation of a renter to pay it. And if they were to walk out of the place they rented tomorrow and owe 2 months of rent, they would still be liable for that, and there'd be a process through the legal system to deal with that. And I would make sure that the bill's language would so reflect that. And I will advise after this hearing those who can help me to put that technical language in, do so. So it touches to that sentiment that you're getting at and that I agree with.
Right, and that's why I say every state of emergency may not have the same funding and the same situation as we're currently in, and may not allow for that to happen.
Yes, we could discuss theoretically what may happen. I agree, and that I don't want to do that for your sake or the committee's sake. But what I would say is that regardless of what may happen in the future, the intent I want in this bill very clearly is to have people protected, but to be liability included and for fairness. And so with that in mind, regardless if there would be any assistance provided, someone still would be liable for their rent. And I do, as well as I mentioned before, I do want it to reflect that this would exclude circumstances where someone is doing serious harm to the building or to others. So for criminal or other issues, they would be able to be removed. So that also is what I want to be clearly in this bill in its final version. Thank you.
Thank you.
And might I suggest for the committee, so we can move on, that it seems that the sponsor has talked about bringing amended language to a work session. Why don't we get it to the committee in advance of the work session, but we're not going to get it right here today. So with that, are there additional questions for the bill sponsor from members of the committee? Seeing none, thank you very much, Representative Collins, for bringing this bill forward and battling through the technological challenges today.
Well, they let me out of Fort Kent, and I'm doing the best I can to figure out computers. Thank you.
Very welcome. Before turning to persons who are testifying in opposition to LD 1296, I would ask if there are any persons in attendance, because none have so registered, who wish to testify in support of LD 1296. And seeing none, I will now turn to those who have registered to testify in opposition, and I welcome back Representative Arata. Nice to see you again. Proceed when you're ready to go.
Thank you, Representative Harnett and members of the Judiciary Committee. So my testimony in opposition to this bill is very similar to my opposition to the previous two bills. Please note that the rent relief program, you can find information at mainhousing.org, and that program actually pays for utilities as well. So that's a big help. This bill, you know, during an emergency order, the courts are usually shut down anyway, so there's really not a need for this bill. I mean, if we get attacked by nukes, we're not going to go to court. You know, we're other things to worry about. Also, you know, if the landlords aren't getting paid any rent, there's no incentive for the tenants to pay rent, so they don't pay rent. Then a lot of buildings are on oil, and in the winter, you know, oil's not something you either shut off or turn on. You know, the landlord pays to have it delivered, gets delivered, and then the tenants have heat. So that could be very disruptive if the tenants aren't paying their rent. We still have the problem where, you know, you have emergency and you have the shutdown order, stay-at-home order, and good, quiet tenants are stuck in a home with a tenant who's, you know, threatening or just keeping them up all night, smoking, doing things that make their lives miserable. This bill protects the tenants who make others' lives miserable and not the good tenants who we all want to keep. You know, so those tenants, in order to evict the tenant causing problems, those tenants would have to be willing to go to court and testify themselves, because anything that I say is just hearsay. And a lot of them are afraid to do that, especially when during a pandemic, they don't always want to go out in public. Again, and if the tenant doesn't pay rent and they owe a lot of back rent, my remedy would be to go to small claims court. And then I have to get a judgment. That's a whole big, long process in itself. But then the tenant doesn't have anything collectible. They don't own a home. So I can't put a lien on their home to force them to pay once they sell the home. So that's just rent that's never going to be collected. And it's going to, in this situation, it really increases the likelihood of a landlord having to be foreclosed on, not being able to maintain the building and things like that. Also, the governor does have the ability during a state of emergency to issue executive orders to prevent evictions and utility shutoffs, which she did do. I can't find the exact number of the executive order, but she did do that, and that was effective. So, you know, at the end of the day, I get to go home to a safe, quiet home, but my tenants, my good tenants, have to stay in the apartment, possibly with a tenant who's a neighbor and banging on the walls and threatening them. And that's just not fair. So do you guys have any questions for me?
Thank you very much. Thank you, Representative Arata. Are there any questions from committee members for Representative Arata? Representative Moriarty.
Thank you, Mr. Chair. I have a question for my neighbor to the north, Representative Arata. As I read this language, it only prohibits an eviction action for the failure to pay rent, but not for threatening, damaging, disruptive behavior. Have I overlooked something?
Yes, it does prohibit the no cause evictions. Remember the no cause evictions where I have a tenant who's upset that she and her family are being treated poorly by a neighbor.
Yep.
And I have to do a no cause eviction because she's afraid to go to court and testify against this person and then be stuck living next to this person for several more weeks after the court date. I sometimes tenants will give me complaints, and I will issue warnings, right? I always issue warnings to people that, turn off your music in the middle of the night. Don't blare it at 2 a.m. And they usually do what I tell them in that case, but because they know I could evict them. So when I do that, I will have a no cause eviction because I don't want to tell the tenant who complained about them, because they have to live next to each other. I don't want battles going on in the building. When you have multiple families, usually multiple families are affected by one bad tenant too. And, and I hate that I'm here all morning and you must think that I'm this terrible person who does a lot of evictions. I don't do many evictions. I've only had one eviction in 14 years that went all the way to the sheriff escorting the person out. So it's really rare to have evictions, but it's a tool that we need to have because just some people are just very difficult to live near.
Understood. Thank you.
Thank you, Representative Moriarty. Representative Thorne.
Thank you, Mr. Chair. Welcome again, Representative Arata.
Thank you.
My question to you is, you said you evicted one person in 14 years of being a landlord.
One went all the way to the end of the process.
Okay.
So yeah, usually we can come to an agreement partway through the process. It's a long process.
And I wonder if the same thing could be true of the conditions surrounding this bill. If it does it go too far? Does it? I think about so many things. If the state of civil emergency gets numbed down in the future, so that every time we turn around, somebody has a COVID outbreak, we could declare a state of emergency, and this all kicks in again. Or if there's some other illness or some other condition that happens where a civil state of emergency happens, that like everything, no good deed goes unpunished, that there would be those that took advantage of this. Do you foresee any of that possibly?
Yes, in talking to other landlords, they have seen people take advantage of it. We have a rental relief program that's very easy to use. I've used it a couple times. I've helped my tenants use it. But some tenants they just will not do it. Maybe they're waiting to get payments because some landlords will pay tenants to leave rather than go through the entire eviction process. So certainly this pandemic has proven that some people will do that. I know one landlord who said that his tenants took their stimulus payment and bought a camper and refused to pay the rent, refused to leave. They have the camper electricity connected to the house with electricity, which the landlord has to pay. And they won't participate in the rent relief program. And that landlord has no recourse. It stinks.
Thank you.
Thank you, Representative Thorne. Are there additional questions from the committee for Representative Arata? Seeing none, thank you very much for taking the time to testify again. And maybe we'll see you in the future.
Okay, thank you. Bye.
I would now turn to Mr. Bernier. Welcome back, sir.
Good afternoon. My name is Dan Bernier. I represent the Central Maine Apartment Owners Association. I won't repeat what I said at 12:55, but I would add, if you look at the CDC declaration that tenants have to sign to qualify for the current moratorium, it puts a burden on the tenant for some things they have to do to qualify for the moratorium. There's like 5 things they have to do. The most important one was they had to apply for government assistance. In my practice, across the board, the people we're evicting for failure to pay rent did not apply for any government assistance. they're also pretty good about admitting it. I've always worried on the stand if one of them said they did and they didn't, how I would prove they didn't. But they get on the stand, they're at mediation, they just admit they didn't. And most of them too will tell you they didn't apply because they heard there was an eviction moratorium. So this type of a ban encourages people not to seek out the government assistance. Maine State Housing went above and beyond the call of duty throughout this crisis to try to reach out to tenants and landlords to get people to apply for government assistance. I think overwhelmingly tenants either paid their rent or reached out to the government assistance. But I would encourage you to look at the CDC declaration, which did not put 100% of the burden on the landlord. It put some burden on the tenant to take some reasonable actions. They also had to talk to their landlord. If they could pay partial rent, they had to do that. But the biggest one is they had to apply for the government assistance programs, which are very generous through this. This would create, under this bill, it'd be about a 14-month period where a landlord gets no rent, but has to pay their mortgage, the heat, the place, taxes, insurance. It's been a long day already for you, I realize, so I'll leave it there and be happy to take any questions.
Thank you very much, Mr. Bernier. Are there questions for Mr. Bernier? Seeing none, thank you again for your testimony and time today. I would next call on Deborah Hart. Welcome, Ms. Hart, to the Judiciary Committee. It's nice to see a new face.
Well, I've sort of been with you all morning.
We haven't seen you, though.
I know. I've learned a lot about rent control, or about rent payments.
As soon as you're comfortable, begin your testimony and I'll start the clock.
Yes, Representative Harnett, Senator Carney, and members of the Joint Standing Committee on Judiciary. My name is Deborah Hart. I'm a resident of Manchester, Maine. I own Hart Public Policy, and I'm speaking to you today on behalf of my client, the Dirigo Electric Cooperative Companies. These are Maine's consumer-owned utilities, and they include, in case you don't know, Van Buren Light and Power, Holton Water Company, Eastern Maine Electric Company, Fox Island Electric, Kennebunk Power and Light, and Madison Electric Works. The history of these companies go back a number of years. They were all formed to serve unserved or underserved areas of the state. They all have board of directors elected from their customers, and all of their decisions are made locally. I won't read my testimony because most of my testimony is really based only on the prohibition that you cannot turn somebody's electricity off during a period of a civil state of emergency. Right now, for your edification, if you don't know it, our utility cannot disconnect your service between November 15th and April 15th. They also have to offer regular payment arrangements, special payment arrangements, and there are exceptions for medical emergency when the lack of utility service would pose a serious risk to an individual. I think if you look at the PUC's testimony, they can tell you exactly what you can and cannot do in a time of disconnect. My clients feel that the whole disconnect process of sending somebody a letter is not to threaten them, it's actually to give them a heads up. A lot of times people will ignore a bill that doesn't serve them very well, and it also doesn't give the utility the advantage of being able to take that customer and give them the information that they need, such as LIHEAP funds. They actually have to get a disconnect notice before you can go through that process. And I think your sponsor actually mentioned that. I did want to just briefly tell you that I think it was Representative Reckitt that asked who was under PUC jurisdiction, and that is all electric utilities, consumer owned, the ones that I represent, together with the investor owns, which is CMP and Versant. They also regulate gas utilities, water, telephone. They do not regulate home heating oil. I will conclude my testimony there and be happy to answer any questions if you have any.
Thank you very much, Ms. Hart, for taking the time to testify before the committee today. Are there questions from committee members for Ms. Hart? Seeing none, thank you for sticking it out with us all morning and into the afternoon. We greatly appreciate your time.
Thank you for your time.
The next person that I have signed to testify is Matt Layton. Welcome back, Mr. Layton. Whenever you are comfortable, begin testifying. You're on mute right now. We can't hear you.
My apologies. Thank you, Representative Harnett, for welcoming me back this morning and the other members of the Judiciary Committee. Here, I'm a resident of South Portland, representing the Southern Maine Landlord Association. And we are opposed to this bill on the broad scope of its language, and believe that it needs to be redrafted and rethought. We have a large state. There's been a lot of talk of uncertainty of future states of emergency, and there's so much that is unknown about those future states of emergency. In fact, we don't know what they will be at all. So we believe that we support maintaining the governor's power to declare these states of emergency, and what might affect certain parts of the state may not affect other parts of the state, depending on the nature of the issue at hand. With that, it's been a long morning. I will leave it there. Thank you for your time.
Thank you very much, Mr. Layton. Are there questions from the committee, any committee members for Mr. Layton? Seeing none, we greatly appreciate your time in testifying on multiple bills this morning into the afternoon. Thank you, sir.
Thank you.
I am now going to call on the last person that I have registered as testifying in opposition to LD 1296, and I welcome Roger Kraus to the Judiciary Committee. And Mr. Kraus, whenever you are ready, begin your testimony. Thank you for being here.
Great. Thank you so much, Representative Harnett and Senator Carney and members of the Committee on Judiciary. My name is Roger Kraus. I'm the General Manager of the Kennebec Water District in Waterville and a resident of the town of Winslow. I'm here to offer testimony in opposition to LD 1296 as it relates to public utilities in behalf of the Maine Water Utilities Association. Maine Water Utilities Association is a nonprofit association that represents 109 water utilities in the state of Maine. We were formed in 1925. I've submitted written testimony, and I'll just highlight a few points of concern that we have in regards to this bill. Under Section 2 of the bill, a public utility in Maine would be prohibited from disconnecting a residential customer during a dedicated state of emergency. This would include water utilities as well as phone, gas, and electric utilities. In 2020, as a result of the pandemic and state of emergency, the Maine Public Utilities Commission issued a moratorium on utility disconnections. This was done under existing statutory authority. Therefore, it appears that this proposed language may be unnecessary. Not all emergencies are the same. The last pandemic was over 100 years ago, but we regularly have natural disasters in Maine with some frequency that have short-term duration and limited in geographic scope. It's unclear how this bill would relate to state of emergency in one county and how that would affect the ability to disconnect customers in a different county. The Kennebec Water District specifically serves 5 communities in 2 different counties. We serve 4 communities in Kennebec County and 1 in Somerset County. So it's unclear how this would be worked in effect if there was some kind of a state of emergency in one county and not in the other. Under current Maine law, disconnections are governed by the Maine Public Utilities Commission, and it's heavily regulated. It's a very detailed process and many steps in the process to disconnect somebody. Although water utilities have authority to disconnect services, very few actual disconnections occur. Kennebec Water District has approximately 9,000 customers and issued an average of 600 disconnection notices monthly to delinquent customers. All but a handful of these notices are resolved before disconnections occur. The disconnection process is far more about keeping customers current on their water bills rather than actual disconnections. In 2020, with the disconnection, with the moratorium on the disconnection process, resulted in a number of customers being in arrears with us that we were not able to disconnect. Historically, our 90 days in arrear number is around 200 customers. But just before the moratorium was lifted in November, we had around 900 customers who were 90 days or more in arrears. However, after the moratorium,
I'm sorry to interrupt you, but we do have a 3-minute limit, and I'd let you go over a bit. So if you could wrap up.
Okay. Well, we
have questions as
when
well.
we reissued start reissuing disconnections starting in November, our disconnection rate did not increase as a result of that. So even though there was more people in arrears, we did not do more disconnections. We're opposed to this broad language. We feel like there's a sufficient regulatory language in place now for PUC to issue moratoriums as needed. And I'm happy to answer any questions.
Thank you very much, Mr. Kraus. Appreciate your time and testimony today. Representative Thorne.
Thank you, Mr. Chair. Mr. Kraus, you kind of touched on something, and I'm curious if you could just elaborate a little bit on it. When you said that it's possible that a state of civil emergency may exist across the state, but not necessarily apply to everybody. And there's many different declarations that the governor could place. I look back on the ice storm back in '98 when it was I think it was declared a state of emergency or a disaster area. I'm not sure what the declaration was, but obviously that just involved a small swath across central Maine, didn't necessarily apply to northern Maine or to southern Maine. So again, the blanket provisions would apply to everybody, even though not everybody is affected. Could you talk a little bit about that, about how you see that affecting this?
Yeah, well, I guess I would say that in Maine, there are 150 plus public water utilities. And so we happen to serve 5 communities. Many utilities serve just 1 community. So if there is a state of emergency applied statewide or geographically, how do you apply that appropriately only to the geographic areas that are affected? If there's no impact on utilities in Aroostook County, what is the purpose of having a moratorium on disconnections in Aroostook County if the affected areas are more than southern Maine? So we certainly have that concern, and how that would be administered within this statutory language is unclear.
And your concern is that it doesn't specifically address that, therefore it's a blanket coverage that applies to everyone.
Right. I mean, I think the pandemic, I don't think. The pandemic is a pretty unusual state of emergency. And we have lots of other states of emergency that arise because of mostly natural disasters, weather events and such. And so, it's still a state of emergency, and those declarations are important to get funding into the communities that need those. But, how would that be administered with 150 water utilities and many other types of public utilities out there as well, electric included in that?
All right. Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne, and thank you for your answer, Mr. Kraus. Are there additional questions for Mr. Kraus? Seeing none, thank you very much again for taking the time to testify and for your submission of written testimony. I will turn now again to the attendee room. That's all of the persons that I had registered to testify on LD 1296. And I would ask if there's, I do see a hand up in the attendee room. Committee Clerk Panette, if I could have Mr. Sawyer moved over to testify, I would appreciate that. Welcome, Mr. Sawyer. Are you testifying? In what capacity are you testifying?
Thank you. I'm testifying in opposition on behalf of the Maine Rural Water Association.
Okay, go ahead, sir. I'll start the 3-minute clock when you begin to speak. Welcome to our committee.
Thank you very much, Representative, and to Senator Carney and Representative Harnett and members of the committee. My name is Brad Sawyer. I am the Director of Government Affairs for the Maine Rural Water Association and a resident of Augusta, just up the road from you, sir. I was not planning on testifying this morning. I was on a lengthy call, but upon hearing how long your morning has been, I decided I could get words in, but won't take too much time. There's just two things I'd like to say. One was touched on by Mr. Kraus and Ms. Hart. Of the vast majority of our members are referred to as utilities, regulated by the Public Utility Commission. That label has grown somewhat of a negative connotation in recent years. And so I'd just like to add to this conversation that most of our utilities and almost all of the public drinking water utilities are municipal or quasi-municipal. They are not out to make a buck. They are locally controlled. And so while they're referred to the same as some others, we're very different utilities in that way. The other thing I'd like to mention is in the order issued by the PUC that ended the disconnection moratorium on they issued it on September 17th last year, docket number 2020-00081. They stated, and I quote, "While the moratorium is in effect, any customer, regardless of means, could stop paying their water, natural gas, and electric bill without near-term consequences. While one might say this is a benefit to customers, that view is short-sighted. Not keeping up with monthly or quarterly utility bills means that those bills accumulate, leading to growing arrearages or debt the customer owes. There is no structure in place to forgive this debt and yet remain a customer. The larger the amount owed, the more difficult it becomes to pay. This is not in the customer's interest." They go on to say, "Meanwhile, despite lower revenues from fewer customers paying their bills, utilities are required to continue offering the same level of utility service, not to mention the incremental costs some are incurring to protect their employees and customers from the virus." End quote. So certainly all states of emergencies are different. We all hope we never see one like this again, but we don't know that. And as Mr. Kraus mentioned, this disconnection moratorium was actually issued the day before the last day of the legislature, when a bill was passed that expanded upon what should happen during this pandemic. And so the PUC already has this authority. We believe that's sufficient. They're thoughtful in their use of it. And we would respectfully urge you to vote ought not to pass on this legislation. Thank you. Happy to answer any questions.
Thank you very much. It was 3 minutes on the nose. Thank you very much, Mr. Sawyer. Are there questions from committee members for Mr. Sawyer? Seeing none, I thank you very much for your testimony.
Thank you.
And I would ask one last time with a little trepidation on my part, is there anybody else in the attendee room who would like to speak? Seeing none, I want to thank all those who testified on our bills this morning. And at this point, having received testimony of those present today, I will close the public hearing on LD 1296. And I wanted to inform the committee and the public how we will proceed. We have 2 more public hearings scheduled. They were scheduled for this morning, LD 1508 and LD 1380. However, committee members and members of the public have been here for over 3.5 hours, which means our committee clerk and analyst have been here over 3.5 hours, and I don't want to torture them anymore at this point. So we will take a break. We will come back at 1:10 and we will start immediately at 1:10 as long as we have a quorum. So I encourage committee members to please get back a little before 10 after 1 and remind everyone to shut off your camera and mute your microphone unless you want the YouTube universe to know what you're doing for the next 30 minutes. So thank you again for all of your hard work this morning, and we'll see you at 10 after 1. Thank you. Committee members, if you are there, if you could activate your cameras. Thank you, Representative Sheehan and Senator Carney.
Representative Harnett, I am here.
Who's that?
Representative Newell.
Oh, okay. Thank you, Representative Newell. I hope you're still not getting your car worked on.
No, sir, I'm currently on the road.
Okay. Driving down here?
Yes, sir.
You have a long trip.
Representative Harnett, I will take the virtual gavel from you after 1508, because you're doing the final public hearing, introducing that bill, right?
I am indeed.
All righty.
Thank you. So we got 1, 2. And I know that Representative Babbage said we might not have him for a good part of the afternoon.
Yeah, he has several bills, I think, to introduce. It's also my understanding that because this is a continuation of our morning session, that it looks like we are going to have a quorum, but that the quorum that we had in the morning
is still established.
Is still established.
Okay, 1, 2, 3, 4, 5, 6. But we had Representative Newell in her car. So I got 1, 2, 3, 4.
I'm here, Mr. Chair, but I am going to be off camera.
Oh, that's okay.
But I am here for purposes of quorum.
Thank you. Welcome back to the Judiciary Committee for continuation of our morning's public hearings. We will forego introductions since everybody knows who we are now. The same people have been here all day. So I will now turn to LD 1508, an act to prevent homelessness by establishing an eviction mediation program. And I welcome my co-chair and our colleague, Senator Carney, to introduce the bill. Welcome, Senator Carney.
Thank you very much. Good afternoon, Chair Harnett and esteemed members of the Judiciary Committee. As you know, I'm Ann Carney, representing the people of State Senate District 29, South Portland, Cape Elizabeth, and part of Scarborough. It's an honor to be before you today to introduce LD 1508, an act to prevent homelessness by establishing an eviction mediation program. The Maine Affordable Housing Coalition in 2020 created an eviction tracking database. The work involved traveling to courthouses, collecting data from the physical case files, and putting the outcomes and other key data points for eviction cases into the database. Lots of legwork and brainpower went into compiling this information, and it has proven to be extremely valuable. I encourage you all to read the Evictions in Maine report, and I've put a hyperlink to that report in my testimony. LD 1508 addresses one of the key findings of the report. Tenants continue to lag far behind landlords in legal representation, and case outcomes continue to strongly correlate with this imbalance. Landlords had legal representation in 80% of the evictions in the study. Tenants had legal representation in only 20%. What surprised me most was not the difference in representation, but the impact of the representation. Unrepresented tenants were subject to eviction judgments in 73% of the cases. Yet when tenants had legal advice, outcomes split evenly. That is, landlords and tenants were equally likely to win or lose the eviction case. And you'll see in my testimony a chart that illustrates that that data. As the data collection progressed, the pandemic hit. Over time, Maine saw the implementation of rent relief programs, eviction moratoriums, and new court procedures. The changes forced upon us by the pandemic helped to identify ways that we could improve the eviction process, use rent relief programs to make rent payments to landlords, and keep tenants housed during a public health crisis. The legislation proposes to preserve the most beneficial changes by strengthening Maine's eviction mediation program. Here are the major features of the bill. Landlords filing eviction actions will include with the summons and complaint a one-page information sheet that informs tenants about the court process, rental assistance, legal information, and housing counseling services available in the area. The initial status conference created by the court in response to the pandemic is incorporated into law and provides an initial point of contact for requiring mediation where appropriate. Mediation is waived and a case moves to an immediate hearing if required to prevent irreparable damage to a dwelling or serious physical harm to a person. Funding is provided to give mediators additional training and resources like information about rental assistance programs that can help the parties reach an agreement. Funding is provided for legal services to tenants in eviction cases to ensure equal access to legal protections. I am working on an amendment to the funding mechanism in this bill. As the bill was being finalized and printed, federal legislation that gives Maine significant financial resources to provide rental assistance and housing support services was enacted. Maine is slated to receive $152 million in federal funds for rent relief, eviction prevention, and other housing needs. The Federal Treasury Department is preparing guidance on exactly how these funds can be used, though it is clear that the funds must be used to support Maine's economic recovery from the pandemic. We have several years to use the funds. LD 1508 creates an eviction mediation program that allows early intervention in the eviction process. It provides information and access to rental assistance programs that benefit landlords and tenants, which in turn helps the parties resolve disputes without resort to an eviction judgment. The legislation will keep Mainers housed during the affordable housing crisis we face, and that is so significantly impacting our state. Thank you for your thoughtful consideration of LD 1508 and the testimony you will read and hear today. I'm happy to respond to any questions you have.
Thank you very much, Senator Carney, for bringing the bill forward. Are there any questions from committee members for the bill sponsor on LD 1508? I will begin with Representative Moriarty.
Thank you, Mr. Chair. Senator Carney, I'm anticipating some of the comment that may be raised in opposition. So I'll put this question out on the floor now. What are your thoughts concerning whether the several stages of the mediation process, to include mediation, can be completed within the typical turnaround time between service of the complaint or summons and the time set for final hearing?
You know, I am concerned about that. The intent of the bill is not to extend or prolong the eviction process. It's really to make sure that we create a really robust opportunity to access any federal resources or other programs that are available to prevent evictions, and that we have time to get those in the works and allow the parties to resolve the case if and when that's possible. So avoiding the avoidable evictions. And I do think that there's some work that could continue to be done on the process issues. For example, yesterday I had a conversation with a representative of the judicial branch and a representative of the CADRES program, which is the court's alternative dispute resolution program. And they indicated to me they had some really good ideas about how more leeway could be given to the judicial system to create the procedure around the initial scheduling conference, for example. And so there's more work to be done there. I appreciate you raising that question because I think that that's probably the most important area to continue to work on this bill. Thank you.
Okay, good. Thank you.
Thank you, Representative Moriarty. Representative Thorne.
Thank you for your patience, Mr. Chair. Multitasking per usual. Senator Carney, you mentioned an amendment that you were working on. Could you perhaps briefly outline that for us?
I cannot because I'm working on it. I don't have, it really involves another round of conversations with the representatives from CADRES and the judicial branch. And I actually would really like to include in those conversations representatives from some of the landlord groups because, you know, again, the purpose of this bill is to bring in more resources that can help make the eviction process fair and that can help avoid those unavoidable evictions and utilize the resources that we know are going to be available to people in our state.
And if I may ask a follow-up question, Mr. Chair?
Yes, Representative.
Is there a distinction, Senator Carney, between homelessness and moving on to a different dwelling?
Definitely.
Does it have to do with the history of the individual that predetermines that if this eviction potentially goes through, that this person is going to be homeless and not have any other opportunity for housing? Is that what I'm gathering?
Let's see, I'm having a little hard time following your question, but I think I've got it. So I think we heard this morning about the impact that in relation to some of our other bills, the difficulty that people are when they've been evicted or had to leave housing, the incredible difficulty they have finding replacement housing because of the affordable housing shortage.
Mm-hmm.
And so, you know, not everybody who gets evicted becomes homeless, but people who get evicted do become homeless. I mean, I was working on an Earth Day cleanup project this weekend, and in a little wooded area where I was picking up trash, I came across a little encampment that a homeless person had made and had been living in not super recently. But, you know, that's the kind of situation that I think we want to make sure that people actually don't end up having to sleep in a little homemade shelter in a wooded area.
So if it's predetermined that somebody would likely not be homeless as a result of it, then this mediation program would not take place. And that's what I'm trying to wrap my head around is, when does this kick in if successful in an eviction mediation program? Is it for someone with a history of homelessness? Does there have to be a history of homelessness?
No, there does not. So if you look at the bill itself, the program, and you can actually kind of see, like if you look at page 1, that first section 2, says that participation in the program is mandatory if ordered by a court or requested by either party to an eviction proceeding. And so it's for any residential eviction case. Cases are not pre-screened for a potential risk of homelessness. And I actually don't know that you can determine that before you've been evicted, actually.
Okay. Thank you, Mr. Chair. Thank you, Senator Carney.
Yeah, thank you for, I didn't realize that that's where you were going, and I appreciate you clarifying it. Thanks.
Thank you, Representative Thorne, and thank you for your response, Representative Carney. Are there other members of the committee with questions for the bill sponsor, Senator Carney?
I see Representative Libby's hand is up as well.
Thank you. Representative Libby.
Thank you, Mr. Chair, and thank you, Senator Carney. I have two questions. One is, I think, for the work session, and that is simply the number of evictions, whether it is it only takes the very start of the process to make it move along, or all the way through the process, as Representative Arata had referenced that she's only done one time in 14 years. I just would like to have as a reference at the work session the number of evictions that occur in Maine per year, to know what kind of workload we're looking at for our judiciary system. And then my other question, excuse me, is I'm trying to figure out where in the process of eviction this process would fit in. So is this, and Representative Arata had kind of spoken to that process earlier, which I'm not overly familiar with. So would this be applied in the very, very first step of the eviction process? Okay, so it would then have the potential to apply to every single eviction done in the state of Maine.
It would be residential only, so not a business being evicted from a business premises. It would have the potential. It would not apply in cases where there was a risk of property damage or harm. Those would actually go right on to an eviction hearing. But in other cases, if either of the parties requested mediation, or if a judge felt that it was important for the parties to try mediation, then mediation would be required.
Thank you.
Yeah. And also on your question about the data regarding the number of eviction cases, if you follow that hyperlink to the Affordable Housing Coalition study, they actually went to courthouses and individually went through paper files, I think, to glean that information. I think you'll find a lot of what you're looking for.
Perfect, thank you.
Thank you very much, Representative Libby. Are there additional questions for the bill sponsor from committee members? Representative Sheehan.
Thanks, Mr. Chair. Senator Carney, I just wanted to learn a little bit more about the initial status conference and wanted to know if this is a current practice, how it's being carried out, and how this conference could relate to the question of whether or not mediation happens.
So those are all good questions, and that is the area that I was, in response to Representative Thorne's questions, I was kind of referring to. As I was working on this, I think I had a little bit of a misunderstanding about how the initial scheduling conferences under the pandemic management order are run. I was kind of envisioning like an individual meeting between the judge or some other judicial representative and the parties. But I've come to understand since then that it's more of what we would call the call of the docket type situation, where judges are calling on the parties, providing some basic information, but I think it's a little bit more of like a triage situation. I also know that in the foreclosure prevention statute that's been in effect for quite a while, there is, I think, probably a better model for how that initial status conference can happen. And that's the first place that I would turn to explore, with a follow-up meeting with a representative from the judicial branch and with others who have been involved in both the pandemic management order eviction proceedings, as well as those who have been involved in the foreclosure processes that are a prelude to mediation, because I think there are a lot of improvements that I could glean from pursuing those two avenues of information.
Great. I'll look forward to the work session.
Thank you.
Thank you very much, Representative Sheehan. Are there any additional questions from committee members for the bill sponsor? Seeing none, thank you very much for bringing this bill forward, Senator Carney. We will now move on to people providing testimony. I will remind everyone again that after the bill sponsor, all persons will be limited to 3 minutes in testimony, although there will be an opportunity for questions at the close of that 3 minutes. And I am going to take our first person slightly out of order as a courtesy to our legislative colleague, Representative Arata, though testifying in opposition. I know you've been here all day. You may have other things you need to do. So you can proceed to testify as soon as you're ready.
Thank you, Representative Harnett. I appreciate that. Although well-intended, for many tenants, this mediation program would merely be used as a delay tactic and force some landlords into foreclosure. The eviction process is already tedious and time-consuming, and many property owners simply couldn't survive several extra months without rental income to pay for the mortgage, taxes, utilities, etc., while also paying additional billable hours to their lawyer. By the time the eviction process is initiated, most property owners have already tried establishing payment plans for tenants who can't pay rent or have given warnings for lease violations or disruptive behaviors. Indeed, eviction is the absolute last thing any rental housing provider wants. Unfortunately, some people simply cannot afford the rent or cannot change certain behaviors, such as smoking in the property, which causes health issues for the other tenants and damages the property. An eviction has multiple steps required and would take over a month for non-payment if everything went absolutely perfectly and all the court dates lined up with the required notice periods. However, that never happens because of holidays, weekends, and the low availability of court dates for eviction hearings. For example, in Androscoggin County, there are usually 2 FED hearings per month. Some courts in Maine offer hearings only once per month and some even less often. During Maine's long eviction process, there's plenty of time for tenants and property owners to come to an agreement and dismiss the case. Often, just the first notice is enough to make the tenant understand how serious the situation is, and landlords certainly have a monetary incentive to work with tenants to keep them in the property. However, if tenants know that they can delay an eviction by going through the motions of a required mediation program, many will take advantage of the situation and use the unpaid rent money for something else or continue their negative behavior. The eviction process is so long that it would take up most of my testimony time to explain it. But if you'd like more details about the eviction process and why it takes so long, I'm happy to try to answer any questions you have. Thank you.
Thank you very much, Representative Arata. Are there questions from committee members for Representative Arata? Representative Libby.
Thank you, Mr. Chair, and thank you for being here, Representative Arata. I have learned a lot from you today and your experience as a landlord. Can I ask, have you ever been part of a mediation process in your time as a landlord?
Yes, actually. Sometimes the courts will offer a mediator, and both the landlord and the tenant, if they both agree, they can go together and meet with the mediator in the back room and come to an agreement that's mutually beneficial. So for my very first eviction I ever did, I didn't have anything against the guy. He just couldn't stay. He wouldn't stop smoking and he wouldn't pay the rent. And so what we sat together and talked, and what he wanted were a few more days to move his things out. And so I said, that's fine. And I gave him the extra time. And we told the judge that that's the agreement we came to. And if he didn't comply and didn't move out when the extra time I gave him, then he would be evicted. So I didn't have to go to court again, because that's a long wait to get back into court if they're only meeting once a month and you have a lot of notice periods and things like that. And also if you're hiring a lawyer, which I kind of like learning new things, so I didn't hire a lawyer, but most people do, and they're very, very expensive. So that lawyer would have to go back to court again if we have required mediation and then the tenant didn't follow through. So, I would support having an option for mediation and maybe putting more money into the program so that it's available for everybody when both the tenant and the landlord want it. Usually that they both want to work things out, So I could support that, a non-mandatory program, certainly.
Thank you.
Welcome.
Thank you, Representative Thorne.
Thank you, Mr. Chair. You half answered my question, Representative Arata. My question is, what is currently in existence that is similar to this program, and what differentiates this program from what is currently already in place and by all accounts from your testimony is difficult to have the hearing held?
Right. I've only been into court a handful of times. And as I said earlier, I've only actually gone to the final step of the eviction process once in 14 years. So, I think whether or not there's a mediator showing up, it's kind of hit or miss, I think. And so maybe we could strengthen the program we already have. I think that would be really beneficial, and maybe do a better job, give a handout or something explaining to tenants and landlords how mediation works, and that you're not giving up any of your rights by going through mediation, but it's something that could be mutually beneficial.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Any additional questions for Representative Arata from members of the committee? Representative Libby?
Thank you. I don't have one for Representative Arata, but if there were an appropriate moment, I do have one more for the sponsor of the bill, if that's possible.
You may ask that now.
Thank you. I just am continuing to read through the mechanics of this bill, Senator Carney, and I see that on page 4, lines 3 through 6 address costs to the court system and to the tenants. And I'm wondering if there is somewhere that I should be looking for money provided for the landlords to hire an attorney to use during the mediation process.
Well, so there's no evidence, and again, I would refer you back to that study, but the evidence is that landlords are able to afford attorneys in most of the cases. The deficit is in the lack of access by tenants to the attorneys. And so the resources would be to help kind of level the playing field there and ensure that when the tenants find themselves in court, that they have similar access to legal advice.
I see. Can I ask a follow-up, please, Mr. Chair?
Yes.
So then the tenants at this point do not have access to lawyers through like Pine Tree Legal or other associations like that that are provided with funds from the state of Maine?
The available legal services resources are not adequate to meet the demand.
Thank you.
That's my understanding anyway.
Thank you, Representative Libby. Seeing no additional questions for Representative Arata, thank you very much for spending a good deal of your day with us today. And you're free to watch or free to go, but thank you. I will now turn to those who have registered to testify in support of LD 1508, and I will begin with Ben Jenkins. Mr. Jenkins, welcome to the Judiciary Committee. I will start the 3-minute clock as soon as you begin to testify.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Ben Jenkins. I'm the Litigation Director at Legal Services for the Elderly. We represent Mainers who are 60 and older and all sorts of court proceedings around the state, including eviction cases in all 16 counties. I've submitted written commentary that, if you're interested, has a number of citations, studies, and statistics regarding the impact of this bill. Some of those are probably duplicative of the materials mentioned by Senator Carney. There's a lot of research out there showing how bills like this help, not just help tenants, but help local economies to avoid the extra costs associated with homelessness and other social problems created by certain evictions. Last year, in response to the COVID pandemic, several legal aid providers, private attorneys, landlords, and other groups participated in remote information sessions with the courts. And in response to that feedback, the courts created a new temporary framework for FED litigation that included the following changes: a comprehensive information sheet that's provided with the complaint and summons that includes resources for tenants, the creation of a telephonic status conference held with the presiding judge, which the parties are informed about the process and potential resources, and the opportunity for mediation prior to a final hearing. These key provisions are all mirrored by the language of LD 1508. And these processes have been followed by district courts all around the state for the last year. This proposed legislation will formalize the improvements in the FED procedures that have been so effective during the last several months. And practically speaking, under these new procedures, LSE has not had a single contested eviction hearing in the last year. This process works. We are able to reach negotiated resolutions in every case that is entered into the court. And it's not just accessing rental assistance. It's working with clients who need in-home services to avoid evictions and allow them to stay in their homes. It's also having the time to find more appropriate housing for vulnerable seniors. And reaching an agreement also protects landlords and tenants by reducing the conflict and tension that creates so many safety issues for our clients. In contrast, under Maine's traditional FED procedures, there's essentially no time for the parties to meaningfully discuss how to resolve whatever issue led to the eviction litigation. The modifications in the bill, and especially the use of mediation, allow many more cases to be resolved by agreement. This protects vulnerable Mainers from homelessness, allows landlords to access rental assistance programs, and reduces the need to expend judicial resources on eviction hearings. LSE always works to resolve eviction cases by agreement between a landlord and a tenant, but unfortunately Maine's traditional FED procedures impede this type of cooperative problem solving. Notably, LD 1508 reflects the fact that these types of agreements typically occur only when the parties are represented by an attorney, and includes funding to allow legal providers to help more clients. I anticipate there may be concerns about delays in the eviction process, and if there are questions on that topic, I'd be happy to answer them based on our real-world experiences. These new procedures used during the pandemic have been a huge upgrade, and putting these steps into statute will protect Maine seniors while also helping Maine courts function better. Thank you for considering our perspective, and we hope that you will support this bill.
Thank you very much, Mr. Jenkins. Thank you for taking the time to provide your testimony today and submitting it in writing as well. Are there questions from committee members for Mr. Jenkins? Seeing none, again, I thank you very much for taking the time to present to us this afternoon.
Thank you.
I will next recognize Megan Hannon. Ms. Hannon, as soon as you are comfortable, please, first of all, welcome to the Judiciary Committee. Thank you for being here. And as soon as you're comfortable, begin your testimony.
Thank you very much. Good afternoon, Senator Carney, Representative Harnett, ladies and gentlemen of the Joint Committee on Judiciary. I'm Megan Hannon, Executive Director of Maine Community Action Partnership, and we are in support of LD 1508. For more than 50 years, Community Action has served as a dynamic and community-based force in addressing the causes and conditions of poverty throughout Maine and the country. Our 10 community action agencies deliver programs and services for people with low and moderate income, including the Home Energy Assistance Program, or HEAP, Workforce Development, Head Start, and more. We've administered all 4 versions of the rental program so far and are still continuing on its 5th. There are a couple of things that the current rental relief program sets it apart, all of them welcome additions. We can pay a year's rent in arrears and up to 3 months proactively. We can pay utilities in arrears and new bills as they arrive. But the best new addition is the ability to provide case management-like services to promote housing stability. Each agency has a team for any eligible tenant. The team includes our case management staff, legal and mediation support, and an appropriate local BIPOC community-based organizations. Stable housing is more than roof and walls. It's a key to economic security. Ironically, in Maine, our rents and electric costs are so high they can work the other way. People work to pay rent and pay rent so they can work. People work many hours at low-wage jobs, sometimes several, and still can fall behind. Our case management includes things like budgeting and lowering costs, but often that's not really the problem. The problem is that too many people don't make enough money to pay the bills, rent, school loans, car payments, groceries, etc. For Mainers of color, the situation is even worse. According to the Maine Center for Economic Policy's report, State of Working Maine 2020, Mainers of color make less than their white counterparts across the board. Even as education moves from high school through a bachelor's or higher, wages did not rise equitably. Mediation before eviction is not asking too much of the landlords. It gives tenants a chance to work with their landlord to reach an agreement. I'm not supporting tenants taking advantage of the situation or of landlords not being able to evict tenants who destroy property or are a danger to their neighbors. I support skilled, unbiased mediation as described in LD 1508. Thank you very much for your time. I'm happy to answer any questions if I can.
Thank you very much, Ms. Hannon, for taking the time to present your testimony to the committee this afternoon. Are there any questions for Ms. Hannon from members of the committee? Representative Thorne.
Thank you, Mr. Chair. Thank you, Ms. Hannon, for showing up and providing your testimony today. In your testimony, you provided information regarding that it is particularly high for persons of color. Is there a provision in this bill that addresses that specifically, or is that just a sidebar?
That's really just a sidebar in our promotion of equity and ensuring that we have the correct people on our teams to make sure that everyone is comfortable.
Okay, so this bill actually encompasses everyone equally, correct?
Yes, correct.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions from committee members for Ms. Hannon? Seeing none, thank you very much for taking the time to present this afternoon. It's greatly appreciated by the committee.
Thank you all.
The next person on my list registered to testify is Chris Linder. Chris Linder, when you are ready to begin, you'll have 3 minutes. Welcome to the Judiciary Committee, and begin talking when you're comfortable.
Great. Thank you, members of the committee, Representative Harnett and Senator Carney, for having us. I am the Housing Counseling Director for Penquist Community Action Agency in Bangor, covering Penobscot, Piscataquis, Waldo, Washington, Hancock, and Knox counties, basically Eastern Maine and Mid-Coast. We are a member of NECAP that Megan just testified from. We're one of 9 CAPs in the state. My team basically provides counseling services to those mostly low-income families who want to buy homes if they need to find a rental, but we also help with both foreclosure evictions and rental evictions. My team also helps small businesses throughout the state in starting up and helping grow, and in the last 8 months really survive through COVID. And we definitely don't, in support of this bill, we definitely don't want to give off the impression that we are somehow against small businesses, which basically landlords here are in Maine. We're a very small landlord state. We don't have large corporate out-of-state landlords. So we're very much in support, and in a lot of ways, it's not always the tenant who is right. Some of the counseling that we provide is basically you've waited too long, you've made a lot of mistakes. The best answer is for you to find an alternative and move out. So there is a lot of tough love in the counseling that we provide. the one program we're part of, we work in the foreclosure diversion program, the mediation, and often what happens is when I visit with my counselors, we get pulled aside by the bank's lawyers, by the court staff who say, we really appreciate you being in the room and being part of this process. We really help with taking a lot of the emotion out and coming up with a real concrete plan. So we think this process, we have a nice parallel system that we can build off of. Why we like this bill, as someone has mentioned, 95% of tenants, and I think it's 95% of landlords have good intentions. What we would like to have is just more of a systematic process to mediation. Right now, it's more ad hoc and more sort of at the knowledge base of the people in the room, and sometimes in terms of the preference by the judge. And it doesn't necessarily have to be a requirement that mediation happens. It's just that mediation has to be brought up as an option. And that's why we like this bill. There are off-ramps in the extremes. Thank you. And so in the extremes of, people not taking care of health issues and legal issues, there are ways for the landlords to move more quickly. And I think I'll stop there. I don't want to go over my time, but thank you.
Thank you, Mr. Linder, and sorry to move you along, but you can see our hearings do seem to go on. But thank you very much for your time and testimony today. Are there questions from committee members for Mr. Linder? Seeing none, thank you very much again for your time and testimony. Greatly appreciate your insights.
Thank you.
I would next ask for Frank D'Alessandro to be moved in as a panelist, followed by Greg Payne, and then Catherine McGovern. And Mr. D'Alessandro, as soon as you are situated and comfortable, just unmute your mic and begin your testimony. Welcome to the committee.
Thank you. I'm having a little technical difficulties here. Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Frank D'Alessandro, and I'm the Litigation and Policy Director of Maine Equal Justice. Maine Equal Justice supports LD 1508. Mainers' health, well-being, and economic stability all start at home, and there is no worse threat to family stability than an eviction or the forcible removal from the home. The bill establishes an eviction mediation program to provide mediation services to the parties in eviction cases, either by court order or at the request of either party. I think you've already heard about the benefits of mediation. One thing I can add, I have done many evictions over the years, and I would not in court anymore, but during the time I was in court, I can say I took, even though I was able to negotiate many cases, I cannot say that all the cases resolved, as did Attorney Ben Jenkins from Legal Services for the Elderly. And that alone just points out how an organization like Legal Services for the Elderly able to settle all its cases, and Legal Services for the Elderly represents both tenants and landlords, is the strongest evidence I can cite to why this mediation program is so important and so effective. It's critical that Mainers remain housed. So it's not just homelessness, which is awful, and it does happen as a result of the evictions. But every time someone is evicted, they're likely to lose most, if not all, of their possessions. Children have to change schools. There's great disruption that ripples through the family's life, and that's important to be avoided as much as possible. I've often described my role at when I was at Pine Tree Legal Assistance in eviction court. Often I found that we were the mental health provider of last resort. And what that means is a lot of times we were representing tenants who needed services and just didn't have them. And we spent a good portion of our time in making sure those services got pulled together. And the mediation process will provide a better, more formal and stable way to make sure that happens. Especially now, I mean, Maine has been in a housing crisis for a long time, at least since the recession, as a result of the foreclosure epidemic. But it's been made worse by the pandemic. And right now, tenants who are displaced often have extreme difficulty getting back into the housing market because they can't afford to, especially low-income tenants. And that's what the procedures in this bill will safeguard against.
If you can wrap up, Mr. D'Alessandro.
Well, and also I think the evidence of, as cited in my testimony, the evidence of the benefit to the process of making sure that tenants receive legal representation is well documented in many studies.
Thank you very much, Mr. D'Alessandro. Are there questions from committee members for Mr. D'Alessandro? Seeing none, again, thank you very much for your time and for presenting testimony today. I would now ask for Greg Payne to be elevated to a panelist, followed by Catherine McGovern and then Nan Heald. Mr. Payne, you can, as soon as you're situated, begin your testimony when you're comfortable. Thank you for being here today.
Great, thank you. And good afternoon, Senator Carney and Representative Harnett and the members of the Joint Standing Committee on the Judiciary. My name is Greg Payne. I am the director of the Maine Affordable Housing Coalition, and we strongly support this bill. We consider it to be actually one of the most potentially impactful housing bills that have been filed in this legislative session. It is our experience that some evictions are probably unavoidable. And in fact, sometimes there are evictions that are urgently necessary. It is also our experience, though, that there are too many evictions that happen that didn't need to. And so the central premise of this bill, what it's really all about, is trying to identify things that we can do to improve the existing process so as to avoid the avoidable evictions. The bill proposes to do that in three specific ways. The first is by providing clear, plain language information to tenants when they're served with a complaint so they understand what the process is, what their rights are, how they might try to find an attorney, how they might try to find rent relief in a way that could end up helping to resolve the dispute. We think getting that information could be very helpful and helpful in allowing them to avoid an eviction. The second way that this bill tries to prevent preventable evictions, as has been discussed, is by trying to close this really large gap in representation between landlords and tenants in terms of legal counsel. 80 to 20 is too much, and especially I think as Senator Carney detailed, when tenants have a lawyer, they are 85% more likely to avoid an eviction judgment. And I just want to be clear, this doesn't always mean the person doesn't leave the property. It means that they have counsel with them to help avoid an eviction judgment. And the reason that's so important touches on a question that I think Representative Thorne asked earlier in that relationship with homelessness. And that is, once you have an eviction judgment, it is so much harder to get your next apartment. It is a red flag for future landlords, and that's part of the challenge people have. So this is part of why we think additional counsel will help to resolve some of these disputes in a way that isn't kind of dragging tenants down for years and years going forward. The final piece of this bill that tries to prevent the preventable evictions, I would say just writ large, the idea from the start has been to do something that the current process doesn't do. And that is to put a place in the process for conversation between the parties. The existing process, putting the pandemic emergency process aside, doesn't do that. And that's certainly the goal that we've had in writing this bill, is just to present a forum for the parties to talk in hopes of resolving the dispute in a mutually beneficial way. I will say, there are some of our friends, some of our partners on the landlord side of this that have concerns about the timeline of evictions. And I think those are fair. And I think it's going to be important to talk those through. The idea here was always to come up with a way of people talking without extending that timeline. And I'll stop there. I think I've reached the end of my time. I did want to point out the report that we have done that Senator Carney referenced is attached to my testimony. There's a lot of data in there, which I hope is helpful. And I really appreciate your time today talking these issues through.
Thank you very much, Mr. Payne, and thank you for taking the time to testify and providing your insight as well as your written materials. I will now open it up for questions from the committee, beginning with Representative Thorne.
Thank you, Mr. Chair. Thank you, Mr. Payne, for coming by today and helping us understand this bill a little more. In your testimony, you mentioned that an eviction could possibly follow a prospective tenant around, and not sure if I heard you correct, prevent a landlord from renting to them. Is that correct?
Yes.
Now I get into the question of, isn't that a form of discrimination?
It's not a protected status, whether or not you've been evicted before. So it is not. I mean, functionally, the way this works is if you're a landlord, you usually do a criminal background check, you do a credit check. But one of the things most landlords do is also seek whether there is an eviction history. And that information, if it shows up that in fact there is an eviction history, and unfortunately that can mean just a complaint being filed, not that it was resolved against the tenant, but just filed. What happens functionally in the real world is that that landlord sees that and immediately goes to the next application, of which they typically have many. But it is a red flag that I think most landlords would, acknowledge that if they see it, they are much less likely to accept that application. And that really is one of the big problems with what happens with an eviction judgment. And again, why it is so helpful to, instead of a judgment, try to come up with a mutual agreement.
Even though they may not have even been evicted, just the fact that they were brought up on an eviction. Is that correct?
Yeah, the fact that a complaint was filed against them shows up on these reports. Obviously, it's worse when there is a judgment against them, but it is better than having a judgment against you is if it reflects an agreement of the parties rather than an eviction judgment. That will at least allow the tenant to have a fighting chance in leasing up their next apartment.
I see. Thank you. Thank you, Mr. Chair.
Thank you. I was kicked out of the Zoom again, but made it back in time. It sounds like you finished your question for Mr. Payne, Representative Thorne. Are there additional questions from committee members for Mr. Payne? Seeing none, thank you very much for taking the time to provide your testimony today.
Thank you, Representative.
The next person I have on my list is Catherine McGovern. Welcome back, Ms. McGovern, and please begin your testimony as soon as you're comfortable.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the committee. I'm Catherine McGovern. I'm an attorney at Pine Tree Legal Assistance. As you know, Pine Tree represents low-income Mainers throughout the state, and we appear in the district courts representing tenants in evictions all over the state. Pine Tree Legal Assistance supports LD 1508 because evictions drive poverty, because having an attorney makes a big difference in outcomes in eviction court, but too few tenants have legal representation, and because providing notice of available resources and thoughtful mediation promotes better outcomes for families. I'm going to focus in this testimony on my experience representing tenants in eviction court and what that looks like, because I think that's important to understand how that happens in the normal course of things before the pandemic management order and what's lost in the course of that process. So I've represented tenants in Portland District Court over the last 17 years. In Portland, we have court twice a month. There's often as many as 60 cases on the docket. The day begins with the court calling through the list. There's generally one mediator available in Portland. And so the judge often will send one case to mediation, often a case that does not involve any attorneys. Everyone else is in the courtroom, is sometimes quite full, is sent out into the hallway to negotiate their cases on their own. The Pine Tree attorney comes with cases that we may have as many as a dozen, people who've contacted us ahead of time. And then we also meet people for the first time at court. And we need to do screening based on eligibility, determine if they're eligible for our help. We need to determine if there are any viable legal defenses. We need to find out what the goals of the tenant are and what potential settlement proposals they might have. And we're doing that while working on our other dozen cases. And often we're negotiating multiple cases at once. We're also aware that the court officer is letting us know that the judge would like to get going with any hearings that need to happen. And so there's quite a bit of time pressure. We negotiate settlement agreements, we have hearings, we prepare for hearings, and all of this generally happens between 9 and noon. What's lost in that process is that although we do our very best to get the best possible outcomes for people under the circumstances and avoid homelessness whenever possible, what we've lost in that process is a chance to really meaningfully talk to people about their cases, to be able to develop defenses that people may have. For instance, if they live in an apartment and the landlord is unreasonably failing to make necessary repairs, they may have a defense based on warranty of habitability. But if we've met them in court for the first time and they're showing us pictures on their phone, we're not going to be able to fully develop that valuable legal defense. In addition, people who have disabilities may be being evicted for a reason that's directly related to their disability. If they have a mental health condition, they may be violating the lease due to symptoms of their disability. And if they had an opportunity to connect with additional services that will lessen their symptoms, they may be entitled to a reasonable accommodation and they may be successful in housing. But we can't determine that in this setting. So we believe that in addition, people will, with the rental assistance, need some time to find out if they're going to qualify for rental assistance. And with that time, we'll be able to resolve more cases in a way that is satisfactory to both landlords and tenants. Thank you.
Thank you very much, Ms. McGovern. Are there questions from committee members for Ms. McGovern? I have one question, Ms. McGovern. You mentioned that the times that you've been handling landlord-tenant matters and eviction matters for quite a long time, 14 years, I thought you said, and that when there is an opportunity to talk and meet and negotiate, that has often improved outcomes. Do you imagine that with a program like this, you would, what do you think you would see in terms of negotiated outcomes rather than litigated cases?
Well, I think that if we have a chance to have a more thoughtful mediation process instead of trying to negotiate 12 different cases at once, that we are more likely to be able to come up with solutions that are satisfactory to people. In particular, during this time when people have the emergency rental assistance that's available to them, but the agencies have to have time to process those applications. Then if we have some time to have meaningful mediation, we can figure out whether people will qualify for help. And that.
Thank you. Thank you very much, Ms. McGovern. Additional questions from committee members for Ms. McGovern? Seeing none, again, thank you very much for providing testimony today. The committee appreciates your insight, both your oral presentation and the written testimony that you submitted. Thank you. I would now recognize Nan Heald. Ms. Heald, as soon as you are set, if you could unmute your microphone and activate your video.
Yes, thank you. Representative Harnett, Senator Carney, members of the committee. My focus today is primarily on the funding challenges that we face. Roughly a third of Maine residents live at or below 200% of the federal poverty guidelines, and that makes them potentially eligible for free representation from Pine Tree Legal. And eviction prevention has been a priority for our program since our doors first opened in 1967. But we have never had enough legal aid resources to respond to the demand for help in this area. Pine Tree, I think under the Maine Affordable Housing Coalition data report that has been shared with the committee, Pine Tree attorneys are the primary source of legal representation for low-income tenants in eviction proceedings. And we're proud of that effect. Most of the testimony that I have heard listening to the committee hearings today from landlords talks about the inability to be able to communicate effectively with their tenants or to convey the importance of accessing the available financial resources that could support the tenant in paying their rent and staying in the apartment. I would note that Pine Tree has 54 years of experience in communicating effectively with tenants about their legal rights and responsibilities. And our experience shows that when tenants are represented, the majority of them are able to stay in their homes because of negotiated agreements that benefit both sides in the case. To make that possible, however, tenants need more attorney resources, which the funding in LD 1508 would provide. Most of the general funding for eviction work has declined or has not kept pace with inflation. And that includes sources that support all of Maine's legal aid providers, as well as the ones that are specific to Pine Tree Legal. The Emergency Rental Assistance Program, now being administered by Maine Housing, carries significant limitations imposed by Congress and the Treasury Department. We estimate that only 11% of the people who come to us for help with landlord-tenant issues would be eligible under that program. Our staff are haunted by the people that we have to turn away, especially when we know that representation could change the outcome of that case. And for that reason, we strongly support LD 1508. I'm very happy to answer questions.
Thank you very much, Ms. Heel. Thank you for being here today, and thank you for your written testimony, which shares some stories of people that Pine Tree has served, and it really helps paint the picture. Are there questions from committee members for Ms. Heald? And I note Representative Thorne.
Thank you, Mr. Chair. Thank you, Ms. Hill, for coming today and providing your testimony, helping us understand this complex bill. You had mentioned that you turned away folks for legal assistance. Hey, could you categorize that perhaps? Why they're turned away?
Representative Thorne, simply because we take very seriously our professional responsibility to handle cases and provide adequate representation to the people whose cases we've accepted. We have, I think, maybe 12 lawyers around the state, of which handle at least a portion of their caseload involves eviction work. And when we get to people that have 60, 70 open cases, we just can't take new cases and be able to provide adequate representation on the other cases, even when they're spread out over time. So that's a decision that's made by our managing attorneys, including Catherine McGovern and others, to be sure that we can do our best job for the people to whom we say yes.
I may ask a follow-up question.
Yes, you may, Representative.
Thank you. So by establishing an eviction mediation program, trying to get this strong, that would perhaps meet people halfway before they get to you. Am I clear in saying that?
Representative Thorne, I am not the expert on the mediation program. My perspective is really, right. Well, and so I guess my point is that if a tenant comes to us, like the tenants that I mentioned in my written testimony, and we don't have the capacity to help them, we will give them general advice, but we will not be in the room when the mediation takes place to ensure that the mediator understands the particular challenges that our client faces. And as Ms. McGovern mentioned, that person may have a disability. There may be other reasons why they are struggling. And I think it's important for there to be advocates for both sides so that the mediator has a full understanding of the situation.
Thank you. Thank you, Mr. Chair.
Thank you, Representative Thorne. And thank you, I'm sorry, are there additional questions for Ms. Heald from members of the committee? Seeing none, thank you very much for taking the time to submit your testimony, both written and oral today. Committee greatly appreciates it. That concludes the persons I had registered to testify in support of LD 1508. I am going to check the attendee room to see if there are any persons who still wish to testify in support. And I do see a hand up for Jocelyn Layton. If I could have Jocelyn moved over as a panelist so I can confirm that she's here to testify in support. Good afternoon, Ms. Layton. Are you here to testify in support of LD 1508?
Yes, Representative.
Thank you. Whenever you are ready, if you could begin by just stating your name and your place of residence, and then you can begin your testimony.
Sure, thank you. My name is Jocelyn Layton and I live in South Portland. And Senator Carney and Representative Harnett and members of the Judiciary Committee, thank you very much for having me. I am a South Portland City Councilor from District 1, and I'm here today to support LD 1508, an act to prevent homelessness by establishing an eviction mediation program. I would like to begin by thanking everyone for sponsoring and co-sponsoring this important bill. I am in full support. Housing is a human right, a fundamental necessity that everyone needs. Without the security of housing, everything in one's life is disrupted. This bill would provide more consideration and direct conversation between landlord and tenant in order to ensure access to a basic human need. In the relationship between landlord and tenant, there is a power dynamic that also needs to be disrupted. This bill would be that necessary disruption and give agency to those directly impacted by a possible eviction. LD 1508 is equity in action. When communities talk of doing the work, this is the work. Creating policies and structures that speak to power and change systems. Insecure housing affects people pushed to the margins in greater proportions, and this bill would begin to change a system that has historically favored people of a certain race, citizenship status, class, and gender. LD 1508, equity in action. I strongly urge you to support LD 1508, and I thank you for your time and attention.
Thank you very much, Ms. Layton, for taking the time out of your day to testify before the committee. We greatly appreciate your insight. Are there questions from committee members for Ms. Layton? Seeing none, again, thank you very much for coming before us this afternoon.
Thank you for having me.
And I will take one more look in the attendee room. Are there any persons who wish to testify in support of LD 1508? Seeing none, I will turn to those who have registered to testify in opposition. And the first person on my list is Daniel Bernier. Mr. Bernier, nice to see you again this afternoon. You know the drill. As soon as you're ready to go, please present your testimony.
Good afternoon. I apologize. This is the fourth time today you've had to listen to me testify, but it will be the last. My name is Dan Bernier. I represent the Central Maine Apartment Owners Association. I'm a resident of Waterville. To start out with, we're okay with mandatory mediation, the one-page notice that Maine State Housing would prepare, and ensuring that you have quality mediators. The issue with this bill is the process that is set up in it is either going to lengthen the process or it's just not going to work the way evictions work. So the process of how you get to mediation is a big issue. I also have some issues with attaching the lease to the complaint. Pre-COVID, you would go to court, the court judge would do a docket call, you'd go to mediation, and then after that, you would have a hearing all in the same day. That settled a lot of cases. The fact that if you didn't settle at mediation for both the landlord and tenant, they knew the next step was 15 minutes later, you were going to be in front of a judge explaining your case, got both sides to be very reasonable. I found under that system, I probably tried 1 in 20 cases, 19 out of 20 settled. Under COVID, partially because the courts don't want 100 people showing up on the same day for eviction hearings, they've gone to a process where you have a telephonic court call. A few weeks or maybe a month later, you have mediation. And a few weeks or maybe a month later, you have your final trial, maybe longer. Depending on which court you're in, understand in rural courts, you might only have eviction days once a month. And there's some courts, it might even be once every other month. So this three-step process can really lengthen the eviction process. And that's our big issue with this. I've seen under this process, one, I've got a lot more contested cases. I know Legal Services for the Elderly hasn't had as many. I actually take some referrals from them. I think there's partially, they also have a screening process and they have some processes that reduce the number of contested cases. Because tenants have figured out they can get 2 or 3 months free rent under this system if they just ask for a trial, I'm finding fewer tenants are settling cases and we're going to more contested hearings. And I've seen the arrearages go from maybe 2,000 to 3,000 on an eviction to 5,000 to 10,000 that a landlord loses under this longer drawn out process. The other thing is, I will do a memo. I can't do it in 3 minutes. The process on an eviction, understand eviction cases are often filed with the court a day or two before the hearing. So there is no written answer, which this statute contemplates. The tenant shows up on the day of the hearing, and by showing up, that is their answer. This proposed statute contemplates a written answer, doesn't happen, and so the process for getting there does not work in this bill. Senator Carney has been very good about reaching out to us and trying to work out these issues, and I think some of the process issues can be worked out, but we can't lengthen out the eviction process. It's going to cost landlords money. And again, it's an incentive for tenants not to settle. From there, the one other thing I'll mention on the lease, I don't know that attaching the lease adds too much. And the more
I will need you to wrap it up, Mr. Bernier. I'm sorry to interrupt. We'll need you to wrap it up.
I didn't see that. I think you want them to read the one-page notice from Maine State Housing. The more you attach, the less they read. So I think if you attach the lease, you're going to reduce the likelihood they read that notice. And there are lots of cases where there's a question if you're still under a lease, where your lease expired. So I don't know about attaching the lease to the complaint. I'm sorry, I went over.
Thank you very much, Mr. Bernier. Questions from the committee? Representative Sheehan.
Thanks, Mr. Chair, and thank you again, Mr. Bernier. Your testimony has been super helpful today. But I just wanted to make sure that I had it clear. If there was a process that keeps the eviction proceedings within the existing time frame, this is something that you could get on board with. And possibly attaching lease. Okay, thank you.
Exactly. That's my biggest gripe is that the keeping it within the existing time frame.
Thank you.
Thank you, Representative Sheehan. And I did not see the order that the hands went up. I was taking notes. I will give deference to Senator Keim.
Well chosen. Mr. Bernier, thanks for being here and giving us all the sort of boots on the ground, real life perspective on these bills. It's very helpful. I know we've had a long discussions around all landlord tenant issues, but your comments today on this bill, are they part of a testimony that we can read online to finish up?
I will put them in writing. If there's a prior bill you weren't here, just the number of bills, I wasn't able to get them everything in writing. Tomorrow, I'm actually gonna have time to breathe between bills, so I will put some stuff in writing and get it filed with the committee on this and one of the other bills.
Yes, I did hear your answer to that on another bill, but I just wanted to check on this one specifically as well. Thank you so much.
Keim, Representative Moriarty.
Thank you, Mr. Chair. It must be nice to have time to breathe between bills, Mr. Bernier. Some of us don't have that luxury. I wanted to ask you, you described, I guess, a prior system or a construct in which there was some mediation involved and you solved 90% of your cases without having to go to court. What system or structure was that? And is that still in place, or did COVID interrupt it?
Sure. You had a voluntary mediation program. I actually, at one point, in a meeting comment to Senator Carney, I pretty much viewed mediation as mandatory because at least in this area, the judges get irritated if you don't agree to go to it. So at least in Waterville, Skowhegan, Augusta, where I tend to do most of my practice, there's a mediator there. And while the judge maybe can't require you to go to mediation, the judge strongly suggests it. And so you go in, the judge calls the docket, they find out who shows up. If both parties are there, our judges very firmly suggest you go to mediation. Let me put it to you that way.
I understand.
And I kind of like the mediation, to be honest with you. I find if I settle at mediation, the apartment's less likely to be vandalized when the tenant moves out than if I take it to trial. I mean, that's because they feel like they got something, like they were treated fairly. And so the other thing is, before I go in and try a case, you don't have a lot of trial prep on evictions. I can also kind of at least hear what the tenants got to say before I decide, do I actually want to try this case? So I personally like mediation, but then immediately after that, you'd go to trial. So I always agreed to go to mediation. I realize some people might refuse, but yeah.
So is that still in effect at this time in that region?
Well, I'm assuming we're going back to it once COVID is over. You have this 3-step process under COVID, because pre-COVID, understand the courts didn't control how many eviction cases came in one day. Waterville District Court might have 5 cases, they might have 30 eviction cases. Under COVID, you want to avoid 30 cases with 60 or 100 people showing up at one day in a small courthouse. So they've gone to this system so they can control the number of people walking into the courthouse on a single day. I'm assuming we go back to that system once COVID is over. And the other thing is, under Senator Carney's bill, if we want to give the judge more teeth in saying you are going to mediation for those who refuse it, I don't have a problem with it, because to be honest, I think you're a little foolish if you don't go to mediation when the judge is suggesting it, as long as it's on the same day.
Good, thank you.
Thank you, Representative Moriarty. Are there additional questions for Mr. Bernier? Seeing none, you're released for the day, sir. You can go read all those bills you haven't had a chance to read. But thank you very much for your time and testimony today. The committee greatly appreciates it. The next, although I will check, final person I have registered in opposition to LD 1508 is David Chamberlain. Mr. Chamberlain, as soon as you're ready to go, just begin your testimony after unmuting your microphone.
Yes, thank you, members of the Judiciary Committee. My name is David Chamberlain, and as I said earlier, we have a boutique practice that totally represents landlords, property management companies, property owners throughout the state of Maine, as small as a single family residence to all the federal subsidy portfolios and thousands and thousands of units throughout the state of Maine. Ned Payne, testifying in opposition to LD 1143, said it best. The eviction process is cumbersome, time-consuming, and expensive. And the proposed legislation, which codifies PMO order of the Supreme Judicial Court, the Pandemic Management Order number 6, to temporarily govern eviction proceedings in a pandemic due to the health crisis through June 30th, this makes it permanent. And the process is further cumbersome, time-consuming, and expensive. Just for an example, an initial court date in one of the York County courts as of April 15th was for the initial telephone status conference to be June 4th. That's 6 weeks away. So there is, and that's just to start the process. This bill also makes optional mediation, which was enacted in 2007, virtually mandatory, and makes supposed neutral mediators decision makers, housing advocates, and removes their impartiality. I was part of the crew that trained the mediators back in 2007 and 2008 at 4 different sessions, and I've attended numerous mediations throughout the state. A mediator is supposed to be impartial and neutral. This bill makes them to be trained in eviction prevention, have knowledge of community-based resources, have reasonable knowledge of rental assistance programs. It makes them decision makers to determine who is can attend the mediation to be an effective mediation, including housing officers. The mediator under subsection 5 may refer the defendant to legal assistance hearing. And at the end of the process, if the tenant fails to appear and the landlord has appeared at every proceeding, the landlord must still prove their case. They're not entitled to a default judgment under the pandemic order as written. They still have to prove the elements of their case. That is just insulting to a landlord who's had to wait all that time to get to court, and the tenant hasn't appeared, and then they still have to prove the elements of their case. This is totally one-sided and in favor of the tenants.
Thank you very much, Mr. Chairman. I'm sorry to have to interrupt you, but I did let you go over the 3-minute time period. Are there questions from committee members for Mr. Chamberlain? Seeing none, thank you very much for spending so much of your day with us and providing information and expertise on this issue. The committee greatly appreciates your time. It appears we have an additional person who would like to testify in opposition to LD 1508. I welcome to the committee Samuel Sherry. Mr. Sherry, thank you for being here today. As soon as you are ready to testify, you may begin, and I will let you know when we're getting close to 3 minutes.
Thank you so much. Honorable legislators, gracious staff, I'm Sam Sherry. I am here as a board member of the Southern Maine Landlords Association, 4 decades old, 500 strong, small business landlords in Cumberland, York, Saginaw, and Androscoggin counties. And I represent 4 of the 6 landlords that aren't clients of David Chamberlain. This bill does 4 things. It curtails judges' discretion about which cases go to mediation. It adds weeks or months to the process when tenants don't bother to show up for court. It spends $1 million based on assuming that more money means more representation for tenants, and I'll talk about that in a minute. And it moves the existing eviction mediation program from the civil rules to statute. SMLA is against the first 2. We support a study commission with respect to the 3rd, and we take no position on the 4th. Dave and Dan talked about the curtailment of judicial discretion, and I'll let that sit. Dave and Dan talked about the default process and how this bill lengthens that process, which is a burden on landlords and on good tenants who suffer from bad tenants. I'd like to focus on the funding. I value my professional relationship with Pine Tree and with Legal Services for the Elderly, and my written submission spells that out in detail. Pine Tree benefits from the best commercial ever. It goes like this. Hi, I'm Judge Kelly. I'll be calling your case in a minute. That's Attorney McGovern. She represents tenants for free. If you need her, all you have to do is say so. Despite that commercial, about half of tenants decline and self-represent. The Affordable Housing Coalition report could have answered the questions: how many tenants choose to self-represent? Why do people choose to self-represent? Is tenant self-representation something the state should address? How much money is required to address it? And what is the best way to do that? Because they took that database and declined to address the fact that so many people know about Pine Tree and choose not to have representation, the report is flawed, the bill is flawed, the funding is flawed. I'm out of time. Thank you for your patience.
Thank you very much, Mr. Sherry, and thank you for keeping it under 3 minutes. You must have a clock there.
I do.
You mentioned that you submitted testimony.
I was the last person in the door, Representative Harnett. It went in about 10 minutes ago.
Okay, and you put it in on this bill, because I know we've had a slew of bills today. So
yes, sir, I did. And you have been really busy today, and I've stood and watched through all of it. It's a testament to your competence and patience on the committee. Thank you for your
flattery
service.
will get you everywhere, Mr. Sherry. Thank you. Are there, and again, thank you for your testimony. Are there questions from committee members? Senator Keim.
Thank you, Mr. Chair. Mr. Sherry, I just wanted to clarify one thing. I think you mentioned something about questioning why tenants would choose to self-represent even though they have the availability of Pine Tree Legal. Could you just explain that a little better? I don't think I quite understood what you were saying there.
Thank you, Senator Keim. I'm happy to give it a try. Every party in court at every eviction in court gets to hear about how Pine Tree is present and available and free, and tenants can have that for the asking. And yet, about half of those tenants don't choose representation from Pine Tree. That is an actual option. I don't know why they do it, but the Maine Affordable Housing Coalition report, it does a great job of talking about how many of those unrepresented tenants there are. But what it didn't analyze is how many of those people heard the lecture about Pine Tree and it didn't reach them. So if you take that $1 million and you give it to Pine Tree, it's not going to change the fact that that incredible lecture from the judge didn't do the trick, didn't bring them across the threshold to Pine Tree. What's going to do it? I don't know. With respect, nobody seems to know yet. Let's find out. The Southern Maine Landlords Association is not against Pine Tree, is not against legal services for the elderly, is not against more funding. We don't really cotton to random funding.
Okay, and then just to clarify, you didn't actually mean an ad that the Pine Tree has that plays in courts, but it's the informative. But it's an informative.
It's better
thing.
than that. It's
right,
better than that. The judge stands up and says, "This is Attorney Parisi. She's from Pine Tree. All you have to do is say the 2 words Pine Tree, and you get a free lawyer, and a good one, a really good one."
Okay, so I understand. So a judge says that. It's
judge.
not a pre-recorded thing. The judge says that at the opening.
Yes, exactly that. It is better than any ad that $1 million can buy. And yet, it only reaches part of that crowd. How come? What could be done better?
Thank you. Thank you, Senator Keim. Representative Sheehan.
Thanks, Mr. Chair, and thank you for your testimony, Mr. Sherry. So I heard representatives from Pine Tree testify that they were significantly limited in their capacity to represent clients. And I'm trying to understand what you're saying. You're saying that that's not a problem and that's actually not true, or just trying to square the two, the testimony you just gave with what I heard from Pine Tree?
Thank you for your question. My testimony is about how tenants choose not to be represented by Pine Tree. Pine Tree is one of the, I don't know, 10, 15 largest law firms in the state. They have something like 40 lawyers on staff and a bunch of incredibly sharp paralegals too. I don't know how they make decisions about how to allocate staff. I don't know how those decisions affect where they're able to represent people or how many people they're able to represent. It's not a good topic for a landlord lawyer to be chatting with Pine Tree about. It's none of my business. No, no offense to Pine Tree.
Thank you, Representative Sheehan. Additional questions, Representative? Seeing no, are there other members of the committee that have questions for Mr. Sherry? Seeing none, thank you very much for your time today and for sticking with us since 9 o'clock this morning.
Thank you. It's a privilege.
Those are all the folks I've had testifying in opposition. I'm going to give one more shot. Is there any person in the attendee room who would like to testify in opposition to LD 1508? Please raise your electronic hand. If so, seeing none, I will now turn to those who have registered to testify neither for nor against. And I will begin with Cullen Ryan from Community Housing of Maine. Welcome to the Judiciary Committee, Mr. Ryan, and please begin your testimony as soon as you feel comfortable. Thank you for being here.
Thank you, Representative Harnett and Senator Carney and members of the committee. My name is Cullen Ryan, the Executive Director of Community Housing of Maine. I've been working in the field of working in homelessness for 34 years. We're the largest housing provider, supportive housing provider for homeless populations. I testify neither for nor against this, and essentially the issue here are there's two of them. The first part is it's not with mediation. We use this all the time. It actually works really well. We'd like to see this supported, but the way that this is written would significantly lengthen an overly lengthy process, and that extra time poses significant risk for the population that I serve. As Daniel Bernier said, it has to be on the same day for this to work. And the second concern really is with the funding source. Taking this out of the home fund, I think, is the wrong approach. It will subtract from affordable housing, which we desperately need. So I've outlined that more clearly. I will tell you that that my organization is a quintessential nonprofit. We focus on trying to house the most vulnerable and challenging populations. We take a leap of faith and bend over backwards to get them housed and to keep them housed. We really evict people. When we do, it's really because it's absolutely necessary. So we need to go through the eviction process after somebody abandons a unit so we can put the unit back into service. And I'll give you some examples below. And the other issue is with this is beyond what Community Housing Maine does. In order for us to end homelessness, we need all landlords to welcome in population to experience homelessness. And landlords simply won't take a risk on people if they believe it will be nearly impossible to remove them if things become disastrous. By making it many times harder or longer to evict people, the unintended consequences will ultimately be less housing for people who need it, which would exacerbate homelessness, the exact opposite effect of the bill's intent. I think this can be rewritten so that it doesn't lengthen the process, and I hope that in the work session that will happen with this bill so it can be effective. The fund is used for affordable housing. It's used for a whole bunch of other services. I really don't want to see funding pulled from that to do this, but we do need to fund mediation and the legal services so that tenants are adequately represented. That is a good thing. We need an efficient system of evictions, and we need to keep them rare while ensuring people are well supported during the process. So let's find another funding source to support tenants properly during evictions. And let's not make it impossible or take longer to evict somebody in an effort to improve the system. Let's craft better language to avoid unintended consequences. 3 examples, I've written them towards the end. One is I've got a person who was in a unit. He was refused to not smoke inside. He was intoxicated continually. When I went in there were burn marks all over his comforter. And it was apparent that he was going to burn this building down. It took us 3 months to get this gentleman out. Really scary amount of time for everyone and the neighbors. The people who said this person needs to go. Other 3 examples. Had somebody come in who was abusing them, and we can't get this person out yet. It's taking a long time. Another woman who
Mr. Ryan, I'm sorry to interrupt, but I did let you go beyond the 3 minutes, so I do need you to wrap up in a sentence or two, please.
Sure. So we have very challenging cases. We need to be able to help people to get out, and please adjust the language in this so that we can support people well. Thank you.
Thank you very much, sir. We greatly appreciate you taking the time, and it's always important for us to hear stories of real people with real struggles and experiences. Thank you for that. Are there questions from committee members for Mr. Ryan? Seeing none, thank you very much for being here today, and thank you for your written testimony, which the committee will thoroughly review.
Thank you very much.
The next person is a former colleague, Eric Jorgensen. Eric, welcome to the Judiciary Committee. Sorry, somebody's knocking on the door. And you can begin your testimony as soon as you're comfortable.
Thank you very much. Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee. My name is Eric Jorgensen. I'm from Maine State Housing Authority. I'm speaking here today neither for nor against this bill. Maine Housing sees this largely as a court-based program, and while we absolutely support the use of mediation, we do know well what it can do to improve tenant-landlord relations. You guys are the committee that figures out the policy. I'm really here just to talk about a couple of things. Most significantly, the thing that Mr. Ryan mentioned, I'm here to object strenuously to the bill's current funding source and to suggest alternatives. And I know that changing the funding source is something that Senator Carney offered to do. We just feel very strongly that this can't come out of the home fund. And I've included a rather lengthy disquisition, I guess, of what the home fund does and all about what it accomplishes in my testimony that you can look at. I just say that over the years, more than $83 million has been diverted from the home fund for other purposes in the last 15 years or so. And I think bills that seek to take money out of that for purposes like this seek to pit one important housing need, in this case, it's eviction mediation, against other important housing needs and like affordable housing construction. And so please, if you choose to advance this program, let's try to work together to figure out how to find a different source of funding. We do think that another viable source of funding might be the current federal emergency rent relief program. There's a provision within the current funding that provides some services for renters that includes mediation. We've got another tranche of money that we're expecting to have come over the summer, and we'll know more about that soon. We don't have long, extensive guidelines on that, but we think that might well offer a solution to fund this program, at least for the next few years. It's probably going to require some program design work. It'll probably require working with the courts and the sponsor, but we'd be very happy to try to figure out how to make that a reality. I also think you should look at the general fund. The general fund might be a source of funding in this particular year because there is going to be a lot more money coming into the state budget through from other sources, from federal sources. So the other small issue I just wanted to address while I'm here is the matter of the section 6004C sub 1B, which is the thing about the one-page form notice from Maine State Housing Authority, written in plain language and providing tenants the outlining of the eviction process. Our legal department has a few concerns about whether such a notice might constitute legal advice coming from Maine Housing, and we can't provide that. So we'll be willing to participate in the development of that. We just may not want it going out under our name. So that's about it. I just want to say that we really appreciate the really meticulous work that Senator Carney does and her work to design this particular program. And we hope we'll have the chance to work with her and others to figure out how to make this all work. So thank you very much. And thanks for looking out for the home fund.
Thank you very much, sir. It's very good to see you again. Thanks for being in front of our committee this afternoon.
Good to see you all.
Are there questions from committee members for Eric Jorgensen? Seeing none, again, thank you very much for your time and also for the written submission that we will again review.
Yeah, you're very welcome. And I sent in something this morning with some information that turns out to have had a mistake in it. Of course, I wrote it very quickly and sent it off. So I'm going to be sending you a revised copy in a couple of minutes.
We will look for it. Thank you very much.
Okay. Thank you. Bye-bye.
And seeing no questions from Mr. Jorgensen, I will now move to the last person who's registered to testify neither for nor against, Julia Finn. Ms. Finn, welcome again to the Judiciary Committee. Please begin when you're ready to go.
Thank you. Good afternoon, Representative Harnett, Senator Carney, members of the Joint Standing Committee on Judiciary. I'm Julie Finn and I represent the judicial branch. As you've heard today, LD 1508 establishes an eviction mediation program to provide mediation services to the parties in FED actions as part of a 3-step process that could involve an initial telephone conference, then a mediation, and then a final hearing. This program is similar to the process that was developed and used when eviction cases were first resumed in August of 2020, after the hiatus in case processing caused by the pandemic. However, the 3-step court process set out in the bill is quite restrictive and resource intensive and is probably not sustainable for us in the long run. The process described in LD 1508 is very specific. It requires an initial telephonic conference and directs how the judicial officer must rule based on different procedural developments in a case. This approach limits the judicial branch's discretion in establishing our own court processes and judges' discretion in adjudicating disputes. We need flexibility to control our dockets and be nimble enough to alter procedures when needed. Further, the bill would make the 3-step process that was set up as a temporary measure in order to resume proceedings in eviction cases during the pandemic a permanent fixture of Maine's eviction process. When eviction hearings resumed, we added the initial telephonic court conferences to the existing process because we were actually unable to assure both the parties access to and the reliability of remote video court proceedings. As pandemic restrictions are eased, these telephonic conferences will not be necessary in all cases. We recommend that the judicial branch be permitted to determine when and how it should use the telephonic conferences to control dockets and manage our cases. Similarly, mediation will not be necessary in all cases. We recommend that mediation be available at the request of a party or by order of the court. Despite improvements in the court's ability to conduct reliable remote video proceedings with Zoom, the courts continue to wrestle with how to address evictions in a fair and timely manner. For example, due to the potential for an exhibit-laden hearing and a summary proceeding, the cases that do not settle proceed to final hearings in the courthouse that the parties must attend in person, unless a judge has given specific permission for the party to participate remotely. It is no secret that courts are backed up due to the effects of the pandemic. The judicial branch was under-resourced prior to the pandemic and remains so now. As the pandemic recedes, the judicial branch cannot take on additional programs or costs without appropriate fiscal support. I'm almost finished. I just have a little bit more, if I may. The judicial branch does support the bill's provisions to provide the parties with information regarding available rent relief and housing services, to facilitate tenants' access to legal assistance, and afford meaningful opportunities for settlement and mediation as early in the eviction process as possible. And we always stand ready to serve as a resource to the committee and to provide information on the procedures and practices that the court has followed in these actions, both pre and post-pandemic, and found to be effective in addressing this important and challenging body of law. Thank you, and I apologize for going over just a little bit. I think that's the first time.
Thank you, Ms. Finn. Indeed, it is the first time that you've gone over in the 130th, but you had a couple minutes in the bank, although that's getting smaller and smaller now. But thank you very much for your testimony today. Are there questions from committee members for Ms. Finn? Seeing none, thank you very much, as always, for your testimony and for the written testimony that you submitted as well. Thank you.
Thank you.
I will take one more look in the attendee room. If there's any person who wishes to testify on LD 1508 in the neither for nor against category, please raise your electronic hand. Seeing none, having received testimony from all present today wishing to testify, I will now close the public hearing on LD 1508. Thank you, committee members, and thank you to all persons that came before to testify. And with that, I will hand the gavel back over to my Senate co-chair, Senator Carney.
Thank you very much, Representative Harnett. And we will launch into our last public hearing of the day, which is LD 1380, an act to increase protections for option contracts for the purchase of real property or rent to own real property. It's being introduced by our colleague, Representative Harnett, and you can proceed when you're ready, Representative.
Let me just switch gears here, but
Yeah, I should have given you a moment to catch your breath.
okay. Thank you, Chair Carney. I was optimistic. Good morning, Senator Carney and fellow members of the Judiciary Committee. My name is Tom Harnett, and I represent the residents of House District 83, which includes the town of Farmingdale and the city of Gardner. I'm here today to introduce LD 1380, an act to increase protections for option contracts for the purchase of real property or rent to own real property. I'd like to start out by presenting you with a little background about this bill. In the 129th, I submitted this bill in a different format as LD 1426. The bill advanced through this committee and was moved from both chambers on roll call votes. When it arrived at the office of the chief executive, it was held. I was asked to work with stakeholders, including an attorney who sometimes engaged in these types of transactions, to address the chief executive's concerns about this bill that had been raised by opponents. I did so along with other interested parties. Through a lot of work, we were able to reach a compromise addressing those concerns and other concerns that had been raised by opponents to the bill. One of the most significant concerns we agreed upon was to not include individual property owners from regulations in this bill if they do not use this approach no more than 2 times per year and not more than 4 transactions in a 5-year period. This bill is not seeking to limit, does not seek to limit the use of this form of a real estate transaction to anyone who is not engaged in rent-to-own real property transactions as a business. While you will hear from people far more knowledgeable than I am in this topic shortly, I want to share my motivation for introducing this legislation 2 years ago and reintroducing it today. For most of my life, I've heard about the American dream. For many, a significant part of that dream is home ownership. The hope that one can buy a home to provide shelter for one's family and perhaps create an asset to pass down to the next generation. Historically, for most people, that dream has been realized by securing a traditional mortgage with all of the legal protections that are provided to home buyers, including the right to certain foreclosure processes that recognize the importance of the single most important asset a person will ever seek to buy, their home. Unfortunately, for persons of limited economic means, that dream is often just that, a dream. Sometimes when dreams are out of reach, people take risks to obtain them. And often there are others who take advantage of those dreams and that risk-taking. Land installment contracts are one method by which dreams are crushed and lives forever changed because the legal system fails those who are trying to achieve the modicum of stability that home ownership can provide. The legal processes established by LD 1380 will protect those hardworking people trying to do the best they can to provide for their families and the generations to follow. LD 1380 will allow everyone who wants to buy a home to do so in a legal environment that protects both buyers and honest sellers. In a recent publication, the Federal Reserve Bank of Boston described the pitfalls facing those who try to become homeowners by agreeing to and entering land installment contracts. In that publication, the Federal Reserve Bank labeled land installment contracts as a vehicle that provides the illusion of home ownership. Consider their observations. While land installment contracts are marketed as an alternative path to home ownership, contract buyers almost never end up achieving ownership. The contracts are designed to fail. Successive cancellation allow the sellers to churn more would-be homeowners through the same property, creating more profit with each new contract. Land contracts are structurally unfair and deceptive without this law because they shift all of the burdens and obligations of home ownership to the buyers with none of the attendant rights or protections. Land contract buyers are typically obligated to make substantial repairs, which often include overhauls of essential systems like plumbing and heating or adding a new roof. Would-be homeowners often invest considerable sums just into making their homes habitable, livable, only to be evicted and lose everything after a default on payments. Independent appraisals and inspections are seldom performed, and the contracts often require buyers to pay grossly inflated purchase prices. Pre-existing liens and mortgages are sometimes not disclosed, and as land contracts are infrequently recorded, contract buyers' interests are often unprotected. In the 129th, we heard from persons engaged in this business who readily acknowledged that they marketed properties they could not rent to tenants because they were not habitable. Today, we can change this practice by moving LD 1380 forward. This bill will guarantee that anyone and everyone looking to buy a home can enter that process with the same legal protections those with greater economic means. Dreams thwarted are dreams denied. I ask you to encourage and protect those who dream. I thank you for your attention today. And I would be happy to answer any questions, but we do have a few experts on this area of law who will be testifying from both sides of the issue. And I want to encourage committee members. We get a lot of testimony through the portal, and there's a piece of testimony in there by Nicole Grant, who tells a story about her family's involvement with a land installment contract and how they ended up losing over $20,000 and losing their home. I appreciate your time and attention, and I look forward to working on this bill at the work session as we move forward. Thank you very much.
Thank you very much, Representative Harnett. Committee members, are there questions? I see that Representative Moriarty has a question. Go ahead.
Thank you, Madam Chair. Representative Harnett, it seems to me that the legislative history of this bill in the previous legislature is particularly significant. And I was writing as fast as I could, and I want to make sure I understand completely. Did the prior bill pass both houses?
Yes, it did, on a roll call vote in both chambers.
Okay, then I went to the governor's office and further negotiations took place, and the result was something that all parties agreed upon?
The result was something that all parties agreed upon. Then COVID happened. We continued the negotiations, and that ironed out some additional problems. And some of the parties to that negotiation are here today to discuss those.
And then finally, is 1380 the end product of the negotiations from last year?
It is. It is not the original bill that I put in the 129th. It reflects all of those.
All right, that's important to know. Thanks very much.
You're very welcome.
Excuse me, committee members, are there additional questions for the bill sponsor? I am not seeing any. I did have one. Actually, never mind, Representative Harnett. I think probably more appropriate for one of those who are going to testify shortly. Thank you for presenting the bill.
And thank you for holding that question.
Yeah, anytime. We'll move on to those who are in the attendee space. If you're here to speak in favor of 1380, please raise your electronic hand and we will bring you onto the panel one at a time. And first we have Paul Mills. And Mr. Mills, when you are able to, you can activate your audio and video and proceed.
Okay. Yes, it's a pleasure to be here. I do want to confirm and verify what Representative Harnett had mentioned about there being some negotiations. My role was I represent people, typically people who are in the position of providing financing on a private basis Some of these people do this 2 or 3 times a year. They're not on the level that I think that existed in the Bangor or Ellsworth area where certain abuses apparently occurred that occasioned this legislation. But I was concerned that there was insufficient latitude in the way the bill was originally enacted for more low-scale situations, because many people do benefit. Many consumers who are trying to purchase homes in the state of Maine have benefited enormously from the procedure of either rent to own or installment sale contracts, oftentimes drafted by sellers who don't even use attorneys. They go draft the thing online. And I was concerned a little bit about some of the requirements might be quite onerous for people who are typically not using legal counsel on either side. These are people who are small-time financiers, and what they're doing, or sometimes they're simply sellers who are trying to facilitate a transaction because the purchasers do not qualify for conventional or institutional financing. Typically, there's very little down payment. And so since there is so little stake or skin in the game in the part of the purchaser, understandably, these instruments or vehicles play an important role. And I haven't really seen, in the number of years I've been practicing and doing a lot of these real estate transactions, oftentimes involving the rent to own or the installment sale contracts, sometimes come to me after the fact. They've already drafted them, they've recorded them, or done something, and they want me to work something out because people don't oftentimes use lawyers on a smaller scale basis. So I felt it was important, and I think this legislation as revised does address the need to facilitate this vehicle to be used for many people who want to buy homes that just can't get financing out of the place with no down payment available to them. And understandably, the DAC is going to be stacked a little bit in favor of the sellers when there's no investment initially. But I think that this legislation as revised does carve out sufficient protection for utilization of this procedure, which I think is a very worthy one.
Thank you very much, Mr. Mills. Committee members, are there any questions for Mr. Mills regarding his testimony? I am not seeing any questions for you. Thank you very much for providing the information today.
Okay, Senator, thank you.
Next, we'll call on Chet Randall. He'll join our panel momentarily. Welcome, Mr. Randall. You can go ahead when you're ready.
Thank you, Senator Carney and Representative Harnett and members of the Joint Standing Committee on Judiciary. My name is Chet Randall, and I am the Deputy Director at Pine Tree Legal Assistance, and I live in Portland, Maine. I apologize for the lighting in the background. I didn't have a chance to sort that out. I am here today to urge you to vote ought to pass an LD 1380, and I do want to note that Representative Harnett's overview of the bill was an excellent one, as were the comments of Mr. Paul Mills. I have been engaged in eviction prevention and foreclosure prevention efforts to stabilize housing on behalf of Maine residents for more than 15 years. LD 1380 seeks to provide protections to prospective home buyers when involved in the option to buy or rent to own transactions. Currently, option to buy or rent to own transactions are not regulated or controlled by any law or rule, and as a consequence, when abused, it results in exploitation of potential and prospective homeowners. It has also left both unsophisticated parties with no guidance on what is necessary or prudent steps to take to implement such agreements, much as Attorney Paul Mills noted. These are transactions. The options to buy and land installment, options to buy and rent to own transactions are not land installment contracts, which are in fact subject to an existing statute that provides structure, parameters, and expectations. These option to buy or rent to own transactions are merely terminated by an eviction, as opposed to a land installment contract, which is terminated by a foreclosure for the reasons that Representative Harnett mentioned, which is the importance of the ownership and purchasing process. Like many other home purchases transactions, these often involve an initial payment by buyers that frequently range from $5,000 to $10,000 to $30,000. Notwithstanding Attorney Paul Mills' comments, our experience at Pine Tree has been we have seen these large and substantial down payments solicited by potential buyers. One client story illustrates the problem that can arise. In November of 2020, Mike signed an agreement captioned as a lease with purchase to option that required him to pay $1,000 a month, where $450 would go toward a down payment. In 20 years, they had the option to purchase the 1991 mobile home on 2 acres for $129,000. Mike agreed to pay $12,000 upfront for what the client believed would go towards the down payment. Under the agreement, Mike was responsible for maintenance, insurance, and property taxes, just like many homeowners. Mike fell behind on monthly payment, and the landlord began an eviction to eject Mike and his family while keeping the $12,000 and all payments and all improvements to the property done by Mike, because there is no requirement that any of that money be returned. And every other legal engagement or legal arrangement for the finance of a home, the home must be foreclosed on before the home can be taken away from the buyer. The foreclosure process allows greater protections, including mandatory mediation and full civil procedures, unlike the eviction process. LD 1380 seeks to strike a balance in these transactions.
Randall,
yes.
The 3 minutes is up, and I know that there are going to be some questions for you, if you don't mind.
Well, thank you very much, and I do urge you all to vote ought to pass as drafted. I'm happy.
Thank you. I'm going to start with a question. Can you describe the scope of this problem for us, please?
Yeah, I'd be happy to, Senator Carney. Thank you for the question. More recently, in the last, I would like to say the last decade, we have seen an increase of activity by companies that are using option to buy or rent to own transactions. And you can see them occurring where these documents have been copyrighted. And they often remind me of these fly-by-night, get-rich schemes on buying up foreclosed properties or substandard housing and reselling it in this context. We've been seeing an increasing rate and volume of these kinds of transactions. You can even find these listings sometimes on websites that are advertising no credit score needed, rent to own, option to buy, sweat equity. And the activity is increasing dramatically over what we have seen over a decade before. And so it's been a problem that's on the increase. We've had a number of cases with a fact pattern, just like the one I described for Mike, in which people have lost substantial amounts of money and not been able to recover it after they've been evicted. We have seen these cases arise in the context of eviction proceedings as opposed to foreclosure. And if we're able to get involved at Pine Tree or have capacity, that's when we would try to unravel the transaction and get the funding returned and avoid an eviction if possible. But it's with increasing frequency, Senator Carney, that has brought this issue to our attention over the last several years.
And then Mr. Mills mentioned something about Bangor. Is there a part of the state where these transactions are happening more frequently than other parts of the state?
There was a company in the Bangor area that was actively engaged in the use of land installment contracts as an alternative finance tool. The worry we had for that was it was intended to evade the serious financial consumer protections such as the Truth in Lending Act. They also were using some rent to own and option to buy, but we have seen these occurring in Bangor, the Augusta region, as well as the Sanford region with some regularity. So it's really been across the state. And I've been hearing from our attorney, Matt Dyer, in the Presque Isle office, that there was a spattering of properties purchased by a company, a holding company, that was engaged in the same option to buy land installment contract. And he speculated they had between 5 and 20 properties.
Thank you for that additional information. I see that my colleague, Representative Thorne, has a question for you. Go ahead, Representative Thorne.
Thank you, Madam Chair. Mr. Randall, what you're saying reminds me of a Choctaw Bingo song by Ray Wiley Hubbard. Owner financing, and they know they're going to default and they take it back. Is that pretty accurate?
That's exactly accurate, Representative Thorne. That is correct.
And I'm also thinking of buyer beware and sold as is and conditions and terms agreeable to both parties and that sort of thing. On this bill in particular, enact increased protection for option contracts. what is it that is proposed that the law would do in a nutshell?
That's a great question. First of all, what it would do is if there's a clear definition for option to buy or rent to own in the statute, it then requires a writing, so everything is done in writing. It requires that there be a representation by the seller that the property meets basic habitability standards and is safe. But then it also allows that in the event that the seller is a single individual's first transaction, it doesn't change the process at all. That buyer beware notion that you noted about, and allows the use of an eviction. If an entity is engaged in 2 or more transactions in a 12-month period, all the protections are implemented, including a requirement that if the creditor wants to evict, they're going to have to refund the down payment. They're going to have to refund those portions that were supposed to be allocated from the monthly payment to the down payment before they can use the eviction process. Otherwise, it would require that the entity, the creditor, in my view, uses the foreclosure process and the homeowner has all the protections set out in the foreclosure statute that this committee has worked so hard to implement in the past. So those are some of them, Representative Thorne. The piece for us, I think, that is most important, it has the opportunity to make the buyer whole in the situation where the property is either completely substandard, it's been a bubblegum renovation or cover up of problems with the property that must have been known or must have been known to the seller. There is, I just want to point out Representative Harnett's comment was really a poignant one, which is these folks are often very poor, low resourced, are not going to be the folks who are going to be able to go out and hire somebody to come do an inspection for $300 or $400 when they're being asked to give up $5,000 to try to obtain that dream. So they're at a disadvantage when it comes to information as opposed to the sellers in some situations.
Thank you. A follow-up question, Madam Chair?
Yeah, go ahead.
Thank you. Which leads me to the question, Mr. Randall, at what point would an advocate step in on it if I'm making a purchase on my own, dealing with a private entity? How would anybody know to come in at protection, or is this something that would kick in after the fact if I'm in duress because I can't meet the conditions of my agreed terms?
That's also another very good question, Representative Thorne. And it's, as always, with respect to consumer protection, it's hard to inform the public of what their rights are and their opportunities. Pine Tree has made it an effort ever since our founding to try to push out as much information to the public to inform and educate so that they understand their rights and responsibilities under a statute like this. I would expect that we would be seeing these cases potentially in eviction court when it shouldn't ever have gone there, and we would be trying to defend against an eviction. It may be that we see these transactions after a buyer has been served with a foreclosure complaint, and we're trying to understand what happened. But it's usually, unfortunately, in many situations, going to be the case that we're seeing these as attorneys in a defensive mode where the person is facing homelessness. And the loss of their limited resources via the down payment, and they're trying to figure out what to do, and often, as you can imagine, desperate.
Great, thank you for helping to explain. Thank you, Madam Chair.
You're welcome. Committee members, are there additional questions? I'm not seeing any. Just one other question for you, Mr. Randall. When the bill sponsor referred to the concept of churn, does that mean that one party might be selling the same property to a number of people over time and basically taking advantage of them, different people kind of serially with the same property?
Thank you, Representative Carney. And what Representative Harnett mentioned is absolutely right. Well, one of the things that has been studied and understood about these transactions is that often, I didn't get to explain that option contracts rent to own often have an expectation that the buyer will actually go out and get financing to pay that purchase price. In the case of Mike, that $129,000. Often these are folks who are not eligible for traditional financing, can't be because they're too low income, or their credit score is non-existent or just terrible. And the reality is the transaction is not going to occur, as the study referred to by Representative Harnett has found. And what ends up happening is these purported sellers, or as we call them in the statute, vendors, just churn the property. They'll evict the person and then move on to the next, put it back on their website, have it listed again. Another person comes in and tries it. I had one client out of the Augusta area where it appeared, after we were able to dig in for a while, that the property had been sold in the same form or fashion at least twice, and we suspected 3 times.
Thank you for the additional information. Any other questions, committee members? Not seeing any. Thanks once again for appearing before our committee today. And we'll bring, I think, the last person to present on this bill is Mr. D'Alessandro, who I believe is coming to join us in a moment. And Mr. D'Alessandro, if you can activate your audio and video and proceed when you're ready. And in the meantime, if there's anybody else in the attendee portion of the meeting who wishes to testify on 1380, please raise your electronic hand. And Mr. D'Alessandro, you can go ahead.
Okay. Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Frank D'Alessandro. I'm the Director of Litigation Policy at Maine Equal Justice. Maine Equal Justice supports LD 1380 because it would protect low-income Mainers who cannot afford traditional mortgages from predatory lending practices. I'm not going to go over what's already been said. I totally agree with Representative Harnett's description, and also Paul Mills and the negotiations that happened around this, and what Chet Randall also said. I would point out that one of the other protections of this law is it requires that the option contract be recorded in the Registry of Deeds. And this is because often, even if the purchaser makes all the payments, at the end of the day, what's turned out is that the vendor has actually taken out other loans on the property. I had a case where I represented a client where the vendor did not record the contract with the Registry of Deeds. The purchaser made all the payments when due, only to find out that during the course of the contract, the vendor had put the real estate up as collateral for other loans. And so that our clients came behind those other lien holders. And so this bill seeks to remedy that problem by requiring that the contract be recorded in the Registry of Deeds so everyone is on notice. The other big thing, one of the other protections here is about the requirement that the property being sold, the residence being sold, be in compliance with the Maine Warranty of Habitability Act. When we did the hearing on this 2 years ago on the original bill, there was a landlord from Bangor who actually had a bunch of units condemned by the city because they did not comply with the local code or the warranty of habitability. And his solution was to put these on the market and do these rent-to-own land installment contracts. And so this also prevents that from happening by requiring that the seller or the vendor certify that the unit is in compliance with the Maine Warranty of Habitability. Because one of the things that we have found that I found in my experience, and Pine Tree and Maine Equal Justice have found in their experience, is that often the units are in very bad shape. And one of the reasons the purchaser can't make the payments is that they are responsible to make all the repairs, and the repairs can be really substantial, and they don't have the money to do that.
Thank you so much, Mr. D'Alessandro. I forgot to turn on my timer, but it's almost 3:30 and we actually haven't even started our afternoon work today. So if you don't mind.
So I just strongly urge the committee to support this piece of legislation. Thank you.
Thank you so much. Committee members, any questions? I am not seeing any. And with that, thank you very much, Mr. D'Alessandro, and we'll close the work session, the public hearing, excuse me, on 1380. And we have a number of work sessions that we are going to launch into this afternoon. I just want to check in with committee members and with our analyst and our clerk. It seems appropriate for us to take some sort of a break before we start the work sessions. Is resuming at 3:30 or 3:35? I would like people to weigh in on that. I see a couple hands up. Go ahead, Representative Evangelos.
Thank you, Madam Chair. Just to expedite things today, I didn't ask any questions, but we've got a very difficult day tomorrow. We've been going all day here. I think we should table these work session bills in about a half an hour. I'm not ready for tomorrow. There's 20 divided reports. I haven't studied because we're working nonstop. You know that. We all are. I'm not being critical. I'm just telling the truth. I need to get ready for tomorrow. And I assume the political parties will be congregating or doing something later today. I don't know what your schedules are, but I'm not ready for tomorrow and I need some time. I don't know how the rest of you feel, but I need some time to get ready for tomorrow. And I've been up since 4 in the morning getting ready for Thursday on testimony. And, there's a limit.
Check in with others just because I get a clear sense of where you are, but I just don't know where anybody else is on it. Representative Moriarty.
Madam Chair, I just want to ask, was there opposition to 1380?
No, there was nobody who had signed up to speak in opposition.
Okay.
And nobody raised their electronic hands.
All right, thank you. I didn't hear that. Okay, thanks.
Representative Libby.
Thank you. I'm sorry, I'm just popping back in here, but I just wanted to say in regards to continuation today, those of us in the House Republicans have caucus at 4:30. Just so folks are aware of that, but other than that, I'm not opposed to continuing for a bit yet.
Other contributions? Representative Moriarty, is your hand up anew or?
No, I just took it down, but that's a good suggestion. If our Republican colleagues have to leave in an hour, I think we ought to keep working until that time.
Peggy and Soupy, can you hang in there with us for about another 45 minutes or so? Representative Thorne?
Thank you, Madam Chair. And in response to Representative Evangelos, I won't ask any questions on Thursday.
All right, that's recorded. Senator Keim, is it okay with you if we go for another 45 minutes or so?
Yes, absolutely. And I mean, I agree. We need to end in a timely fashion today because we all do have to prepare for tomorrow.
Okay. Can you live with that, Representative Evangelos?
Yes, that's a good suggestion. Thank you.
Okay. Thank you, everybody. Something that I did want to bring up and is that we have requested some committee bills related to the work that we've been doing on indigent legal services. And I think what I'll do is email those to everybody. And then if we can find a little bit of time to talk about them on Thursday, that is probably a good way to proceed. So I'm going to open the public hearing on, the work session on LD 741. That is an act to establish a Bill of Rights for Maine residents 65 years of age and older. I know that the bill sponsor is in the attendee space, and I'm just going to bring her over quickly to check and see if she had a proposed amendment. And Peggy, did you receive a proposed amendment on this bill?
Yes, Representative Warren actually emailed it, and I think she submitted it into the portal.
Okay, I didn't see it. I'm not sure when that happened, but she is here before us. Representative Warren, welcome to the work session on 7:41. Can you activate your camera and your audio, please? Hello.
Hello, hello.
So we understand, I guess, that you have submitted an amendment. And let me just check in. Peggy, did you do any analysis on the amended language?
No, she actually submitted it this afternoon while we were, she definitely worked on it and she can walk through it, and I would be happy to screen share if that would be helpful to you.
Okay, is that helpful to you, Representative Warren?
Yeah, sure. I had thought I had sent it the day of, and I clearly did not. I'm so sorry for that. So, but I'm happy to take your direction. But yeah, I just want to apologize for that.
Okay. All right. If you can, Peggy, if you could please screen share it, and then Representative Warren, if you could walk us through it, that'd be really helpful.
Okay, so this is her discussion, and then here's her text. Let me know if you can't see that. This is existing law. No, this would be new definitions to Title 38, Section 574. Representative Warren's going to walk you through this, right?
Yes, Representative Warren, maybe you can go ahead and sort of lay a little bit of the framework for us and then walk us through the language.
Absolutely. So this concerns the establishment of the Maine Climate Council and provisions therein. It is attempting to be more affirmative with the human rights for protected classes and others who would be disproportionately impacted potentially by both environmental degradation that the Maine Climate Council attempts to remediate for, or in other ways redress, and the definitions that I believe there are 6 here, that those are terms that are relevant to the pieces that I think are on the following page. Yeah, so these are just a couple of the places under that that act concerning, I think it's a green jobs and the establishment of the Maine Climate Council, that basically attempts to say part of the mandate is a little bit more robust and explicit in the protections of disproportionately impacted or protected classes, where right now there's a few different pieces of language that basically say that the mandate of the council is to encourage diversity, equity, and inclusion. I think that it's basically saying that any further findings or recommendations have to account for environmental or consider environmental justice in the recommendations that are given to the legislature or the governor.
Excuse me, what bill are we talking about?
We're talking about a Bill of Rights for Maine residents 65 and older. And in the language during the public hearing, I discussed basically the specific needs of my community, being an older one in a coastal community, and saying that basically the provisions that had been set up that I was, I guess, discussing with different people, those recommendations were not specific to age. So it kind of expanded from there. But I think it is definitely a different bill than maybe the title of the concept draft implies. So.
Yeah, that's my concern as well, Representative Warren, is that I think if this bill had been introduced with the language in it, it probably would have been referred to a different committee. Is Peggy, have you shown us are there additional sections that we haven't looked at?
And there's a summary, and Representative Warren did change the title to an act to establish environmental justice provisions in Maine climate action plans. That would be her recommendation for a change.
Okay. Do you want to stop screen sharing perhaps, Peggy, for a moment, just so we can see each other for the discussion part of today? Is there anything else you wanted to share with us, Representative Warren, before we take committee discussion?
I did want to say that in speaking to a whole variety of folks that there was just a broad sense that this was too much to put on the Maine Climate Council, that basically these are, and so there's a part of the Maine Human Rights Act that just basically says that there is no discrimination allowed by public agencies, and that would be the best remedy for people that feel any action by an agency that has to do with the Maine Climate Plan or any other, that it could be enforced that way. But my interest is to protect different vulnerable populations in Maine, like my own, and that was what originally brought me to bring this forward. So yeah, I really appreciate your time and your consideration, and I do acknowledge that it's kind of a strange one, but thank you.
Yeah, thank you. Representative Harnett?
Thank you, Madam Chair. And I'm a little confused. It feels like, and correct me if I'm wrong, Representative Warren, but it feels like we're being asked to change the charge of an already existing the climate committee. I mean, I forgot, I lost the screen there, but the
Climate Council.
The Climate Council that's already been established, where we seem to be modifying that statute, and which I don't see, that's far more an environmental issue than a judiciary issue. Am I missing something?
Well, I guess I see it as a human rights issue, but I do understand the point you're making. I just think climate change affects all different areas. So I would want actually the judiciary to be, or yeah, human rights to be a pretty central part of protecting our environment in a way that we would need to. And I do fear that that could be, or I'm interested to see that be more of a part of the Maine Climate Council's charge in the future, but this may not be the moment for that, and it may not be the vehicle, and I may not be the best advocate for it at this moment. So I appreciate the consideration. I apologize if I misunderstood the question also, so if you have more clarification, please let me know.
No,
I think you've addressed it. Thank you.
Yeah, and there's a couple of committee members with questions. I saw Representative Evangelos first, and then Representative Libby.
Thank you, Madam Chair. By the way, Sophie, you are an excellent person to raise these questions. No one questions your commitment. Madam Chair, Amy Sneerson's on the attendee panel, and it says in the information that Representative Warren sent us that the objectives of this bill may already be covered under the Maine Human Rights Act. So when it's appropriate, could we hear from Ms. Sneerson as to whether that's the case or not?
Has she seen this, Representative Warren? Has she seen this proposal?
I don't think so.
Okay, I just hesitate a little bit to put her on the spot, Representative Evangelos. Representative Libby, go ahead.
Thank you. Thank you, Madam Chair, and thank you for being here today, Representative Warren. I, of course, have only just read the amendment as you all have, but I wonder if some of the pieces that Representative Warren is trying to address are actually addressed perhaps in LD 489, resolution proposing an amendment to the Constitution of Maine to establish a right to a healthy environment. And that is being brought forward by Senator Maxman. And in that case, I wonder if some of those same goals might be met by that, that which is being brought forward this session. I don't want to duplicate. I don't want to duplicate efforts. I think I appreciate Representative Warren bringing this forward, but at this point, having seen the kind of similar goals of both of those, I would put forward a motion ought not to pass.
Is there a second on the motion before we have committee discussion? Seconded by Senator Kine. And I just would like to echo what Representative Libby said. I think the policy that you're presenting to us is really important. I also do think that the Pine Tree Amendment, like the policy you're advancing, is something that has already progressed through the legislative process, and we'll be voting on it. And I think that I think you can be assured that your policies will live on in that and in the other work that you do in the legislature. Other commentary by committee members? Is the committee ready for the vote? Looks like we are. And go ahead, Ms. Panett. Thank you for joining us.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kine.
Yes.
Senator Kine votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Regrettably, yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
I'll second Lois's comment, but I'll vote yes.
Representative Evangelos votes yes. Representative Newell. I'll call the absentees. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Representative Babbage. Representative Babbage is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 are absent.
Thank you very much, Ms. Panett. And so the motion ought not to pass carries. Thank you so much for being with us this afternoon, Representative Warren, and we look forward to seeing more legislation from you in the next session. And with that, the work session on LD 741 is closed, and we'll open the work session on LD 855. This is an act regarding issuance of a birth certificate following a gender marker change. And Peggy, if you could take us through sort of a top level analysis, and then we'll do a deeper dive in the areas where we have questions.
Sure. Thank you. This bill amends the statute to allow a person or an individual, or if the individual is a minor, their parent or guardian, to have their that their birth certificate be amended for a gender marker change, and it would not be listed. The new birth certificate would be issued, and it would not be, there wouldn't be an indication on it that it's been amended. And this actually codifies the rules that DHHS has been following since, I think it's July. Kim Hagan, the Registrar of Vital Statistics, she probably has a much longer name than that, is here and can answer those questions about what they've been doing in the interim since this bill's been proposed.
Thank you very much, Peggy. Committee members, questions regarding the bill analysis and Representative Sheehan?
Thank you, Madam Chair. I actually want to move this relatively straightforward and technical department-driven bill ought to pass.
We have an ought to pass motion. Is there a second? Sorry, Representative Arnett, seconded by Representative Arnett. Okay, so I think committee discussion on the bill. Would anybody like to hear from Ms. Hagan from the department? She did speak to us in the public hearing on the bill.
I would.
Okay, Representative Moriarty, I will bring her over, and if you can just be ready with your question. And Ms. Hagan, thank you very much for joining us. And Representative Moriarty has a question for you.
Oh, no, I just wanted to hear from her. I thought she had commentary to offer. No?
No, I don't think, because we heard extensive information. Did you have something you wanted to add, Ms. Hagan?
No, I don't think so.
Oh,
Okay.
okay. I misunderstood then. I didn't have any questions.
Okay.
So I'll
It
pass.
looks like Representative Libby might. Do you have a question, Representative Libby? No. Does anybody have a question for Ms. Hagan before I return her through cyberspace? Go ahead, Senator Kime.
Thank you, Madam Chair. Yeah, I did, since you're here, thank you, Ms. Hagan. My takeaway from the public hearing was just that there are not established measures on how the department would ensure that these changes are not made fraudulently. Is that right? Because I think you said you may require some corroboration from a health professional or something, but none of that is actually established. The process isn't established. Is that right?
We do have the rules that were developed last July, enacted in July, that creates this administrative process for a minor. And when you asked the question in the public hearing about whether we would or wouldn't, we don't believe that the changes that is going to change in the rule. We will keep that requirement. We'll keep the rule intact, but that it doesn't go far enough in that if someone has a sex change and then wants the birth certificate to reflect that change, it's going to be annotated by the laws that govern the amendments. And as far as, and I'm not sure if that answers your question, but then as far as what other safeguards are in place to prevent fraud, so someone couldn't just change their name to escape the law, we currently have in our rules for amendments, for any amendment, that we will only change a field one time without a court order. So this change could be done once. It's not something people are going to flip-flop and do it to escape the law or change your name or to get out of debt, or we would change a record once.
So just to clarify, if this was a minor, the current guidelines are that a health practitioner has to sign off.
Correct. Yes.
But there there is a definition of what that health practitioner has to be.
There is. It's a doctor or mental health.
Thank you.
Thank you for the questions, Senator Keim, and thank you for the answer, Ms. Hagan. Committee members, are there any questions for our committee analyst? Is the committee ready for the vote on 8:55? We have an ought to pass motion. Representative Libby, did you have a question?
I don't have a question. I just wanted to just speak to the motion for a moment.
Okay, go ahead.
I have to disagree with Representative Sheehan that this is a simple department matter. A birth certificate is a record of a live birth, and it's supposed to be an accurate record. And as far as minors, I quote someone on our committee who voted against allowing those under 18 to marry because that would be a permanent lifelong change that a parent should not make for a minor. So speaking specifically to the point that this could be done on a minor's behalf, I have to object most strenuously to that portion. As Senator Sanborn had noted at the previous bill, I think that minors should be left to make these decisions once they are of age, which is technically 18. So I will be voting against the motion. Thank you.
Thank you, Representative Libby. Go ahead, Representative Thorne.
Thank you, Madam Chair. My question is a clarification question for Representative Libby. Are you saying that if someone voted in favor of the parental consent under age 18 and voted for this, that it would be a hypocritical vote? Is that what you're saying?
I am simply saying that statement made in one context on one bill makes sense that that would be follow through on this bill. But I can only vote for myself, Representative Thorne.
Okay, I just wanted to clarify that. Thank you.
Senator
Thank you, Madam
Sanborn.
Chair.
Thank you, Senator Carney. I have a sense that we may disagree about the nature of gender and sex and marriage, and which of those are innate qualities and which of them are civil status conferred by the government. Thank you.
Is the committee ready for the vote? Representative Moriarty? You're muted, Steve.
Thank you. Thank you, Madam Chair. I may be having a brain cramp. I'm not seeing a reference to a minor. Can
In the
someone
bill?
in the bill?
I believe that the if you look at section 5 of the bill,
Yep.
There is a existing, it's not a change to the law, but the existing law that is being amended talks about a person the parents of a child under the age of 18. Maybe Peggy, you can help me out with this. The information that Ms. Hagan gave us, it was related to the departmental rules. And so I don't know if that's specifically what you were referring to.
Okay, that let's assume that's the case then. Does the bill actually permit a minor to apply for an amended birth certificate?
Can I answer the question, Madam Chair? I have the line numbers.
Yes, go ahead. Thank you.
Okay.
Thank you. It is in section 5. And on line 21 and 22, you see what's been added in, gender marker change. And then on line 28, you see adoptive parents of the adopted child under 18 years of age. And you also see on line 34 and 35, adoptive parent of adopted child. And then on line, it's in section B under paragraph B, I guess, under section 5. You see 2A and then there's A and then there's B. So in paragraph B, which is lines 36 through 41, is the other place where I believe that that applies.
So does this apply only to adoptive minors? Adopted minors?
Let's ask Peggy to help us with this because we are only seeing a section of the statute here, which is the section that needed to be changed, and the reference to parents of minors may actually be in something that didn't have to change. I'm actually not 100% sure.
I'm looking for that now, and actually I think the unamended language of A and B are serving different purposes. A is about a new birth certificate after adoption, and B is a new certificate established after legitimation. And then C includes the gender marker change language. And I'm wondering if Ms. Hagan is the one to ask, because it's the rules that specifically identify the process for a minor. And I'm not seeing it in other places of the statute.
Let me bring her back. Ms. Hagan, I am moving you back on to the panel. We appreciate your help. Ms. Hagan, we promise not to send you back and forth through cyberspace too many times today. Can you help us out with the statutory reference to a parent requesting a gender marker change?
It is in the LD, and it covers statute 2765 2B, and 2B says that a new birth certificate may be requested by the parent on behalf of the minor.
I don't see that. Oh,
Line 14, page 2.
okay, I see.
Representative Rackett?
It sounds to me like the law that we're trying to change is just to add this as one factor, that the parent, in the case of a minor, the parents could request the change. I didn't hear anybody say the kid could do the change themselves, unless I'm crazy here. That's not what I'm hearing. And I think that what I don't want to do is have us debate the entire bill when really what we're trying to do is deal with the gender marker change. And I think that, and I'm not looking at the bill, so I'm dependent upon those that are right this minute because I have the analysis, but not the bill. So anyway, am I right in that?
Yes. Yep. Senator Keim, go ahead.
sorry, I didn't hear the answer to Representative Reckitt's question. So Peggy, a child can't ask for a change to their birth certificate. It must come from the parents. Is that correct?
I mean, it looks like the last line in line 14 on page 2 of 2765 subsection 2B, a birth certificate may be requested by a parent on behalf of a minor.
Okay, and the other comment that I wanted to make is this, as we heard in the public testimony, this isn't actually, a simple fix. This is a distinct legislative decision. The department did make this change. They did make it over strenuous objections from Maine people that want birth certificates to actually identify how people are born. And there are a great number of people that believe that science matters and should be reflected in birth certificates. So this isn't, I just want to clarify, this is not a simple change. This is a major decision on the part of the legislature, and it's being made so that a different department run by a different chief executive can't come in and then by rule change alter how birth certificates are. Now we can, disagree on what that should be, and we likely do, but this definitely is not an easy or a simple fix of language. This is a significant decision. Thank you.
Thank you very much. Representative Libby, go ahead.
Thank you. I just wanted to point out as far as this goes for a minor, as Ms. Hagan had brought up today or answered today, this is a one-time change. This is not something that will be changing back and forth. So the fact that it can be requested by a parent on behalf of a minor, that is a substantial concern. We had many concerns in the marriage bill about parental intentions, or what if one parent agrees, one parent doesn't. Just seems to me that this is something better left for when a minor is no longer a minor.
Thank you. It seems to me like the committee members have solidified in how they feel about this bill, and that we should move on to voting on it. Representative Thorne, did you have a clarifying question that you'd like to ask?
Yes, thank you, Madam Chair. And she mentioned a one-time deal. So that's, I guess what I'm thinking about now is if a minor makes the request to change from a female to a male, let's say, that's the one-time deal. If down the road they regret it, does that mean they cannot make the change back? That they're forever a male?
It means that we won't do it administratively. They can get a court order, and we will change it based on the court order.
Okay. That helps. Thank you. Thank you, Madam.
Yeah, thank you. Representative Moriarty?
Thank you, Madam Chair. Ms. Hagan, I'm not familiar with the rule, but is there a minimum age of the minor before which even a parent can't request a gender marker change?
We do not have a minimum in the rule. Right now, the rule, the parent can request it on behalf of the minor, and there needs to be a statement from a healthcare provider, a physician, or a mental health worker, that counselor, that states that they have that the minor is their patient and their gender aligns with their the change is made to align with their gender. So that there is no minimum age.
Okay, and then just refresh me, what level healthcare provider can support the request? You did mention a medical doctor.
Is a doctor or a
Sure.
psychologist, mental health, a psychologist, or
Well,
someone in?
You
for
seem to be
mental-
unsure. I need to know if it's a social worker or a,
No, it's a psychologist or a physician.
And we do, I believe we do have the rules in, hang on a second. The rule is included in the bill analysis on the last 4 pages, if you'd like to refer to it,
Yeah,
Representative Moriarty.
right. That's just something I never had a chance to read before this afternoon.
Yeah, I know we've got a lot of information coming to us all at once. Committee members, are we ready for the vote on this legislation? Okay, Peggy, Soupy, excuse me, I think we are ready for you to call the vote. So the pending motion is an ought to pass on LD 855.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
The vote is no on the grounds that it could be applied to someone very young in age.
Representative Moriarty votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Thorne.
Nay, nay, nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll call the absentees. Representative Babbage. Representative Babbage is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 6 members voting in the affirmative, 6 members voting in the negative, and 2 members are absent.
Thank you very much. So the vote is 6-6 with 2 absences. And those committee members will have the opportunity to vote in the next 48 hours. So with that, we'll close the work session on LD 588.
Wait, can I just ask the people who voted no on the ought to pass? Do you have a different report other than ought not to pass?
Mine is ought not to pass. Thank you.
Okay.
And mine would be ought not to pass unless the minimum age of the minor is 16.
So were you offering an amendment? So yours would be ought to pass as amended?
Yes, Peggy, I guess that's probably the better way to record it.
Okay.
So I'll just restate that then before closing the hearing. So there are 6 ought to pass. 1 ought to pass as amended, establishing a minimum age of 16 for a change requested by a parent. And then 5 ought not to pass and 2 absences. Did I get that right, everybody? Great. Now we'll close the work session on LD 855, and I don't think we should be taking up anything in addition right now, other than we did have a request from one of our colleagues on the committee to move to reconsider LD 853. That was a bill that raised the rate of that sheriffs can charge for service of civil process. And we do have a couple of minutes, and I think that this is something that are committee members comfortable taking this up? Would committee members like to hear from the Representative Hagan had asked for a reconsideration? Are we able to take this up in the next few minutes? Representative Moriarty?
Madam Chair, I think we can take it up. I would like to know what the rationale behind the request to reopen is.
Representative Hagan, did you want to speak to that, please?
Yeah, thank you, Madam Chair. I was thinking of an amendment to this bill after conferring with my esteemed Republican colleagues. I decided that I would not, that I would like to go ahead and just withdraw the amended thing and keep with the ought to pass, making it sort of blah, blah. And I called the speaker's office and they said that you just can't drop the -A, as amended, ought to pass as amended. You have to have a reconsideration vote. I said, okay, ask your chairs. So I did. And I would like to reconsider in order to eliminate my amended version and just go with ought to pass. And
Thank you for that explanation, Representative Hagan. Soupy, did you want to speak with us?
Yes, I apologize, but Representative Hagan can't make the motion because he wasn't on the prevailing side. It has to be somebody on the prevailing side that makes the motion. I'm sorry, I don't need to throw.
Thank you. Representative Hardet?
Thank you, Madam Chair. I would like to make a motion to reopen the vote on LD 853 to extend a courtesy to a member of the committee to change their vote.
Thank you very much. Is that a second, Representative Moriarty?
Yes, it is.
All right, so let's use electronic hands just to, this is a vote on the motion to reconsider out of an accommodation to our colleague. Please raise your electronic hand if you're in favor of reconsideration. Or your real hand.
Looks like 12.
Only seeing 11, but that's okay.
Representative Libby has to use her real hand.
Oh, I'm sorry. I was counting the side. Thank you so much.
Thank you. All right, so the motion to reconsider carries, and let's all take our electronic hands down. And now we will, I'm looking for a motion on LD 853. Did you wish to make that motion, Representative Hagan?
Sure, I would make a motion ought to pass on that bill.
And is there a second? Seconded by Representative Harnett. And I think we are ready for the vote. Ms. Panett, whenever you are.
Okay. Sorry.
Thank you. So this is the ought to pass motion on the reconsideration of LD 853.
Would it be helpful for you to know who was on each side? Because I'm a tad bit confused because it was I have a 1, 2, 3, 4, 5, 6, 7, 8 to 3. So there were 3 people that were also with Representative Hagan.
Okay, committee members, do you need to know?
I'd like to know. I'm just curious.
Okay, the minority report was ought to pass as amended. Representative Hagan, Representative Poirier, and Representative Thorne.
Okay.
Thank you.
You're very welcome. And I'll call the roll for the ought to pass.
Yes, please.
Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Thorne.
Yay.
Representative Thorne votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll call the absentees. Representative Babbage. Representative Babbage is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Ms. Panett. And with that, the ought to pass motion on reconsideration of 853 passes. And that was a crazy way to end a very long day. We went through the procedural hoops and came out with a nice vote in favor of sheriff's fees for civil service of process. And with that, I think our work for the day is done. Well, our committee work for the day is done. We are all, I think, going to turn ourselves to additional work. So we'll close the reconsideration on LD 853. And then is there any business that we need to take up before we adjourn for the day? Not seeing any. Is there a motion to adjourn? Representative Thorne. And thank you all. See you tomorrow in the Civic Center. Good work today, everybody.
Very good. Good night now.
Good night. Thank you, Peggy. Thank you, Soupy.
Bye.
Bye.
Night.